Good morning. This is the Colorado Energy and Carbon Management Commission. This is a Tuesday morning. It is September 3rd. It is 9 a.m. and we have a special agenda for the next couple of weeks involving the cumulative impacts rulemaking. We will start by recognizing our existence with the roll call.
Thank you. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins,
Here.
Commissioner Shea.
Here.
Thank you, Mr. Chair. You have 6 of 7 commissioners present. We are welcoming Commissioner Shea on behalf of CDPHE.
Great. Thank you very much, Hearings Manager Thomas. Want to welcome you, Commissioner Shea, to being with us. We appreciate your being the CDPHE ex officio representative for this rulemaking. Your ideas are welcome, so thank you very much. Before we get to the cumulative impacts and enhanced systems and practices rulemaking, we do need to take up docket 24010004. This is a request for a Rule 11 public hearing, Rule 511 public hearing on the extraction oil and gas Draco OGDP. Commissioners, we had received this request for public hearing from the Flatiron Meadows Oil and Gas Monitoring Group. Previously, we asked the Flatiron Meadows Oil and Gas Monitoring Group to provide some additional perspective and also response to a rebuttal to the response filed by Extraction on the request. We are taking this matter up to determine in the first stead what we desire to do with the 511 hearing request. And then in the next stead, if we're going to have a 511 hearing, how we're going to do it. My preliminary sort of thoughts, because this is just in a deliberative stage, are as follows. Rule 511 was created, I believe, prior to COVID and prior to our making most of our work product done virtually. It was a method to ensure that we had transparency and that we could hear from people in the field with regard to transactions and or applications that might impact them. We now conduct most of our business virtually. I believe that this is an appropriate method for us to conduct our business. I believe we've had a much more transparent ability for folks to be involved with us. We previously held a 511 hearing, kind of the first one, at Lowry Ranch, and that was at the Arapahoe County Fairgrounds. That was well attended. I also would note that over the course of the next month, we have a tremendous amount of work before us. With all that said and done, I would be inclined to grant a 511 hearing request, but I also would be inclined to suggest that we utilize Rule 511, which allows the commission to, in its discretion, determine whether to grant a request for a local public hearing. The commission has discretion to decline a request for a public hearing, or in the alternative, hold the local public hearing either at the commission's offices or otherwise. The commission also has the discretion to designate a single commissioner, an administrative law judge, or a hearing officer to preside at the local public hearing. My thoughts are, and I'm not wed to this, that we grant the request for a local public hearing, that we require it to be done virtually, and that we require it to be done before a hearing officer. We would allow it to be recorded, and we would ensure that all commissioners have the ability to, and will, listen to the 511 public hearing prior to considering the Draco matter on its request. This would increase efficiencies. This would allow members of the public to be heard. This would give an extra opportunity for members to be heard when we have a public 511 hearing, we don't ask questions anyway, so it would not divorce any commissioner from fully participating in the public hearing. And it would also address the fact that we're really busy over the course of the next 3 weeks with the cumulative index hearing. So those are my initial deliberative thoughts. I am happy to hear from other commissioners with regard to thoughts on the request for a public 511 hearing. Commissioner Messner.
Thank you, Mr. Chair. So I acknowledge that the Rule 511 was developed prior to COVID. I do think that the intent of the 511 hearing is certainly to give folks who are identified as potentially impacted by the application to be able to have additional time and transparency in our process to be able to share their thoughts. And so I certainly am in support of granting the 511 public hearing. I think also having the support for having that public hearing from the town of Erie is very compelling, in addition to the applicant that has asked for the public hearing. I, for one, would like to have that public hearing attended by commissioners. I think that is important to hear firsthand from the different folks that are taking the time out of their day to share their thoughts. And I think it's important that we are present at those hearings to be able to hear those thoughts. My gut tells me that it's probably best to have in-person public hearings, because I think that those are an opportunity to better engage with community members and be able to fully understand, I think, the information that they're trying to present to us. I am not wed to having to have an in-person and can be swayed into having a virtual, but I would prefer to not see that go in front of a hearing officer. But those are my initial thoughts.
Hearings Manager Thomas, if you could elevate yourself. What are the and I'm still want to hear from the other commissioners, but just help us with just pragmatic capacities. What are the capacities for us to hold a in-person meeting that is recorded that we could then listen to later?
I believe we have done that in the past. I believe we've done that in the context of produced water and in the previous 511 hearing. So we can do it. It will depend on the venue, and we would just need to organize that beforehand. Capacity schedule-wise is a different question. Obviously, we're looking at October at the earliest, but that we could make this happen depending on the venue. And
is Draco scheduled for a hearing before us at this point?
It's been continued, as there's currently another petition and in anticipation of the rulemaking. I do not believe it has been rescheduled, but I don't want to guarantee that it hasn't been put back on the calendar.
All right, why don't you check in with your team and try to figure that out before we make a decision here. Commissioners Oath, Cross, and Ackerman, anybody else want to weigh in? Commissioner Oath?
Sure, thank you. I would like to be there if possible. So kind of lean towards what Commissioner Messner was saying about having commissioners present. But I think, if we can't find a date that works for all, it sounds like we might have the ability to have commissioners who are able to be there, attend, and others, if they're not able to be able to listen to that afterwards. And then in terms of in-person versus virtual, I'm mixed there as well. I see a lot of value in person, and sometimes that is more meaningful, or that's not the right word, more an opportunity for people to participate who may not have access virtually. But then there's also the flip side. Sometimes it's easier for people to participate virtually than in person. So I am kind of on the fence on that part.
Okay, now just would remind everybody for the record that commissioners don't ask questions at the public hearing. It's just a matter of listening. So, Commissioner Cross?
Thank you, Mr. Chair. I've got a couple thoughts on this. Similar to Commissioner Oath, if we do in fact have public hearing, I plan on attending, be it in person or virtual, because I also think it's important to make sure I listen at least firsthand and be able to take notes in that manner, as opposed to trying to watch it again as recorded. I do think I'll say my biggest concern overall is I want to make sure that moving forward, I want to make sure that we clean up the process for 511 hearings. To me, I think I am absolutely a proponent of public comment. I'm happy to go anywhere around the state and listen to the public comment. But that said, I do know that for many of the people that ended up on the subsequent attempt signing on to the petition for the 511 hearing, many of them also submitted public comment in this matter as well. But then again, as was noted, decided to request a 511 hearing mere days before the hearing was set to take place. I do have some concerns with this process being used as a potential delay tactic. I want to make sure that it is not used in the future as, oh, well, let's make sure we do this so we can, one, either make the process take longer, or two, potentially have a hearing that might have one or two people. I think we need to make sure that in the future we set up some kind of process. I don't know if we need to amend the rules or just be stricter on how we interpret it, but trying to make sure that 511 hearings can and do happen, but when appropriate and with plenty of notice ahead of time. That said, I would absolutely be in favor of having a public hearing in this instance, and I would absolutely be in favor of having it in person, and I would too.
Great. Commissioner Ackerman?
Thank you, Mr. Chair. Not a lot to add. I appreciate you leading out with your deliberative thoughts on this. And I, as one commissioner, and I suspect my fellow commissioners, whether it's in person, whether it's virtual, whether it's a hearing officer at first and recorded, I'll listen intently in any format and take copious notes as well. And I suspect that we all will. And so I think we're just talking about, like Commissioner Cross said, what's appropriate process. And that's something that's been on my mind as well. I do think that going forward with this one is a good idea. I think that it's good at this point for commissioners to attend as well. And I am somewhat indifferent on in-person or virtual.
All right. So I think what we've heard is a consensus from all 5 commissioners that we will grant the request for a public 511 hearing. I would suggest to the fellow commissioners and to Hearings Manager Thomas, perhaps you figure out the details and issue an order as a hearings manager that contemplates commissioners' calendars, that preferably establishes that it is a in-person meeting in Erie or in and around Erie, that if it's not able to be in person, and that if it is in person, make sure that it is recorded so that not only us, but all of our stakeholders can also listen in at a time. Commissioners will take every effort to be at the meeting in person. And then if for circumstances that we're not aware of, we're not able to do it in person, let's schedule it for a virtual meeting that will be, again, YouTube videoed, and we'll all attend virtually. And then we'll make that record available for everyone, including the applicant and others in the Draco matter, probably suggesting this is something that will occur in October, given commissioners' calendars between now and then. Does any commissioner have any concerns about those musings, which are not really in motion, but just kind of direction to staff? Hearings Manager Thomas, did you get all that?
I did. And we will issue an order forthwith.
Excellent. Anything further on the Draco, public 511 hearing request? All right, we will move to docket 24060015. We are starting out with public comment. And before we move into the substance of public comment, I would like to recognize, I'm not sure if it's Hearings Manager Thomas or Anya Lofgren, but we've got some Spanish speaking interpretation issues that I want to make sure everybody's aware of.
Thank you, Mr. Chair. ECMC is very excited to have Spanish interpretation for the public comment session this morning, as well as tomorrow evening. The process is relatively straightforward. Individuals that do require Spanish interpretation are able to join a Spanish room where an interpreter will translate public comments and commissioner comments to them as they're being heard. That button will be available down at the bottom of the screen. You'll see a button that says interpretation, and you can click that and enter into the Spanish room. If you do not require Spanish interpretation, you do not need to do anything. You can remain in the room, and if there are any Spanish public commenters, their public comments will be translated in live time in the main room. And we have our interpreter here, Christian, to translate those instructions into Spanish as well. So thank you. Go ahead.
All right,
Perfect.
Christian, go ahead.
Thank you, sir. Muy buenos días a todos. Esperamos que se encuentren muy bien. Gracias por acompañarnos el día de hoy en esta reunión de ECMC. Y bueno, ellos están muy contentos porque en esta oportunidad, en esta reunión para dar comentarios públicos, va a haber interpretación disponible. Así que les pedimos que si usted necesita interpretación al español y quiere dar su comentario, usted va a poder escuchar toda esta sesión completamente en español. También va a poder dar su comentario en español y yo le voy a traducir a los comisionados al inglés. Así que en este momento, si usted necesita interpretación al español, le voy a pedir que levante su mano para yo saber que va a haber una persona que necesita, que va a necesitar la interpretación y así yo poder empezar esta audiencia también en el otro cuarto en español. Así que una vez más, si usted necesita interpretación al español, levante la mano aquí en Zoom. Ahorita vamos a abrir ya la interpretación. Usted va a escoger su lenguaje español y me va a poder escuchar a mí. Una vez que usted quiera brindar su comentario, vamos a reunirnos otra vez en el cuarto principal. Usted habla en español y yo voy a hablar en inglés. Muchas gracias y aquí estamos para servirles.
Great, thank you very much. So okay, I see at the bottom of my screen is an interpretation window. It looks like the world sort of thing. So that's what folks would click. And then if they want to hear our public comment proceedings, they could hear that in Spanish. Is that right? Hearings Manager Thomas?
That is correct.
Okay, excellent. I just want to thank staff for the worthy work here. This is not something we've done before. It is absolutely something that we should do on important tasks before us. And so really thank the Department of Natural Resources and the Energy and Carbon Management team staff for making this happen. And so if anybody has questions, they can reach out to Hearings Manager Thomas or Christian, our interpreter. All right. With that, we start our cumulative impacts public hearing with the public comment stage. And with that, we've got 24 people that signed up for public comment this morning. We have a few elected officials that signed up, so they'll go first. They are given 5 minutes each, and then members of the public are given 3 minutes each for public comment. I will remind everybody that the extensive nature of this rulemaking establishes that we have a lot of things to accomplish and we have a short amount of time to get there. With that, we'll hold the timeframes pretty tight. So would ask everybody to be cognizant of their timeframes. We will start with Senator Faith Winter.
Hi, ECMC. Thank you so much for having us today and taking public comment both this morning and tomorrow on this really important rulemaking, which stems out of several pieces of legislation that myself and several other lawmakers worked on. And I'm here today to talk a little bit about the legislative intent and about the changes from the proposed rules in June to the drastic changes that came to the proposed rules in August and some concerns that we have. This rulemaking originally came out of HB 23-1294, which was to create goals around cumulative impacts, and that was extended through 24-1346 this year. In addition, we passed 24-229 and 24-1338 as pieces of legislation to address these policies. And we have some concerns around how this is being implemented. The first is really the change in disproportionately impacted communities and failure to really focus on disproportionately impacted communities. The term cumulatively impacted community is misleading, and it weakens protections for communities that have been burdened by pollution for a very long time. This was the center of our legislation that we were passing along with community, was really to protect disproportionately impacted communities, and to completely change that through the rulemaking, I hope doesn't become finalized. And that includes the cumulative impacts. It also includes how close drilling can be in informed consent, which was in the previous rule and then taken out. And the legislature hasn't historically mandated specific setbacks because we're working with all you as partners. But we do really from the directive in Senate Bill 24-229, it's clear minimize adverse impacts to these communities needs to be a priority. Also, we're worried that there is a failure in these rules to establish meaningful pollution thresholds. The revised draft rules significantly weaken pollution controls for the oil and gas industry from those originally proposed in the June draft, jeopardizing our public health and undermining the intent of the state law. For example, the ECMC has removed critical safeguards that help the entire oil and gas industry hold the entire oil and gas industry accountable for reducing pollution. The agency's initial draft included provisions to ensure the industry as a whole met APCD targets, and that's incredibly important for our public health. And one of the reasons we brought these pieces of legislation was to address those public health concerns from our communities. And then this also has a failure to assess cumulative impacts. And I know I've talked to many of you many times about the challenges of assessing cumulative impacts, which I appreciate, but we need to take a larger step forward than what's currently proposed. This is ignoring the big picture, limiting the assessment of cumulative impacts to a 1 mile radius is short-sighted, as pollution and environmental damage often extend far beyond this area. So I appreciate the work that you've done. I would appreciate further conversations, understanding that out of those 4 pieces of legislation, I think these rules fall significantly short on meeting legislative intent on protecting our communities, especially those disproportionately impacted communities. And I look forward to continuing the conversation. Thank you.
Thank you, Senator Winter, for leading off. And I believe that that is the intent of the commission, is to weigh all the competing pieces of 4 legislation and come to the right solution. So we appreciate your providing that perspective to us. Senator Cutter, you are now recognized.
Thank you so much. Thank you all for convening this and for having me here today. My name is Lisa Cutter, and I'm a state senator. And for several months last summer, we heard testimony during our ozone interim committee. We heard testimony from the communities most at risk from the negative health impacts of oil and gas production and the poor air quality. We heard from so many experts and community members and reviewed data on health and other negative impacts. And as my colleague, Senator Winter, shared, over the past several years, we've passed many pieces of legislation to protect health around the oil and gas industry and these cumulative impacts. While the bills we offered last session changed because of negotiations with industry and the potential ballot measures, the process and resulting legislation was incredibly clear in its intent. As everyone here well knows, Colorado is in non-attainment, and we're at serious risk of being classified as an extreme non-attainment area. This would mean we have the worst air pollution in the nation. That's something that I can't even imagine we're having a conversation about this right now. The original draft rules were really encouraging, actually, but I'm deeply disappointed in the weakened pollution controls proposed in the current rules. The failure of the ECMC to enforce strict emission limits and restrictions on drilling during ozone season will only worsen air quality and put the people of Colorado, particularly in many marginalized communities, at risk. This agency has a responsibility to protect public health, and I cannot imagine what compelled these rules to be weakened by every single metric since the last rules were published. This draft has significantly undermined the legislative intent and our desire to protect air, water, wildlife, and public health. It's reduced pre-consultations, reduced the zone of residence receiving information. It's just multiple things. It's reduced the comment time for disproportionately impacted communities. So while I sincerely appreciate the work, I know you have to deal with many competing interests and hear testimony from everyone. I greatly hope that you will hear all of the testimony lined up today from community and go back and consider revising these rules back to a version more similar to the June draft, where the communities were more protected and the legislative intent was better mirrored. So thank you again for your time this morning, and I will look forward to seeing what the commission comes up with. Thank you.
Thank you, Senator Cutter. We appreciate your taking time out of your day to provide your perspective to us. We now will hear from Stephen Douglas.
Mr. Chair, we've been unable to locate Mr. Douglas for the time being. So I will keep an eye out and let you know if he does appear.
All right, then we will now hear from Renee Chacon.
Hello, it's Renee Chacon. I am here and allowed to speak on behalf of Commerce City Council as well. We've got the approval because of the severity of just how abysmal this draft is. Tlasokamati ometeo, tlasokamati atatonati, tlasokamati tonantinklali, tlasokamati abuelitos, the abuelitas, and all the ones that came before and all the little ones to come. We live on the land of the Ute, the Cheyenne, the Arapaho, the Shoshone, the Kiowa, the Comanche, the Inde, the Dine, the Chicano, 48 tribes that still live and travel through this space. And in fact, I live in Commerce City, where we have a very large Latino population, and we are that disproportionately impacted community. So I do not take it lightly when you erase my community specifically under this definition of cumulative impacts. Good morning, I'm Renee Chacon, and a member of Commerce City Council, and thank you for my comments on cumulative impacts. This is finally our chance to reduce harmful emissions from this sector through measurable, verifiable methods that must be included in these rules. It's just as important that these new rules take the legislature's direction seriously to protect these most vulnerable to these dangerous emissions. In the first draft of the rules published earlier this summer, this commission wisely proposed strengthening Rule 604 to require that in disproportionately impacted communities, an operator must get residents' informed consent to locate any wells or storage tanks within 2,000 feet of their homes. It is unacceptable now that this provision has been removed from the updated draft, and as that has been released in August. This means legitimately putting 5 oil tanks across the street from an elementary school that's already suffering. in Senate Bill 24-229 explicitly directed the ECMC to minimize adverse impacts to DICs from oil and gas activities, eliminating the requirement for informed consent to place critical equipment closer to DIC members, homes, and workplace. This is a step backwards and counter to the intent of the new law. Informed consent is a common sense provision in protecting those that are most vulnerable. I implore you to replace that provision into the final draft in order to prevent further impacts to these communities, my communities. I also ask that the ECMC remove the term cumulative impacted community, or CIC. It erased my community. I'm not asking you to equitably pollute. I'm asking you to eliminate pollution from my community, and this draft rule does not do that. This term actually weakens protections for impacted communities and oil and gas development, and CIC isn't the problem. In fact, no oil and gas permit has been issued in a CIC in at least the last 5 years. This development has been happening. The CIC language included in the new draft is incompatible with the statutory definition of DIC and the latest study directives of HB 23 and 1294, including 1266, the EJ Act, which I'm co-commissioner of the equity analysis of cumulative impacts. Most of all, according to a report by the Carbon Tracker, over half of Colorado's nearly 50,000 oil and gas wells do not generate enough cash to ensure that they'll be cleaned up by the end of their life. They're leaky and unprofitable, and which are a huge risk to my community, which makes them not enough to be a risk to my generation, my next 7 generations. Many of these wells are located in disproportionately impacted communities. And only 24% of Colorado's counties with a high Latino population even have an air quality monitoring station, while 35% of those counties with a low Latino population do have one. Drilling this close to homes poses a threat to public health and residents, and we must be able to provide informed consent before drilling takes place within the 2,000 feet of our homes. There are rules you shouldn't be able to decide for people without the awareness to their quality of life and protected health and safety being prioritized the most. And I'm no longer speaking about just cumulative impacts, but really your decisions of their cumulative intentions. When you make allowances for profit over people, you're intending on allowing harms. And in our view, this is something that no one, especially elementary school children at DuPont, should be excluded from the decision-making and their parents. I'm asking you as a human being to have exhaustive measures that actually provide a health analysis before the drilling, and no matter the delay, is able to accommodate any language barriers for my communities. We're suffering now. You might be talking about rules that happen in the next few years, but our community has already been out of unattainment for the last 7 sips. We're tired of the bath water overflowing and harming not just our current generations, but our future generations in a way that should not be allowable for profit. I thank you for listening today, and klasuka matiometo.
Thank you, Councilmember Chacon, for participating with us this morning. Next, we have a council member from Fort Collins, and I'm not even going to try to pronounce your last name because I'll butcher it. So, Tricia, you're up.
Hi, I'm Tricia Canonico. I serve on Fort Collins City Council. My apologies. The city is trimming trees outside my window, so if you hear external noise, that's what's going on. Today, although I serve on Fort Collins City Council, I'm here as an individual representing myself, my family, and the constituents I represent. I appreciate the work ECMC has done so far in addressing emissions from the oil and gas sector. The rules that address flaring are a great example, as are the financial assurances that you've enacted to discourage spent well abandonment. My community of Fort Collins has been positively impacted by a recent decision you made regarding Prospect Energy, and the commission and the agency must be commended for its work. The work is far from done, of course, and this current cumulative impacts rulemaking can be a significant step towards assuring ultimate success for this commission and for the future of emissions reductions. I appreciate that ECMC is moving forward with a process that began with the mission change rulemaking. Then as now, the legislature acknowledged that in addition to that important work, much more work is needed to build evaluative data and then to get to the work of addressing impacts. That time has now come. The legislature provided a clear definition of cumulative impacts And this definition and the legislation passed this year directs the commission to address impacts to those who live near and far from oil and gas operations. Unfortunately, the draft rules as currently written do not adequately protect the most vulnerable among us from the dangers of these pollutants. Terms such as cumulatively impact communities not only segregate communities into who has it worse and who has it the worst, the draft also does not follow the clear directions of the legislature that all disproportionately impacted communities should be protected. The current draft also doesn't adequately evaluate the impacts of this industry on a cumulative basis. The rules must address the aggregate impacts of all wells and industries. Make sure to aggregate impacts from all producers would be a big improvement to these rules. I appreciate the decision you made this past month to protect my community, and I appreciate your time and your efforts to address the impacts of the oil and gas industry on a cumulative basis. Thank you for your time today.
Thank you very much. We now will hear from Catherine Goff from the city of North Glen.
Good morning, EMC members. I'm Catherine Goff. I'm a mother, a grandmother, a wife, and a North Glen City Council member. In each of these roles, I take my responsibility seriously to do all that I can to protect the health, safety, and welfare of my family and my community. My husband has asthma and has to stay indoors many days, especially during the summer. And I do want to be clear today that I'm here to speak on my own behalf and on behalf of my constituents. I'm a senior. I would say seniors and children suffer the most when our air quality is poor. And like many of my constituents, I want to do everything I can to create a livable planet for all of us and for our future generations. It's clear we need to reduce emissions from the oil and gas sector to protect the health of those who live in the Front Range non-attainment area, near and far from gas wells. We know oil and gas is amongst the heaviest contributors of the nitrous oxides that cause ozone and many other dangerous pollutants. We must also address planet-warming emissions from this industry. Earth is now in its 15th consecutive month of record-breaking global temperatures. This summer marked the hottest single day on record on Earth, a record that was broken the next day. These facts should stop us in our tracks and cause us to put all our efforts into stopping this trajectory. I know you understand the urgency, and I appreciate your hard work so far in increasing the standards that hold industry accountable. I hope the final rules include a clear definition of cumulative impacts that includes all impacts, even impacts to those who don't live or work near well pads, as well as impacts to air, water, and wildlife. The rules must also include a full scope of requirements that evaluate all of the impacts within and outside of the oil and gas industry. We all know these emissions do not stop at a 1-mile boundary. As someone whose community is split in half by I-25, my constituents and I are deeply impacted by the cumulative effects of oil and gas, transportation, and many other forms of pollution. Here in the city of North Glen, we have 2 air quality monitors, and myself and many others I know check that before they plan any long outdoor activities such as gardening. The rules could also be made stronger by a stronger analysis, particularly when analyzing how permitted operations contribute to environmental and public health harm. The rules should require that negative impacts first be avoided before considerations are even made for how harm can be minimized or mitigated. I thank you all for the time you've invested to date in the development of these rules and the time you will spend ahead in these coming weeks. Thank you for taking the strongest approach possible for ensuring our community's health and welfare. Thank you.
Thank you, Councilmember Goff. And just noting for the record that you spoke on behalf of yourself as well as your constituents. So we will note that as comments on behalf of the city of North Glen, your constituents, because that's what you said. So thank you very much for that.
Yes.
We will now hear from Kathy Henson. And Ms. Henson is from the city of Thornton.
Yes, good morning. Thank you for the opportunity to speak. I'm Kathy Henson. I am a Thornton City Councilor, and today I'm speaking on behalf of my constituents and my community. I would like to highlight the need for strong safeguards, including setbacks for well pads in disproportionately impacted communities. I would like the Commission to resurrect the 2,000-foot setback requirement stripped from the most recent draft. This is a health and safety issue because scientific studies have consistently linked proximity to oil and gas operations with increased health risks, including respiratory problems and cancer and birth defects. A 2,000-foot setback provides a crucial buffer zone to protect public health. This also has an impact on our property values because residences located near oil and gas operations often experience significant declines in property values. This has a devastating economic consequence for homeowners and communities. I would like us to protect our children. A 2,000-foot setback helps shield schools and playgrounds and essential community spaces from harmful effects of oil and gas operations. I believe that residents deserve to have a voice in decisions that impact their lives, and a 2,000-foot setback demonstrates respect for community rights and values. Disproportionately impacted communities are facing a health crisis. Residents in these communities experience higher rates of respiratory illness, cancer, and other health problems directly linked to oil and gas pollution. This is an environmental injustice. Disproportionately impacted communities are often low-income communities and communities of color that have been historically marginalized. We must address this systemic inequality and ensure equitable distribution of environmental burdens. Stronger protections are needed. The current regulations are insufficient to shield disproportionately impacted communities from the harmful effects of oil and gas activities. We need stricter setback distances, air quality standards, and water protection measures. The oil and gas industry is a major contributor to air pollution in Colorado, and we must hold polluters accountable if they fail to reduce harmful nitrous oxide emissions. Strict enforcement of emission reduction targets is essential to protect public health and our environment. Nitrous oxide emissions contribute significantly to the formation of ground-level ozone, which causes respiratory problems, asthma, and other health issues. The oil and gas industry needs to be held accountable and responsible for its contribution to our air pollution, and we cannot allow them to prioritize profits over people. Enforcement is the key. The ECMC must have the authority to impose strict penalties on operators that fail to meet nitrous oxide reduction targets. This includes permit conditions and denial of permits. Reducing nitrous oxide emissions is also essential for addressing climate change. These pollutants contribute to global warming and exacerbate extreme weather events. We need stronger regulations to protect our health and the health of future generations. This is a matter of a basic human right. By August 2nd, the date the ECMC released these draft rules, Colorado's Front Range had already had more ozone action alert days in 2024 than all of 2023. Colorado regularly ranks as having some of the worst air quality in the nation, largely due to the oil and gas pollution. I know we can do better, and I urge you to take these items, these important issues into consideration in your drafting your rules, and I thank you for the opportunity to speak to you today. Thank you.
Thank you, Councilmember Henson. We appreciate your being with us. That concludes the elected officials portion of public comment. Before we move to the rest of public comment with about 20 people signed up, I'd like to elevate Kyle Davenport, our Assistant Attorney General, to speak to public comment in general and when public comment is allowed, et cetera, as set forth in the hearing, the case management order. AG Davenport.
Thanks, Chair. Assistant Attorney General Kyle Davenport. I would like to just briefly run through a portion of the August 30th amended pre-hearing order, which, and specifically the part at the bottom of page 3 regarding public comment. And for everyone's edification on this meeting right now, there are 2 public comment sessions, as the order makes clear. One is taking place right now, oral public comment session. There's another tomorrow, September 4th in the evening. These, as the order makes clear, are the only two opportunities for the public, only two remaining opportunities for the public to make oral comment to the commission. The commission will not receive oral comment after the second session concludes tomorrow. And I'd also like to note that in the same section at the bottom of page 3 for the amended pre-hearing order, that the deadline for written public comment for this matter was August 27th, 2024. So that means the commission is not accepting any more written public comment on the cumulative impacts rulemaking.
Okay, thanks for that. And to sort of provide perspective on that, we provided a ton of opportunities for public comment, both written comment and oral comment. And we just wanted, I think the point there is that we want to make sure that everyone sort of follows those rules and regulations. I would note that oftentimes in rulemaking, commissioners' email boxes get bombarded with additional public comment, and just let folks know that, you know, we discourage that. We need to make sure we've got a good record and everything is within the record and it is established under the Administrative Procedures Act. So we discourage additional sort of emails to commissioners during this time and encourage folks to participate via our rules, which we really relish that public comment. And speaking of which, we will now turn to additional public comment. We now will hear from, looking at who's on the stage, it looks like we don't have Scott Hatfield yet who signed up, but we do have Ryan DeCrescent. So Ryan, you are acknowledged. You have 3 minutes.
Yes, great. Thank you. I'm here. I hope you can hear me.
We can.
Great. Commissioners, yeah, thank you. My name is Ryan DeCrescent. I live in Boulder, Colorado, 34 years old. I'm here today representing myself, and I hope the well-being of all living beings. I'm going to be honest, I'm not a politician. I'm not a business person. I've been a professional research scientist for about 10 years. And this proposed rule has a lot of technical detail, and in limited time, I simply just want to share how I relate to the term cumulative impacts generally. To me, it's sort of something like, what level of detail do we want to pay attention to? The scientific community and thus humankind in general develops in a positive and healthy way only when we report our findings honestly and completely. And I want to repeat those terms, honestly and completely. If we don't do those things, we call that sweeping it under the rug. And that is a huge no-no in the scientific field. People's careers can, in fact, effectively end if they're caught doing this, at least repeatedly, and they'll be shunned from the community and distrusted. So to me, only accounting for and permitting based on direct emissions from industry is sort of like this terribly crude modeling practice in my field, or terribly crude modeling practices in general, where there's a whole lot more we can be taking into account to approach the truth. In the case of industrial pollution, this crude modeling might only account for, it's hard to say exactly, but perhaps 25% of the whole story. And there's so many other features we can consider that get us closer to the truth. Like, you're a bunch of intelligent and caring people, and I know there are so many more people, smart people in this world available and interested in solving these problems. It's painful to know that industries can get away with this poor practice that I've called sweeping it under the rug. As doing this is just inconsistent with the greenhouse gas reductions roadmap and the practices I think we all know we need to be doing for our well-being. With that, I'm just going to thank you for letting the community participate in this very interesting and important conversation, and appreciate the work you do and your time. Thanks so much.
Thank you, Ryan. Really appreciate you taking time out of your day. You're right. This is interesting and important, and we will look forward to hearing from all members of the public in this first session on the cumulative impacts rulemaking. Next, we had signed up Karen Bigelow, but I don't believe we have found her yet. Following Karen, we have Megan Kemp, and I believe we have found Ms. Kemp.
Good morning, commissioners. My name is Megan Kemp, and I serve as the Director of Healthy Air and Water Colorado. We are a nonpartisan nonprofit composed of hundreds of health professionals across our state, and we all advocate for equitable, health-focused policy solutions to not only mitigate the causes of climate change, but also to ensure that every community and its health is resilient and adaptable to current climate impacts. I hear very frequently from our healthcare provider members seeing the impacts of climate change almost daily in the patients they're treating here in Colorado. Children are experiencing a greater number of asthma attacks on high ozone days. Older adults' risk and concern for their cardiovascular health increases, especially during extreme heat days. And pregnant people intuitively know that wildfire smoke harms their own unborn children. Strong research proves that climate change and oil and gas pollutants directly compromise our health. This is especially true for residents that are predominantly low income and communities of color. Recognizing the importance of protecting the public health of people and our environment, Colorado law now mandates new rules to mitigate the cumulative impacts of oil and gas operations, one of the top drivers of climate accelerating pollution in Colorado. Unfortunately, the most recent draft rules put forth by the Commission fail to implement adequate protections in disproportionately impacted communities. Instead, this recent version caters to industry requests that yield few meaningful protections at the expense of Coloradans that need them the most. An earlier version of the draft rules would have strengthened the 2,000-foot setback by removing problematic loopholes, but the Commission reversed course in its most recent rule draft and walked back community protections. This directly threatens public health and environmental justice, as research indicates the chance of adverse health impacts greatly increases within 2,000 feet of oil and gas operations due to proximity and exposure to toxic and cancer-causing emissions like methane and benzene. With this rulemaking, the Commission has the opportunity to better protect our communities and public health. I urge you to strengthen these rules to accomplish the tasks set forth in legislation and create truly meaningful protections for Coloradans and our collective health. Thank you.
Thank you, Ms. Kemp, for the testimony. We now will hear from Joan Patterson.
Hello. Thank you for listening to all of our statements today. I have some note cards here, but I'm just going to go off script. I live in Douglas County. I fall outside of all of those mile-long radiuses that are the places where we would like for people to have informed consent. But I work as a tree worker outside all over the Front Range, trimming trees. And I experience the effects, the cumulative effects, every day during the summer, especially on the high ozone days. It gets hard for people who work outside, and that's hundreds of thousands of people who live in Colorado, work outdoors. It gets extremely difficult to breathe when you're working outdoors, and a lot of us don't have asthma. We're all pretty healthy people. But we haven't had that happen to us until really this summer. We started noticing a compounding effect of high ozone days. I have coworkers, or have had coworkers, who have autoimmune diseases who can't go to work on days where there are high ozone reports. They have to stay indoors. So this is something that, while I don't have statistics on all of these things, I just know that it directly impacts people's lives and their ability to make a living. It impacts, like just a very mundane thing, impacts our ability to meet a quota in tree work. When you are in a tree and you can't breathe and you have to stop a job and you just can't get the work done. And we've all had that experience in that industry. And I'm also on here as a mother of two and a concerned Colorado resident, especially for the communities that are disproportionately affected, the schools who have drilling operations happening, so close to children. It's not just the statistics of what we know now. I get very concerned about the things that we don't know. There's always the impacts that you find out happen later because of your exposure to these things at a young age. And what I'm hoping is that you will have a better definition for cumulative impacts. Thank you.
Thank you very much for your participation with us this morning. We now will hear from Shayna Oliver.
Hi, can you hear me?
Yes.
Thank you. Thank you for taking public comment. I would like to remind everyone that we are on the unceded lands of the Cheyenne, Arapaho, Ute, including 45 tribes that have ancestral ties to Colorado. My name is Shayna Oliver. I'm a Northeast community member of Denver, Indigenous people's rights advocate, field organizer for Eco Madres and Moms Clean Air Force Colorado, a national organization of moms, dads, and caregivers united in fighting for all children's right to a safe environment. Over 42,000 members in Colorado are looking up to leadership to move forward with effective systems and practice rulemaking that results to action for all children's cumulative impacts on health and rights to live, play, and learn in a safe environment. Most importantly, I'm an Indigenous mother of 4 and wife. We are the descendants of the genocide known as the Indian Removal Act, known to the Diné as the Long Walk of the Navajo. Colorado's disproportionately impacted communities have seen an increase in ground level ozone pollution. In fact, Colorado is the 6th worst state to breathe, and according to the American Lung Association's State of the Air report. This rise in air pollution makes it hard for community members to simply be outside, including myself and my 12-year-old son who also has asthma. Oil and gas operations are Colorado's leading source of methane pollution, a powerful climate change pollutant responsible for about a quarter of the climate change we're experiencing today. Oil and gas operations are also responsible for 30 to 40% of ozone-forming volatile organic compounds produced on the Front Range. So that information could be found on CDPHE's greenhouse gas inventory report as well. Other information can be found on scientists' pinpoint sources of Front Range ozone. But bottom line, communities disproportionately impacted have been paying the price for their health, from asthma attacks, decreased lung function, increased risk of respiratory infections, susceptibility to pulmonary inflammation, and aggravated lung disease like emphysema and COPD. Studies also link lower birth weights in newborns to ozone levels in their community. Like myself, I was born as a low birth weight, premature at birth. So moms are counting on your leadership to move forward with effective cumulative impacts and enhanced systems and practice rulemaking that implements House Bill 23-1294, pollution protection measures, and also, long waited for Senate Bill 19-181, protect public welfare, oil and gas operations, which includes cumulative impacts. So we would like to see that actually being implemented through this rulemaking. Thank you.
Thank you for participating with us this morning, Ms. Oliver. We now will hear from Sierra Guerrero.
Good morning. Thank you for hearing my comment on this issue. My name is Sierra. I am a mom of 4 from Colorado Springs, and I live on unceded Ute, Cheyenne, and Arapaho land. when I learned that there were commissions like the ECMC whose job it was to work on these kinds of critical issues, I was relieved that someone's job to work on these things. But when I looked at the most recent draft of the rules, I was disappointed with what I saw. I recognize that these are complex issues with many different viewpoints weighing in on them. And the truth is that in today's times, when commissions like these have an opportunity to make decisions that lead humanity in a direction that breaks with our long-held pattern of putting profits above people, it's more important than ever that you do your best to make sure your decisions are not causing additional harm. I ask you to take a look at the current IPCC report and consider that our reality is currently asking us to make different types of decisions. I'm sure you're aware of the urgency of this issue, and I encourage you to remain brave when up against industry interests that aim to extract as much as possible at all of our collective detriment. The cumulative impacts of oil and gas pollution show up far beyond what's being considered and affect people in disproportionately impacted communities, as well as everyone else in the state, to be honest. The term cumulatively impacted communities doesn't extend protections to the rest of the impacted communities. And so I agree with the idea that people have brought up of removing the CIC term from the rules. And I also think we do definitely need more informed consent than the range that the rules describe. I'm suggesting also that the rules shouldn't allow new permits in areas that are already experiencing warming that's more than 1.5 degrees Celsius. Avoiding doing that will affect every single one of us in terms of our ability to grow food, access water, especially during droughts, breathe clean air, and have a livable future for our children. Thank you so much for listening and considering my comment today.
Thank you for being with us and the public comment that you provided. We now will hear from Jan Douglas.
Good morning, and thank you for this opportunity to give public comment. I'm Dr. Jan Douglas, a resident of Denver, retired family physician. I spent most of my over 35 years in practice taking care of patients in clinics that serve disproportionately impacted communities. I stand for those patients now and urging the ECMC to adopt stronger rules to protect these communities from the cumulative impacts of oil and gas production in Colorado. DI communities suffer more from all the impacts of the wasteful, non-sustainable, polluting, fossil fuel dependent society in which we all take part. We all breathe in ozone, nitrous oxides, and PM 2.5. We ingest PFAS and microplastics in the air we breathe and in the water we drink. Cancers, neurologic illnesses like Parkinson's, developmental problems like autism are all increasing, and that increase is more and more thought to be a man-made problem due to the pollution we are spewing into our environment. But low-income communities and communities of color suffer more from these hazards. The neighborhoods in which they can afford to live are ones that are more polluted and are ones where industry knows they will get less pushback from residents and governmental regulation as they put profit ahead of people and of a healthy environment. The Colorado legislature has again and again directed the ECMC to address cumulative impacts on DIC of oil and gas operations. It is foolhardy to permit a new well pad based on the emissions of that particular pad, rather than looking at the total air quality of the area. People do not breathe in the isolated air from that well pad. They breathe in the pollution from all the well pads that surround their home, as well as traffic and other industry. In order to look at cumulative impacts, operators must document the existing impacts in an area when they apply for a new permit. Furthermore, rules proposed in June by the ECMC require that any drilling within 2,000 feet of homes in a DIC get the approval of those residents. After industry complaints, this requirement has now been removed. At a minimum, this requirement should be reinstated such that disproportionately impacted communities can speak for themselves about the impact of new nearby oil and gas development on their health and livelihoods. Thank you.
Thank you, Ms. Douglas, for participating with us this morning. We now will hear from Eleanor Andrews.
Hi, can you hear me?
Yes, we can hear you now.
Thank you. Thank you, commissioners. My name again is Dr. Eleanor Andrews, and I'm representing myself. I live in Greeley with my family, and we are in a census block group that, according to the Department of Public Health and Environment's EnviroScreen tool, is in the 80th percentile of disproportionately impacted communities. So, of course, we bear a greater health burden and more environmental risks, and that's not good, especially for my 2-year-old or for my 3-year-old. And at least, sorry, it chokes me up. They are 2 and 3 years old, and we will not stay in this state if they cannot have clean air to breathe. I also teach and I conduct research on energy production and the causes and consequences of climate change. I was at CSU, now I'm at the School of Mines, so I speak as a scientist as well. It was hot this summer, and last summer, and the one before that as well. And not just because I was pregnant for 2 of those summers. Average annual temperatures in Colorado have gone up by 2.5 degrees Fahrenheit in just my lifetime. I do not understand how that does not count towards cumulative impacts and the baseline against which applications for new permits for wells are assessed. The current draft rule limits consideration of cumulative impacts to a very small radius. Obviously, impacts extend well beyond that. There was an earlier commenter who was also a concerned and, dare I say, confused research scientist like him. I don't want to say he's confused, but I am. I simply cannot understand the inconsistency at play. How can the commission continue to permit wells that add new sources of ozone within the non-attainment area and also permit wells that are new sources of greenhouse gases when our state is not on track to meet its greenhouse gas reduction targets? We have to start somewhere. And in fact, we did. The legislative intent of these rules from several years back is very clear, and it would be an embarrassment for the state to go back on those principles. The changes ahead are not a hard choice anymore. We know how much all this pollution really costs. And thanks to massive federal investments and more, we are finding ways to pay for it. We have a chance to build something better, a more fair economy, a more prosperous economy, one where any hint of transitioning off of fossil fuels does not bring out people to say, well, the school children will suffer because of school funding. We can move past this. We are smart, we are professional, we have the data, we know what to do. And the tide is turning. The ECMC has an extraordinary opportunity to lead, and I beg that you do. Thank you.
Thank you, Dr. Andrews. We appreciate you being with us and providing the testimony for us this morning. Appreciate it. We now will hear from Carol Hawkins.
Can you hear me? Hello?
Yeah, we can almost kind of hear you. Can you speak up a bit?
I'm coming in. Okay. Can you hear me now?
Yeah, that's better. Visually,
Okay.
you're appearing to us sideways, but that's fine. We can still see you.
I don't know. I'm not a technologically advanced person, but
It's okay.
I have become somewhat of a community expert on oil and gas in all Colorado. So my name is Carol Hawkins, and I live in Alt, a disproportionately impacted community in Weld County, a community that's been bombarded by fracking since I moved back to Colorado in 2017, and shortly thereafter was served with a forced pooling notice, which I protested. Welcome to Weld County. I've come to rely on Andrew Klooster of Earthworks to capture subsequent major emission events in Alt with his OGI camera. We have compiled over 3 years of data that we are analyzing now of captured major emission events in and around Alt. Bayswater sites in particular, whose permits I have protested before this very commission, only to be dismissed because citizen impacts did not matter. And then I had to listen to Bayswater address your questions that dealt with citizen impacts with cliched answered like, we only use best practices. So much for best practices. But citizen impacts do matter. As studies indicate that I live near well that because I live near well pads, I'm at a greater risk of dying prematurely, more likely to suffer from respiratory and heart issues, both of which have come to pass. The bloody noses came first, then a nasal infection, followed by the discovery of lung nodules, high blood pressure, sleep apnea, worsening anxiety, and insomnia. None of these ailments existed until I moved to Alt, and I was a full-time caregiver to my partner with Alzheimer's for 10 years, and I never had these issues. And I thought that was the biggest challenge of my life. Furthermore, premature birth and low birth weights are also associated with living near well pads. Indeed, my grandson, who is a working class guy who has to be outside in this filthy air every day, his first child, my great granddaughter, came early and she had a lower birth weight and at 18 months is showing signs of language delays. Am I angry? Yeah, I'm angry. And I'm scared, just like the woman before me and all the people before you that have tried to talk to you about health impacts. They too, my grandson and his family, live in Alt. You know why? Because we can't afford to live in Fort Collins. This is where working class working people and oil and gas workers live, in low-income communities like Alt, who are disproportionately impacted because profits and politicians like our current governor sells us out, pay to pollute, policy initiatives. So we're being gassed in Alt. What is this committee going to do about it? There's your qualitative analysis. Now let me get you to the quantitative, because yes, I have a PhD. I know how to do research. But Andrew Klooster and Earthworks came to my rescue. And this is from Andrew. First, we'll define some terms. A survey is an individual survey. And okay, let's go. I'm going to go right to the point. The easy way to sum up all this is to say that it is very common for pollution to occur in these facilities, both for intended and unintended reasons. The pollution is pervasive and a major factor that should be considered by the ECMC for meaningfully addressing cumulative impacts. 3 years of data. The video is on YouTube.
Ms. Hawkins, please wrap up.
One complaint averages out, one complaint for every time we have been out in the field. Phase water, the permit you approved, is the biggest major emission of these toxins into our air. And I blame this commission and our governor and the pursuit of profits. And I will have a voice and I will be heard because I protested that.
You are done.
Go ahead, cut me off. I watch you eat your breakfast and get a cup of coffee and go to the printer and everything.
All right, folks, I started this hearing with the fact that we've got a ton of work ahead of us. We have a mandate to get this done by a specific period of time. I really need folks to pay attention to the time. That was disrespectful, frankly, and I want folks to be respected. So from here on out, I want people to pay attention to the clock and keep their comments within the 3 minutes that are allocated. That is a sufficient time for everybody to be heard. All right. We now will hear from Brad Clayton. Good morning. We have heard you before. We look forward to hearing from you this morning.
Yes, good morning. Thank you. My name is Brad Clayton. I was a party to the mission change rulemaking, and I was a member of the Biological Resources Working Group as a representative of the Colorado Native Plant Society. Today, I'm speaking on behalf of myself. Senate Bill 181 says ECMC shall protect against adverse environmental effects on any biological resources. Senate Bill 181 made protection mandatory, not optional. It removed the qualifier significant from the impacts protected against. It disallowed you from taking into consideration cost effectiveness and technical feasibility, and it valued biological resources for their own sake. not just as they service other values. We are now into year 5 of ECMC kicking the issue of biological resources down the road. And with the August staff draft, you are doing it again for perhaps another 2 years. Since 2019, 2 other laws affecting ECMC have also included the biological resources language in the definition of cumulative impacts. And 2 letters from legislative sponsors have chastised you for ignoring it. In addition, CPW this year with HB 241117 got statutory authority to conserve rare plants and invertebrates. So CPW needs to step up to the plate as well and not continue to kick the can down the road until after the 2025 swap is completed. I'd also note, I forgot to mention that in back of me are the 17 species of rare plants that were identified 10 years ago as being vulnerable to oil and gas operations. Staff's attempt with CPW concurrence to substitute high-level habitat types for examining impacts on individual rare species makes a sick joke of the law's requirements. Yes, BRWG's definition of biological resources was broad, but a reasonable interpretation of it would focus on those species that are at risk. Even COGA recommends that biological resources focus on the plant species identified in the swap. Together with the federal agency list of species of conservation concern and species ranked S1 to S3 and G1 to G3, that should be the focus. The simple solution to these supposed overwhelming complexities is to just require a biological assessment of every OGDP and CAP. Operators on the western slope have done this for years when accessing federal minerals. It's standard operating procedure. So please restore the definition of biological resources, tweak to emphasize at-risk species, require biological applications, assessments of all applications, and let's start to protect native plants from the continued environmental impacts of oil and gas. The time is now.
Thank you. We appreciate your continued presentation with us. We appreciated hearing from you during the mission change. So I appreciate your comments. They're helpful. Next is Wade Pridgen. Mr. Pridgen, I may not be pronouncing your name correctly, I apologize, but do you want to unmute?
Yes, can you hear me now?
We can, yes.
Thank you. Hi, my name is Wade Pridgen. I volunteer on 2 farms as well as my own here in the North Fork Valley. The North Fork Valley is experiencing challenges from climate change. We had a highway washout from excessive snow melting in 2023. Cancers in the lives of our citizens has increased. Large cottonwood trees are dying in large numbers currently. The climate change occurring in our area is like a ticking time bomb. Eventually, our climate, due to more increased warming, will continue to escalate to stronger and more severe thunderstorms. There have been several warnings this year and last year to neighboring communities 20 plus or minus miles away that have caused severe washes, shutting down roads and accesses for a community. The public is then subject to unsafe conditions. Our community has even more threats from a climate change event, being the disruption and contamination of our irrigation water that serves our farms and ranches, crops and livestock. The oil and gas wells and pipelines are all uphill from our most vulnerable resources for irrigation water. Our community has irrigation ditches, Fire Mountain, and Farmer's Ditch that run 10 to 15 miles to service farms and ranches. The risk to public welfare would be devastating to people, economics and commerce, environment and wildlife. The threat of wildfires is increasing exponentially along with these storms. Lightning strikes are increasing with each storm due to increased warming. Please reconsider this cookie cutter approach to cumulative impacted communities. There are real reasons to consider a larger area and a study for the communities impacted here. The emergency plans from oil and gas operators are inadequate and will not meet these climate change challenges. Please make these operators do more to provide more intense plans to protect this special community, the North Fork Valley. Please also make oil and gas operators provide better records to provide adherence to current laws for fresh water protection and provide an audit by an independent reviewer for oversight. Thank you for your time.
Thank you, Mr. Prejean. Appreciate your being with us. We now will hear from Karen Artel.
Hi, Karen Artel here. Thank you for the opportunity to comment. Addressing cumulative impacts is important due to the intensity of Colorado's oil and gas development, especially along the North Front Range where I live. Intense oil and gas development directly competes with the safety and well-being of Colorado's residents and ever-increasing population. The ECMC's cumulatively impacted community designation should be removed from the rules. The ECMC limited enhanced protections for disproportionately impacted communities to a very small number of DI communities labeled as cumulatively impacted. But all DI communities should be afforded the same heightened protections, requiring emission sources to actually reduce air pollution. Statewide agencies like the ECMC may, by rulemaking, prioritize certain definition criteria or community subsets that meet the DI community definition. You can do this in a way that makes sense for oil and gas development in and near DI communities, and that is actually protective. The designation of impact area in the draft rules needs to be completely reworked. Oil and gas development is the largest contributor to ozone precursors in the North Front Range. The Regional Air Quality Council ozone season summary table shows all the first to third max ozone levels, except one, are in the 80s to 90s range. These draft rules do not adequately address Colorado's severe ozone non-attainment. The impact area should include the whole of the ozone non-attainment area. Pre-application consultations regarding the impact area should include more than the director, relevant local government or federal agency, and the operator. For example, proximate local government should be added to the consultation. The DI community definition notes that the lack of public participation as one of the factors that may act cumulatively to affect health and the environment and may contribute to persistent disparities. But the draft rules disregard the legislation regarding impact area. The impact area provisions need to include disproportionately impacted communities in decision-making, along with the long-suffering communities in the ozone non-attainment area. Impact area decision-making should be in a public forum in which impacted communities can provide input. The draft cumulative impact rules as written take protections backwards for the communities the ECMC is charged with protecting. Thank you.
Thank you. We appreciate your participation with us. We now will turn to Leslie Schill.
Good morning. Thank you for the commission for taking my comment today. My name is Leslie Shine, and I'm a doctor of physical therapy, and I am here representing myself and my family. I work with children and adolescents in the Broomfield area, and I have 2 young children of my own. In my work as a physical therapist, I am regularly making decisions about how to safely help children return to healthy physical activities, while at the same time weighing the extreme risks of exercise in times of significant levels of air pollution and dangerous heat. The facility where I work has a wonderful outdoor area that can be used for therapeutic exercise for young patients. However, my colleagues and I are increasingly needing to reduce the amount of time we are outdoors with patients due to the high levels of pollution, including PM 2.5 and ozone, in addition to the extreme heat. Increasing rates of childhood asthma are only compounding these concerns. I kept my own children indoors on many days this summer due to the unhealthy air quality. As you know, oil and gas is the primary source of ozone-causing substances in Colorado. Because of the hazards to human health, I strongly urge the committee to take up the most stringent rules possible. This includes rules for cumulative impacts of many wells in one area. Wells in areas where impacts are too great must be denied. In addition, the committee should strengthen rules that protect disproportionately impacted communities. To best protect the health of the most vulnerable Coloradans, no new wells should be permitted in disproportionately impacted communities. In order to protect human health, high-emitting activities must not be allowed during ozone season and high pollution days, and new permits must not be granted if Colorado is not meeting emissions reduction goals. The committee has an obligation to protect health and quality of life for Coloradans and everybody who is living downwind and downstream. Thank you so much for the work that you do. Thank you for prioritizing human health, especially the health of children. And thank you for your time today.
Thank you very much. Appreciate your being with us this morning. We now will hear from Edward Behan.
Good morning, commissioners. My name is Ed Behan. I live in Fort Collins, Colorado. I have given you feedback before on behalf of the Larimer Alliance. I am here speaking for myself. My community is in a unique position regarding the cumulative impact of oil and gas activity in northern Colorado, as we are frequently subject to some of the worst air quality readings in and around the EPA's non-attainment zone. While I'm aware that vehicular traffic and other industrial sources are factors in that dubious distinction, the regional impacts of the massive oil and gas operations in Weld County remain the most significant contributor to the prevalence of ground level ozone and other emissions that affect the health and well-being of our residents. It is disappointing to see how your rulemaking processes have evolved since the release of your earlier draft regulations in June. I am aware of concerns expressed by some 24 of our Colorado state legislators about the weakening of those rules. This is not a time to be going back on our commitment to better regulation and cleaner air. I want to remind you all that the mission of your commission is, quote, to regulate the development and production of oil and gas, deep geothermal resources, the capture and sequestration of carbon, and the underground storage of natural gas in a manner that protects public health, safety, welfare, the environment, and wildlife resources, end quote. Any regulations that do not pay the most stringent attention to how any new or continuing energy development operates, and which rely primarily on the industry to report on itself to ensure compliance with relevant rules and health and safety concerns, are not worth the paper they are printed on. There are many here today who are more competently drawing attention to the failings of specific provisions in the current draft regulations, and I urge you to pay attention to them. I just want you to be transparent in doing the people's business and not draw back from the necessity of tighter regulation of oil and gas industry in Colorado. Our people and the planet deserve no less than that. Thank you for your attention this morning and the work you do.
Thank you for presenting to us this morning. We appreciate your time. Ms. Vanderkool?
Lois Vanderkoy, Broomfield resident. In 2017, Extraction came to town proposing 144 wells less than 2,000 feet from residents. That became an incentive for Broomfield citizens to change our charter, advocate for Senate Bill 19181 and later legislation, and appear before you to gain better protection from oil and gas operations. I know you tried to find a balance between protecting health and fostering development, which is complicated and adversely impactful in many ways. But the balances you reach greatly favor the industry, perhaps because of their threats to sue and run ballot measures. They also work closely with you to minimize the financial impacts of regulation and oversight. It seems difficult for you to similarly respect the input of us and the Environmental Justice Task Force. I was pleased when Commissioner Mesner voted no on the Lowry Ranch cap because he follows the rules. What happened to the rest of you who admitted the cap was lacking? This speaks to how you develop rules with plenty of wiggle room and then try to negotiate with operators to gain a little bit of high ground. Your current draft is weaker than your June draft in providing protection. The same thing has happened with other rulemaking. Why? Don't you recognize valid data showing adverse cumulative impacts? Can't you be honest with the public? The strictest regulations claim doesn't really matter when you fail to fulfill the intent of Senate Bill 181 and later legislation, and the state fails to adequately address air quality, water quantity, and climate change, but rather pursues expensive and unproven schemes to keep the industry going indefinitely. Please strengthen these rules per legislative intent, which was already watered down by the governor and industry. I'm angry, sad, and fearful as our world burns and floods. We need to transition quickly to clean energy economy, and you have a role to play by denying permits that go beyond certain thresholds. Please honor us by setting protective thresholds and applying them. Thank you.
Thank you for your public comment. Commissioners and Hearings Manager Thomas, that concludes the public comment from the folks that signed up. Am I correct in that assessment, Hearings Manager Thomas?
That is correct.
Okay. It's 10:32. Let's take a 10-minute morning break and return at 10:42, and then we'll get into case in chief. All right, we are reconvening on cumulative impacts and enhanced systems and practices rulemaking docket 2406-00145. It is 10:42. And I've got a few preliminary comments before we take up a presentation from staff. And this is for my fellow commissioners and for all of the 136 people that are participating with us. The way we set this up is we have a rulemaking this week through Tuesday the 10th. We then will be taking off a period of time to allow staff to redevelop and take direction from commissioners, and we're reconvening on the 17th through the 20th for rulemaking, and then we've set aside potentially the 23rd to the 27th. I want to let people know that our hearings officer was generous in provision of time to parties for their case in chief and rebuttal. I've run the math here, and as I look at it, we've got 16 hours of presentation from ENGOs and local governments and other community organizations. And then we have 10.5 hours of presentation from industry and other folks on that side of the docket. we need to get to a point on Tuesday, September 10th, where we are done with cases in chief, so that the commissioners can, at a high level, provide deliberative thoughts back to staff so that they can take advantage of the break that we consciously planned, so that when we come back, we can provide perspective to our stakeholders and listen in on rebuttal statements. What that means is that while we've allocated generous amounts of time, 970 minutes to the environmental NGOs and local governments, and 625 to industry, we need you to be conscious of your time, to be as efficient as possible, to not speak for speaking's sake, but instead get to your points, and not be repetitive in order to get this done. We understand the importance of the rulemaking. I think that's why we've been generous in time allocations, but we also need to meet our statutory deadline of getting this done in time. And in order to do that, we need to be done with cases in chief by the end of Monday, 9/9. With all that said, I had contemplated shaving some time, but I'm not going to do that. Instead, we're going to allow everyone their time allocations. But I'm putting all of us on notice, myself included, that if we get to Friday and we're not close to being done, we will convene a Saturday hearing. So set it aside, put it on your calendars, tell your families that you may be working on Saturday the 7th for 8+ hours in order to get us to a point where we're able to get through this rulemaking in a conscientious time, in a manner that gets everybody to be heard, because that's important. So I reiterate, block out Saturday the 7th. I hope it doesn't happen, and it's going to be based upon what you guys do. But if it comes to it and we need it, we will do it. So with all that said and done, appreciated the public comment. We're now going to move to cases in chief. And I believe we start with hearings manager. Oh yeah, we're going to start with our staff, Ms. Trask. I believe we're going to have a presentation from you and anyone else from ECMC. And I want to just start out by thanking you and your team for the really hard work, the conscientious work that you've done to get us to this point. I know you worked hard to deliver the June draft. And I know that you've worked even harder with your team to look at pre-hearing statements and provide to us additional alternatives that everyone ought to be talking about, so that we can make sure that we span the spectrum of cumulative impacts and enhance systems and practices, which is what we've been delivered to do. I am one commissioner thoroughly appreciative of that work. I'm appreciative of the fact that you've provided us with different alternatives for everyone to debate and think about, because that's how we get to the proper solution, is by thinking about all the proposed methods of dealing with what is admittedly a contentious issue, an important issue for the state of Colorado. So with that, I'll stop musing along, and I would love to hear from you in a presentation as to where ECMC staff is now.
Good morning, and thank you, Chair Robbins. Can everyone hear me okay?
We can.
All right. Good morning, commissioners and parties and stakeholders. My name is Sabrina Trask. I'm the manager of the Cumulative Impacts and Energy Transition Unit here at ECMC. I'll be presenting on behalf of staff today with the help of Senior Assistant Attorney General Caitlin Stafford and Assistant Attorney General Lauren Mercer. Our presentation is about an hour long today. We'll try to hold to that timeline, and we will be available for commissioner questions at the end of the presentation. Next slide, please. So this is just the table of contents. We'll walk through some of the legislative background, staff's goals for this rulemaking, and then we'll take an in-depth review of the process, the rulemaking process, our public comment summary, and then a really in-depth review of overview of staff's August 2nd draft rules. We'll also provide a summary of the protections that the August 2nd rules provide for disproportionately impacted communities. And then our attorneys general will jump in with some legal questions and issues, and then next steps for staff. I want to just flag for expediency for today in the presentation. We're using the term RBU, or residential building unit, today and in this presentation to include residential building units, high occupancy building units, school facilities, and child care centers. That's a mouthful, so we're going to abbreviate it in our presentation today with just RBU. And then I wanted to note that we've got a couple of staff notes in the presentation for reference for parties and for commissioners as well. Those staff notes are italicized and in that sort of blue-green font for your convenience. Next slide, please. The cumulative impacts and enhanced systems and practices rulemaking is a continuation of ECMC's long-term efforts to understand and implement improvements to its cumulative impacts analysis process. Starting in 2019 with the passing of Senate Bill 19181, ECMC promulgated the Mission Change Rules, which established a new permitting process that took a more detailed look at incremental and cumulative impacts associated with oil and gas operations. This resulted in the creation of the Form 2B, CITER, and the annual cumulative impacts report that was first published in January of 2022. In March of 2023, the governor provided direction to ECMC and the Colorado Department of Public Health and Environment, or CDPHE, to collaboratively implement rules to reduce oil and gas NOx emissions in the ozone non-attainment area. Also in 2023, House Bill 23-1294 was signed, which directed ECMC to conduct additional rulemaking by April 28th of 2024 to further incorporate cumulative impacts processes into its rules and also to define the term cumulative impacts. Next slide. House Bill 1346 and Senate Bill 229 were signed by the governor in May of this year, giving ECMC additional clarification in which to continue this rulemaking, this cumulative impacts rulemaking. House Bill 1346 changed the rulemaking deadline to September 30th of this year and provided us with new statutory definitions and the requirement to conduct a cumulative impact analysis on all new oil and gas operations. SB 229 provides ECMC the ability to hire 2 community liaisons and creates pathways for ECMC to collaborate further with the AQCC and APCD in reducing NOx emissions through intensity targets and enhanced systems and practices in the non-attainment area, and particularly in disproportionately impacted communities. Next slide, please. So staff's goals for this rulemaking process, based on these legislative mandates and based on input from our stakeholders and ECMC's mission to regulate oil and gas in a manner that protects public health, safety, welfare, the environment, and wildlife resources, staff's goal for this rulemaking includes 5 primary targets. First, to adopt rules that clearly evaluate the incremental adverse and beneficial impacts from oil and gas, as well as impacts from other past, current, and future sources in order to understand the cumulative impacts that occur in Colorado over time. Second, to adopt rules that clearly demonstrate how ECMC will address the impacts from oil and gas development in order to reduce adverse impacts that would otherwise contribute to cumulative impacts. It's important to remember here in this goal that although ECMC intends to evaluate other sources of impacts, such as midstream oil and gas, and other types of industrial facilities like power plants, transportation, and agriculture, ECMC does not have the authority to regulate or address those other sources of adverse impacts. Third is to adopt rules that focus on avoiding impacts first, then minimizing impacts, then mitigating those impacts that cannot be avoided or minimized. Fourth, to adopt rules that provide recognized and consistent protections for the health and well-being of people living and working in disproportionately impacted communities, as well as protections for the environment within those geographic areas. And fifth, to align and reduce redundancy of efforts and red tape between ECMC and CDPHE in our shared efforts to reduce NOx and, by association, reduce other components of air pollution at the same time. Next slide, please. This is a slide that probably looks pretty familiar to many of you. It details the Commission's stakeholder engagement throughout 2023, so last year, including a dozen formal listening and public comment sessions, both virtually and in person, as well as 2 Commission update sessions. In August of last year, the Commission opened an informational docket seeking input from stakeholders. We received over 60 written comments, many of which were discussed at the Commission's November 7th overview session. Next slide. In 2024, staff issued a preliminary draft rule called the Straw Dog to obtain initial feedback from stakeholders. Staff considered and implemented the stakeholder feedback we received and issued draft rules along with a draft statement of basis and purpose, or SBP. These 2 documents were noticed to the Secretary of State on February 9th for a rulemaking hearing in April. As April approached, it became clear that the legislative session would likely have a significant impact on the rulemaking process, so the docket was continued until after the legislative session concluded. The session ended with the signing of House Bill 24-1346 and Senate Bill 24-229. Staff again engaged with stakeholders and drafted a new version of proposed rules, which incorporated the new definitions and directives from the new laws. This new draft was noticed with a revised SBP on June 14th under docket number 24006000145. And as is ECMC's typical process, on August 2nd, staff issued yet another revised draft. This was followed with the release of the corresponding draft SBP on August 29th, just last week. Today marks the commencement of the rulemaking hearing on staff's most recent draft rule and SBP. Next slide, please. ECMC has received hundreds of written and oral public comments regarding cumulative impacts since January 2023. For today's presentation, we focus on those written comments received only in the last few months. ECMC opened a public comment window on our website on July 26th to accept written public comments through August 27th. We also opened a separate Google comment form from August 15th through 29th for commenters to sign up to provide oral public comments this morning and at the evening session scheduled for tomorrow night, I believe. That second public comment form also allowed stakeholders to provide written public comments in lieu of signing up for oral comments. So between the 2 Google forms, we received comments from approximately 448 individuals. I do want to note that some comments were submitted or received multiple times, resulting in quite a few duplications. Those, as well as comments submitted by out-of-state residents, were not counted here. Of the 448 comments received through these 2 public comment forms, just over 300 comments were all very similar in nature and appeared to be variations of a single form letter. Those comments expressed 3 primary themes. First, support of a 2,000-foot setback from residences in DI communities and the requirement for applicants to obtain informed consent to operate within that setback. Second, opposition to the use of the defined term cumulatively impacted community. And third, support for a requirement for applicants to conduct air quality monitoring prior to approval of an ECMC permit application. The remaining 145 comments we received were notably unique in their language. The themes expressed here ranged significantly, with the majority of comments indicating a need for greater protections to air quality, DI communities, including a 2,000-foot setback, water, and wildlife. Approximately 1/3 of the comments indicated concern about the proposed 1-mile impact area or a lack of baseline data necessary for a robust cumulative impact analysis. Roughly another third of the comments also indicated support for strict permit denial criteria and the adoption of thresholds or limits to pollution. Many commenters also described personal anecdotes and lived experiences related to oil and gas impacts, and some described concerns specific to their place of residence, such as on the West Slope or near the Lowry Ranch Cap and the Aurora Reservoir. Next slide, please. So most of the rest of this presentation will be a walkthrough of staff's August 2nd draft rules. We'll start with some of the 100 series definitions, followed by new rule 224 and an in-depth review of the 300 series. And finally, a few minor revisions to rules 803, 904, and 1201. No other rule series were noticed for this rulemaking and are therefore outside the scope of this rulemaking. Next slide, please. Staff took the definition of cumulative impacts directly from the text of House Bill 24-1346, with one exception being that we opted to use the words "the act" in lieu of using this Article 60. Parties to this rulemaking seem to be generally in agreement with staff on the use of this definition, which is good news. The words shown here in bold type and underlined are also defined in staff's draft and the topic of our next few slides. Next slide, please. Impacts to climate is a newly defined term that was derived from House Bill 24-1346. Again, parties generally seem to be in support of staff's introduction of this definition. The definition of reasonably foreseeable future development is taken directly from House Bill 24-1346. Staff intends that this definition includes the development of any type as indicated in the statutory definition of cumulative impacts. It is not limited to only oil and gas development. Staff also intends that an application or a permit is publicly available if it is visible or searchable on the permit issuing entity's website. We opted not to include a criteria for permit application completeness, as some of the parties suggested, since some permitting agencies might not have a completeness determination as part of their process. Next slide, please. The definition of impact area was also derived from House Bill 24-1346. Staff opted to have the impact area determined by the director through consensus process with participants at the pre-application consultation. This determination and application of the term impact area will be described a little more in rules 301 and 315 in this presentation. Next slide. The definition of disproportionately impacted community was unanimously recommended to the legislature and the governor by the Environmental Justice Action Task Force in late 2022. That definition was adopted by the legislature in 2023. Staff opted to specify the four main prongs of census block group designations, those being low income, housing cost burdened, people of color, and linguistic isolation. By statute, any agency can designate a DI community outside those four prongs if a community is identified as being one where multiple factors, including socioeconomic stressors, vulnerable populations, disproportionate environmental burdens, vulnerability to environmental degradation or climate change, and lack of public participation may act cumulatively to affect health and the environment and may contribute to persistent disparities. CDPHE's Air Quality Control Commission, or AQCC, established cumulatively impacted communities in their adoption of Reg 3 earlier this year and set the standard as any census block group that has an EnviroScreen above the 80th percentile. I'll note that for this rulemaking, staff is only considering EnviroScreen 1.0. The AQCC anticipates releasing EnviroScreen 2.0 later this year. That version of EnviroScreen cannot be incorporated into ECMC's rules without a subsequent rulemaking to update that reference. Staff would encourage the Commission to conduct such a rulemaking in order to ensure our GIS maps and information gathered in permit applications is current and consistent with AQCC. Next slide, please. The definition of enhanced systems and practices was adapted from Senate Bill 24-229 as equipment, methods, or other operational techniques that are designed to avoid, minimize, and mitigate emissions of ozone precursors from oil and gas operations. Some of the rulemaking parties indicated this definition could be better aligned with the statutory language by clarifying that it only applies to new operations and only those operations taking place in the ozone non-attainment area. Staff agrees and would ask the Commission to consider this revision. Industrial facility is a term staff is defining as those facilities that conduct industrial or manufacturing operations. It includes such facilities like oil and gas and other energy production and refineries, agricultural industries, steel and cement plants, manufacturing, mining, airline operations, wastewater treatment plants, landfills, and abandoned coal mines, although this list is not exhaustive. Industrial facilities are one component in identifying past, current, and future sources of adverse cumulative impacts in the permitting process. Next slide. 8 other definitions have been added to the 100 series rules. They're listed here with a reference to where the definition originated. As these definitions are generally well known and widely accepted, I'm not going to review them in depth today. Next slide, please. SB 24-229 mandated that ECMC will appoint at least 2 community liaisons to serve as dedicated resources for disproportionately impacted communities regarding commission regulation. Staff's first draft rule all the way back in February 2024 first introduced the concept of community liaisons based on recommendations of the EJ task force. The August draft refines the role, which has been added into specific rules throughout the 300 series. Staff would like stakeholders to note that we do intend to hire a West Slope liaison and a Front Range or a DJ Basin liaison to ensure that these staff members have expertise in environmental justice issues pertinent to those regions. Ideally, these positions will be filled by people living in those locations. Staff is also pleased to confirm that most, if not all, of the parties to this rulemaking support this rule. Next slide. So jumping into the 300 series, we'll be in this series for a little while, and I apologize for the visual disinteresting slides here. It's just a lot of text. So Rule 301F was amended to clarify that if the local government or federal agency with land use authority doesn't require a pre-application consultation, the director will require that consultation with the operator pursuant to new Rule 301G. 301G lays out the pre-application process that staff and operators have been voluntarily conducting for almost 2 years now. This pre-app consultation will now be required for every OGDP unless a pre-application consultation is conducted through the local government's process. The consultation will include a discussion on possible alternative locations, an overview of cumulative impacts, including a determination of the impact area and the operator's greenhouse gas intensity status and NOx intensity status where applicable. Invitees will include the relevant local government, all proximate local governments, any state or federal agencies with land use authority or mineral interests, CDPHE, CPW or Colorado Parks and Wildlife, all residents within 2,000 feet of the proposed location, and the community liaison if the proposed location is within 2,000 feet of homes that are also within a disproportionately impacted community, or if the proposed location is within a CI or cumulatively impacted community. Next slide. New Rule 301H introduces a new requirement for operators to provide pre-application notice to residents within 2,000 feet of the proposed location. Current Rule 302E already requires this notice to the relevant and proximate local governments. New Rule 301I is the incorporation by reference of AQCC's Reg 7, and specifically the 2024 version of Reg 7, which includes AQCC's NOx intensity program. This incorporation only applies to the 300 series rules. It does not extend to other ECMC rule series because those rules are outside the scope of this rulemaking. We'll talk specifically about the 900 series a little bit later in this presentation. To eliminate confusion around having different versions of Reg 7 in our rules, staff would encourage the Commission to hold a future rulemaking to update all incorporations by reference. Next slide, please. As we'll see on slide 21 in a moment, the draft rule would require an alternative location analysis performed on every location proposed in an OGDP. This makes the ALA criteria obsolete. In Rule 302B, we've removed the language around ALA criteria to better describe the local government's siting disposition. In Rule 302C, staff made a small but significant change by striking the phrase defer to and replacing it with consider regarding the director's review of the local government's siting information. We recognize the co-equal authority shared between ECMC and local governments in the siting of oil and gas operations, and we anticipate that through the pre-application consultation and other engagement, the director and the local government will reach the same conclusions on siting decisions. However, where a local government makes a siting determination that is outside the director's legal authority to support, we want to ensure there is no implication that the director would cede her authority. Next slide, please. So procedural requirements for OGDPs, Rule 303A5 is the Form 2B, which is the Cumulative Impacts Data Identification Form. This Form 2B is still required as a component of every OGDP. We've taken the language around the Form 2B out of Rule 303A5 and moved all of it to new Rule 315, which we'll walk through later in this presentation. Rule 303D updated the public comment period. There seems to be a little bit of confusion with some of our stakeholders about the public comment period, what we've proposed right now. So I wanted to make it as simple as possible. What we're proposing is a 60-day public comment period for locations that are within 2,000 feet of RBUs, where those RBUs are in a disproportionately impacted community. This is changed from current rule 45-day period. 60-day public comment period also for locations that are located within a CI community. 45-day public comment period for locations that are within 2,000 feet of RBUs where those RBUs are not in a DI community. 45 days for locations that are proposed within a DI community. This is changed from the current rule of 30 days, and then 30 days for all other locations. Next slide, please. So we're proposing that an ALA is required for all OGDP locations that would require a Form 2A. So this would include both new locations and existing locations where significant amendments are proposed by an operator. The ALA criteria has been removed, and certain information requirements that are currently listed in the ALA have been moved to the cumulative impacts analysis, which is in new Rule 315B. We've done this in order to reduce duplication across both the ALA and the cumulative impacts analysis. Rule 304B2D introduces the cumulative impacts analysis, or CIA, and I apologize for all the acronyms. Cumulative impacts analysis would be required for all OGDP locations that also require a Form 2A. So again, new and amended locations. The CI analysis includes how the proposed location best avoids, minimizes, and mitigates adverse cumulative impacts. We'll go over that in more detail in Rule 315B. Next slide, please. So some of the smaller revisions to the materials required in a Form 2A includes the existing location drawing will now require the addition of industrial facilities. disproportionately and cumulatively disproportionately impacted and cumulatively impacted community map is already required for locations proposed within 2,000 feet of RBUs in DI communities. There is a new requirement for this map for locations that are proposed within CI communities, regardless of proximity to RBUs. This map would now require information about the distance and the direction to all RBUs within 2,000 feet of the proposed location, and would also require a table indicating the number of RBUs that are found between 2,000 feet and 1 mile of the proposed location. Rule 304C, there's a long list of plans. These plans must address incremental and cumulative impacts. Next slide, please. 304C19 is the Community Outreach Plan. This is already required for locations within 2,000 feet of RBUs where those RBUs are in a DI community. There would be a new requirement for this plan for locations that are within CI communities, regardless of proximity to RBUs. This revised plan would also require a description of the impacts that are anticipated from both pre-production operations and the long-term production operations of the location over the lifetime of the location itself. It also would require a description of the operator's long-term plan for continued outreach and engagement with the residents living within 2,000 feet. Rule 304D is existing lesser impact area exemptions. The draft rule is proposing that these exemptions would be prohibited for locations that are within 2,000 feet of RBUs, where those RBUs are within a DI community. These exemptions would also be prohibited for locations that are within a CI community. In addition, the revised rule would make ALAs and cumulative impact analyses ineligible for these exemptions. Next slide, please. Substantially equivalent information. We've had over the last few years, we've had a number of operators and particularly Weld County, who we've worked very closely with to develop substantially equivalent information. That's where in a local permit process, certain information is required for the local permit for the local government. As an operator develops that documentation, they're able to submit that document with their OGDP application. It may not exactly meet our rule requirements to a T, but it answers the information that we're seeking through our rule requirements. So we've revised this, we've proposed a revision to this where the ALA and the cumulative impacts analysis must meet the rule requirements. There would be no substantially equivalent information accepted in lieu of these rule requirements. However, ALAs or CIAs that are developed through the local permitting process or a federal permitting process would be accepted as supplemental material if the applicant wishes to include them in their OGDP application. Next slide, please. Rule 306 is the director's recommendation on the OGDP. The recommendation of approval would only exist when the OGDP is protective and when the operator has not exceeded its NOx where applicable and its greenhouse gas intensity target. Possible conditions of approval based on the NOx and greenhouse gas intensity target status indicated on the operator's most recent Reg 7 annual and or interim reports. This would be where the director is seeking additional information regarding additional information from the applicant regarding information that they've provided in their annual and interim reports. So some of these COA's conditions of approval might include limitations to pre-production operations during the ozone season in the non-attainment area. For new to market operators or operators not subject to NOx targets, they would need to acknowledge future compliance and or continued exemption of NOx targets. This would be documented in a condition of approval on the permit application. The director may recommend denial if the operator has exceeded its NOx or greenhouse gas intensity target. And the notice of the director's recommendation would now be required for those individuals who participated in a post-completeness consultation, and we'll get to that in Rule 309. If they provided an email in that consultation, then they would receive the notice of director's recommendation. Next slide, please. Following the director's recommendation, we have the commission's consideration of OGDPs. The commission could approve the OGDP if the operator has not exceeded its NOx or greenhouse gas intensity targets where applicable. There is a denial option for the commission if the operator has exceeded its NOx or greenhouse gas intensity targets, again, where applicable. Next slide, please. Shifting a little bit away from OGDPs, Rule 308 addresses Form 2s. Form 2s are applications for permit to drill, where the OGDP largely focuses on the surface permit through the Form 2A. The Form 2 focuses on the downhole, the well permit. A Form 2 is required, and for many years has been required in order to actually drill a well. So what we've proposed as a revision is that the Form 2 may be submitted to staff or through our web forms or e-forms systems once the director has recommended approval of an OGDP. Currently, operators have to wait until after the OGDP is approved by commission vote and the Form 2A is approved administratively by staff in order to issue a location ID number. This rule proposes to speed up the permitting process timeline a little bit by allowing operators to submit their Form 2s once the director's recommendation of approval has been issued. I want to note that staff can still return those Form 2s to draft for corrections at any point in that review process. Form 2s may also be submitted if a Form 2A and necessary spacing have been approved. This is particularly critical for built locations. We're proposing that for an operator to submit a Form 2 where a location is already built, that location must be in compliance with Rule 1003, which is interim reclamation. This would ensure that operators are in compliance with interim reclamation in cases where drilling rig occupations are happening significantly later than pad construction or prior rig occupation. In some cases, we have locations that are built, wells are spud or drilled, and then a year or multiple years passes before the operator is ready to come back and drill the remaining wells on that pad. We want to make sure that the operator is complying with interim reclamation requirements during that time period. Additional revisions to Rule 308 clarify when a Form 2 is required prior to operations, and also requiring a new notice to the relevant and proximate local governments when a Form 2 is submitted that is not subject to an OGDP. The emphasis here is that when an OGDP is submitted, the relevant and proximate local governments do get notice of that, so they'll know that there would be subsequent Form 2s coming shortly. We want our local governments to be informed when Form 2s are submitted outside the OGDP process. Next slide, please. We've also revised Rule 308 to basically formalize a process we've been using for quite a few years now, which is that the director may require a Form 4, a sundry notice, for the location where those wells are intended. This Form 4 sundry notice gives staff and the operator an opportunity to review the location itself, to review existing best management practices or BMPs, and a chance to add new or upgrade existing BMPs for that location that are related to future drilling and completions. The director may also require a cumulative impacts analysis. This is particularly important if the location was approved or built prior to mission change or prior to January 15th, 2021. In those cases, there was no cumulative impacts analysis or Form 2B done on that location. This gives the director a chance where it's needed, not particularly every time, but where it's needed, gives the director a chance to review cumulative impacts information. If the Form 2A has been acted upon, but the original expiration date has expired, this might be another opportunity for the director to require that CI analysis. The analysis might be required if the land use around the existing location has changed since the location was last reviewed. That could be where there's a new subdivision that has encroached upon the location, or the location, the block group where the census block group where the location exists is now recognized as a disproportionately impacted community. Another new part to this rule is that the director may refer a Form 2 to the commission for review, and the commission may initiate proceedings to review a Form 2 independently through a commission process. Next slide, please. Rule 309 has been the formal consultation process for quite a few years. To alleviate some confusion about it, we've changed the name to post-completeness consultation so that it is differentiated from the pre-application consultation. So we've clarified in Rule 309 that these consultations will take place after the permit application passes completeness. This would now require a community meeting for locations that are proposed within 2,000 feet of homes where those homes are in a disproportionately impacted community. Where those meetings are required, the community liaison will work with the operator to provide input on meeting logistics, including providing input to the operator on facilitating coordination of childcare, transportation, and interpretive or translational services as necessary. The operator will provide enhanced contact information to all the participants, not only contact information about the operator, but for ECMC as well. And this is where, if the attendees, folks that attend these community meetings, if they desire, they can provide their email address to the operator. And if they do, they will receive additional notice, such as the notice of director's recommendation. After the community meeting, the operator will provide the director with a detailed summary of the meeting within 10 days. Next slide, please. This post-completeness consultation will include a consultation with CDPHE. This would be required for locations that are within 2,000 feet of any home, for locations that are proposed within a CI community, regardless of proximity to residential building units, and for locations that are within the ozone non-attainment area where the operator is proposing pre-production operations to take place during the ozone season between May 1st and September 30th. Couple of staff notes here. We'd like to remove some duplication that we've found in Rule 309 F1A Romanet 4, 3 and 4, where there's a little bit of duplication of language. So we'd like to clean that up a little bit. And then there's, since mission change, there's been in our 300 series rules, some use of the term oil and gas location and some use of the term working pad surface. This probably extends beyond the 300 series and into the other series that are not under consideration in this rulemaking. But just for a future note for commissioners, it might be a good idea to conduct a rulemaking to bring some consistency across the entire rule series, suite of rule series, to generate consistency between either the use of oil and gas location when describing information or working pad surface. There are some significant differences between those two definitions. Next slide, please. We amended Rule 312, subsequent operations on existing wells. The director may require a cumulative impact analysis and or of Form 2B for this location. These are built existing locations where wells are already at least spud. They may not be drilled to total depth, and they may not be completed. So examples of when the director may require such an analysis or a Form 2B is when a long period of time has elapsed since the previous well operations with heavy equipment occurred, or where land use may have significantly changed since the Form 2A was approved. In particular, if the location was approved or built prior to mission change, no cumulative impact analysis has been undertaken. So the director may wish to seek cumulative impact analyses or a Form 2B for that location. Next slide, please. Getting into Rule 314, this is the rule that guides comprehensive area plans, or CAP applications. 314B relieves a CAP applicant from having to submit a Form 2B with its subsequent CAP OGDPs. Staff revised this rule to encourage applicants to voluntarily submit a Form 2B with their OGDPs. Based on at least one party's response statement and additional review by staff, both the current and proposed Rule 314B3 suggest that the relief granted for the OGDP application is only relief from the Form 2B. This could be interpreted to indicate that a cumulative impact analysis is still required with the OGDP application. Staff agrees that proposed new operations do require a cumulative impacts analysis, as well as an incremental impact analysis, whether it occurs at the CAP level or the location level. We ask that the Commission consider this as you deliberate on any changes you might propose. Rule 314D will require a pre-application consultation similar to that proposed for OGDPs. This procedure would require, or would follow the same process as outlined in Rule 301G. CAP maps will include existing and proposed utility lines, including electrical transmission lines and substations. And CAP information will also include clarity on the timing of operations. This is important so that the Commission can understand when pre-production operations might be proposed in the non-attainment area. If they're proposed between May 1st and September 30th, that should be clearly discussed in the application. Next slide, please. So one of the big changes to Rule 314 is 314E10, evaluating and addressing cumulative impacts. The current rule requires a suite of information around cumulative impacts for a CAP application. That information currently comes in, sorry, I have an intern here that I need to move. That information currently comes in through the e-filings system, which is sort of where the legal documents, the legalese is filed. That information does not currently come into the COGIS database or the CIDR database at all. So staff is proposing a new electronic form, the Form 2F, which is CAP Cumulative Impacts and Data Identification. This is basically the CAP version of the Form 2B that is required with an OGDP application. Staff took the data that is already required in Rule 314E10 and revised that language to enable staff and the applicant to provide that information in data fields in an electronic form rather than in a narrative statement through the e-filing system. This data will include impacts that are anticipated from access roads, flow lines and pipelines, utility corridors, location, construction, drilling and completions operations, and production operations. Next slide, please. We've expanded air resources and impacts to climate to include particulate matter. We've expanded or clarified water resources to include tank storage volume for all proposed locations, regardless of any sort of sensitive area for water resources designation or proximity to waters of the state. We've also revised language around terrestrial and aquatic wildlife resources in order for that information to comport with the new Form 2F data fields. Next slide. Biological, ecosystem, and soil resources have been combined. This is where we're bringing in the statutory requirement to review biological resources. Again, we've revised the language such that it will comport with the new data fields on the Form 2F. We also incorporate by reference Colorado Parks and Wildlife 2015 State Wildlife Action Plan, or SWAP, for the identification of potentially impacted habitats. There's also a new requirement for the applicant to identify wells that would be plugged, locations that would be closed, acres of land of surface to be reclaimed, and tanks and facilities to be decommissioned. I do want to note that CPW does intend to release an updated SWAP in 2015, and staff recommends that the commission again conduct a future rulemaking to incorporate the 2025 SWAP reference into the 300 series rule when that reference is available. Next slide, please. We've revised 314E10G, which is disproportionately and cumulatively impacted communities. The new requirement will include a narrative that describes past, present, and reasonably foreseeable adverse impacts that are within a DI community, which includes CI communities, or within 2,000 feet of a DI community based on the operations proposed at the location, the access roads, flow lines, pipelines, or utility corridors. Also requires a description of how the operator intends to avoid, minimize, and mitigate those impacts. A new addition to Rule 314, again, is the NOx intensity target. This is for CAPs that are within the ozone non-attainment area. Subsidiary operators will demonstrate their NOx intensity target based on the parent company's target, and we'll get a little bit more in depth into that shortly. The CAP application would require a statement of NOx intensity target status based on the operator's most recent Reg 7 annual and interim report. And then for operators not subject to a target, a statement of compliance with enhanced systems and practices would be required. Next slide. Another new addition is the greenhouse gas intensity target. And let me just remind that both of these NOx intensity and greenhouse gas intensity targets stem from AQCC rule, Reg 7. Subsidiary operators will demonstrate, again, their greenhouse gas intensity target based on the parent company's target. The application would require the operator to provide their greenhouse gas intensity target status based on their most recent Reg 7 annual report. And for new to market operators, a statement indicating that that they are new to market operators and might not have a target yet. The public review process for CAPs has been revised. It would now require a notice of the director's completeness determination to all homes within 2,000 feet of proposed CAP locations, and would require notice of completeness determination to all homes that are within a DI community that are within 1 mile of the proposed CAP location. I do want to note, and I apologize, I don't have a staff note here, and I should have added one, that this could be potentially problematic for CAP applications where the locations proposed are not seeking preliminary siting approval. Our Rule 314 does allow operators to submit CAPs where the locations are not specifically defined. The siting of the location is not specifically defined. So in those cases, this rule context here would probably need some work to make it applicable to locations that don't have a specific siting as of yet. Next slide, please. Public comments for CAP applications. This rule clarifies that the director will consider those public comments received within the formal public comment period, which is 60 days from the date the CAP is posted on ECMC's website after passing completeness. We recognize that some public commenters prefer to submit written public comments into the e-filing system. outside the formal public comment period, the commission will still accept those comments and will consider those comments received after the 60-day public comment period closes. But in order for the director to make her recommendation, she has to make a recommendation in a certain time frame. And so public comments that come in after that 60-day public comment period would not be considered as part of the director's recommendation. She can't just keep reading new public comments and revising her recommendation after the fact. So just a little bit of clarification on our system there. Public meetings for CAPS. The community liaison will provide input to the operator on meeting logistics, again, including the operator facilitating coordination of childcare, transportation, and interpretive and translational services as necessary. And similar to OGDPs, the operator will provide the operator's contact and commission information. The attendees, those folks who attend the public meeting, if they provide their email address at that meeting, they will be eligible to receive additional notice, such as notice of the director's recommendation. And the operator will provide the director a summary of the public meeting or any public meetings that are held for a CAP application. Next slide, please. So new Rule 315, this is a big one. There's two parts to Rule 315. 315A is where we've taken the Form 2B and CIDR, which is the Cumulative Impacts Data Evaluation Repository, where we've moved them from current Rule 303A5 into 315A. And then 315B is the new cumulative impacts analysis, which has come up through the legislative session this year. This cumulative impacts analysis is meant to be an attachment, so a PDF, either attached to a Form 2A in an OGDP or attached to a Form 4, where required under Rule 308 or 312 or other conditions. I just want to flag for the commission and all of our stakeholders today, the Form 2B for OGDPs captures the incremental impacts of the proposed oil and gas development plan, and that is what populates CIDR. CIDR then is used to aggregate OGDP impacts, those Form 2B data, year over year, so that the commission can see trends over long periods of time. The cumulative impact analysis is different from the Form 2B in that it captures the incremental and cumulative impacts of existing, current, and reasonably foreseeable future impacts from sources in the impact area and how the proposed OGDP will affect the cumulative impacts. So a little bit of a distinction. The Form 2B is incremental impacts that would result from the OGDP, and the cumulative impacts analysis is sort of that bigger picture look at other sources of impacts at all the receptors in the impact area. Next slide, please. So Rule 315A is the Form 2B. Again, we've included impacts to climate, which is a new requirement from House Bill 1346. Impacts to climate are included in the Form 2B's air resources section, and biological resources are included in the Form 2B's soil resources section. This will use the impact area, unless otherwise noted, as a radius to examine impacts. We're also revising the Form 2B to better capture beneficial impacts. This section will now include details of wells that the operator proposes to be plugged and locations proposed to be closed and reclaimed. By capturing the API numbers of wells to be plugged and the location ID numbers of locations to be claimed, we can better link this information to the Form 6, 6A, and 6B and other forms in the COGIS database. Those Form 6s are requests to plug wells. And so this provides a mechanism that staff can effectively track the plugging of wells and reclamation work, which also then would provide updated documentation for an operator to revise their financial assurance as they are plugging those wells and closing those locations. In addition, the Form 2B will now accommodate NOx and greenhouse gas intensity target status. Next slide, please. Rule 315B, the cumulative impacts analysis. This would be required for every proposed new or amended location in an OGDP. And as we mentioned earlier, it will be required for Form 2s upon the director's request in Rule 308 or Rule 312. The director may also require a CI analysis for other reasons, particularly for heavy-duty operations that are occurring on existing locations where those locations were approved or built prior to mission change. Next slide, please. The impact area. This is a big topic of discussion. I think we'll hear a lot about this week. Staff is proposing that the impact area starts as a 1 mile radius from the working pad surface of a proposed location. This would be the smallest impact area, sort of establishing the minimum review. This impact area can be expanded due to the nature, intensity, and scope of operations that are being proposed and potential impacts. The impact area is intended to be determined through cooperative discussion between the operator, the director, local governments, and other parties participating at the Rule 301 F or G pre-application consultation. Certainly that would include input from CDPHE and CPW and others as well. We ask that the commission defers to the director's determination of the impact area in order to minimize the risk of the impact area needing to be changed very late in the process. The commission may only overturn the director's determination of the appropriate impact area if the record demonstrates that the determination was clearly erroneous. Next slide, please. The contents of a CI analysis would include high-resolution aerial images showing the proposed location and the impact area. This would also delineate potential impact sources and receptors within the impact area. So identification of both DI and CI communities, residential building units, high occupancy building units, schools and childcare centers, high priority habitats, surface water bodies, public water system intakes, local government jurisdictions and land use zoning, existing and approved oil and gas facilities, existing or approved industrial facilities, major transportation and rail corridors, and other significant sources of potential adverse impacts. Next slide. The contents of the CI analysis would also include a narrative description of other past, present, and reasonably foreseeable future development, as well as measures to avoid, minimize, or mitigate adverse cumulative impacts. The analysis would also include a narrative evaluation of both incremental and cumulative impacts, specifically on those categories listed in statute: air quality, water quality, climate, noise, odor, wildlife, biological and soil resources, which for the sake of consistency, staff is asking includes CPW's 2015 and eventually 2025 SWAP habitat data. I want to flag that we're asking for a lot of best management practices, having the applicant provide what are your mitigation measures. This creates an issue, and there is an ongoing issue already in the 300 series, whereby the rules are seeking lists of BMPs across many different components in the OGDP application. Staff recognizes this is difficult to review. It's frustrating for operators to have to repeat themselves in plans and attachments, and now the cumulative impacts analysis. And so staff fully intends to issue a guidance document as soon as possible to provide a streamlined mechanism for operators to list their BMPs in a single location in the OGDP application. So minimizing a smattering of BMPs across plans, attachments, and the CI analysis. we're going to ask for or intend to do a guidance document whereby all the BMPs can be found in a single document, a single master list that would be included in the OGDP application. I think that that will provide some efficiencies for operators, efficiencies certainly for staff and for commission, and efficiencies for stakeholders that are reviewing applications. Next slide, please. The commission's review of the CI analysis, we would ask that the commission considers how well the operator's analysis demonstrates avoidance and minimization of adverse impacts, effective mitigation of those adverse impacts that cannot be avoided or minimized, considers any beneficial impacts identified, considers the operator's engagement with nearby residents, public comments, and the operator's response to those public comments, potential alternative locations that might better avoid or minimize adverse impacts, certainly the relevant local government's local permit disposition, and any results of consultations with other entities such as CPW and CDPHE, as well as the operator's record of compliance with the Act and Commission rules. There is one staff note here. We did discover we missed a little bit of a step in Rule 308 and 312. We proposed language whereby the director can review the cumulative impacts analysis pursuant to Rule 308 and through 312. We would still intend that the director and not the commission would be involved in that administrative approval under 308 and 312. We did not clarify that in Rule 315. So we would ask for a chance to clarify revising Rule 315B to allow the director, not the commission, to review the CI analysis in cases where it may be administratively approved with a Form 2. Next slide, please. The next big new rule, oil and gas operations in the ozone non-attainment area. I want to just remind folks that Rule 316 is specific to operations in the ozone non-attainment area. This does not apply to operations outside the non-attainment area. So as we walk through this rule, keep in mind, it's only in the non-attainment area. There are 4 parts to this new Rule 316. 316A is the consideration of an operator's NOx intensity target status for OGDP applications that are proposing pre-production operations between May 1st and September 30th, which is sort of colloquially known as ozone season. 316B is for an operator requesting approval to conduct pre-production operations in the coming ozone season where they already have a permit approved. This introduces our new Form 2D, which we'll get into. Rule 316C is enhanced systems and practices, which is the new component from recent statute. And then 316D, also part of the new statute, actions to reduce NOx emissions. Next slide, please. Rule 316A provides a mechanism for operators to gain commission approval through the OGDP process to conduct pre-production operations between May 1st and September 30th. Only pre-production operations are considered here because drilling and completions operations generally produce higher NOx emissions than production operations and are thus a key contributor to an operator's overall NOx intensity status. By ensuring pre-production operations are meted out through careful and thoroughly considered commission approvals, the commission is ensuring that individual operators are staying on track to meet their required NOx reduction targets as designated and enforced by the APCD. Commission approval is based on the operator's certification on the Form 2B that they have not exceeded their NOx intensity target as demonstrated in their most recent annual and interim reports submitted to the AQCC. Operators who are a subsidiary of a parent company will demonstrate their NOx intensity target based on the parent company's target. Staff took this rule language directly from AQCC's Reg 7 for consistency of application between the two agencies. For operators who are not subject to a NOx intensity target, but who wish to conduct pre-production operations between May 1st and September 30th, the Form 2B will include the operator's statement of compliance with enhanced systems and practices, as well as a list of additional practices to further reduce NOx emissions. For any operator seeking approval to conduct pre-production operations between May 1 and September 30, the operator must indicate on the Form 2B the year those pre-production operations will occur. This information must also match any operational timeline indicated on the associated Form 2A. An operator may intentionally plan to avoid pre-production operations between May 1st and September 30th. The Form 2B may be submitted without NOx intensity information. In this case, conditions of approval will be added to the OGDP, limiting pre-production operations to October 1st through April 30th. And last, if an operator submits corrected information to CDPHE, it must also submit that same correction to ECMC within 10 days. Next slide, please. Draft Rule 316A4 considers or describes the director's recommendation to the commission on whether or not to approve pre-production operations between May 1 and September 30. This is not to be confused with the director's recommendation to the commission on whether or not to approve the entire OGDP. It is merely a component of that overall OGDP recommendation. If the operator has not exceeded their NOx intensity target as certified by the operator on their Form 2B, based on their most recent annual and interim reports, the director may recommend approval of pre-production operations during ozone season. If the operator's annual and interim reports conflict with each other, where one indicates the operator has not exceeded the target and the other indicates the operator has exceeded their target, the director will initiate a consultation with CDPHE and the operator. This consultation will help the director understand why the discrepancy exists. Perhaps the operator recently upgraded to an electric drill rig and anticipates their future drilling emissions will be well below the allowable NOx target going forward. This discussion will enable the director to make a sound decision about whether or not to allow the operator to conduct pre-production activities during the ozone season, or if conditions of approval are necessary to limit these activities to outside the ozone season. If both the operator's annual and interim report indicate they have exceeded their NOx target, the director will recommend denial of pre-production operations during the May 1 through September 30th ozone season. Through a COA, this timing limitation will be included in the director's overall recommendations to the commission on the OGDP application. There will likely be a special group of OGDP applications that won't have the benefit of both the annual and the interim report. This is just by the nature of timing of this rulemaking. Those are any OGDPs submitted between the effective date of these rules, roughly November 30th of this year, and August 1st of 2025. This is due to the timing of the effective date of AQCC's Reg 7 rules governing NOx intensity and the reporting of 2024 data. 2024 is the first year that Reg 7 NOx intensity targets are required. However, operators do not submit their 2024 reporting to the AQCC until June of 2025. So the annual report will not be available until sometime after the June 30th AQCC deadline. Any OGDP applications that fall into this category will only have their annual report, their interim report. So their NOx intensity target determination will be made solely based on their November 2024 interim report and not the annual report. Next slide, please. The Commission's consideration of the operator's NOx intensity target status. The Commission may approve pre-production operations only if the director recommends approval of pre-production operations. COAs may also apply. The Commission may conditionally approve with timing limitations or deny pre-production operations if the operator has exceeded its NOx intensity target. I want to just make another note that the commission's decision regarding pre-production operations between May 1st and September 30th is only one component of its decision on the OGDP application as a whole. Next slide, please. We are proposing in Rule 316B a new form, another new electronic web form or e-form called the Form 2D Emissions Intensity Assessment. We should have probably called this a NOx intensity assessment because it will focus on NOx intensity rather than greenhouse gas. This is for operators who request to conduct pre-production operations in the upcoming ozone season where they already have approved permits, whether those are OGDPs, Form 2As or Form 2s. This is required, director's approval of the Form 2D is required prior to conducting those operations in the upcoming ozone season. This would begin in 2025, since the first NOx intensity data will not be available to us until after the November 2024 interim report. The Form 2D would be due by February 15th of each year for operations in the upcoming ozone season. And again, subsidiary operators will demonstrate their NOx intensity target based on their parent company's overall target. Next slide, please. So the Form 2D will include data that illustrates the NOx intensity target based on the most recent Reg 7 annual and interim report, with the exception that I just noticed about this year. This information will essentially be the operator's declaration, certification that they've exceeded or they've not exceeded their target. For operators who are not subject to a target, they will provide a certifying statement indicating that there is no target required. The Form 2D will include a list of all permitted pre-production operations that are proposed to occur in the upcoming ozone season. This list would include operations that are approved prior to Rule 316, so operations that have not had a NOx review at all, and operations that were approved through Rules 316 where they had a NOx review. A narrative description of the ESPs, the enhanced systems and practices that the operator is committed to using, as well as a narrative description of the operator's ability to conduct their proposed pre-production operations and not exceed its NOx intensity target will be required on this form. We have a staff note also that we realized the language that we put in draft Rule 316 B2B, we need to clarify a little bit to ensure that it's only operations permitted without a Rule 316 A determination. We've got just a little bit of minor wordsmithing to do there to make it clearer what our intentions actually are. Next slide, please. The director will review the Form 2D, not the commission. The director may approve the Form 2D if the operator has demonstrated that it did not exceed its NOx target for the prior year. So this is a backwards-looking review. If the annual and interim reports are contradictory to one another, the director will initiate a consultation similar to the OGDP process, whereby the director may approve with conditions or deny the Form 2D based on the information identified in the consultation. The director will deny the Form 2B if the operator's annual and interim reports both indicate the operator exceeded its NOx target in the prior year. I want to make sure that industry sees that the operator has the right for a hearing before the commission if an operator disagrees with the director's denial of the Form 2D. Next slide, please. Changes to an approved Form 2D, staff recognizes that during the drilling season, changes can crop up due to vendor availability. We saw during the coronavirus, there was supply and demand issues. We recognize things can happen on the fly that are unanticipated. So we added a provision that an operator can request changes to an approved Form 2D through submitting a new Form 2D. If their Form 2D is associated with OGDPs that were approved, they may need to also submit a Form 4 pursuant to Rule 301C, which is changes to an approved OGDP. The replacement Form 2D that are submitted after March 15th will only be approved if the changes that are being requested result in no net gain of NOx emissions. This would be recognized through improved ESPs, enhanced systems and practices, or a reduction in operations, or an equal substitution of authorized locations or wells. So this would be a case where an operator has previously said they want to drill these 10 wells on this pad, and now they say, wait, we're not going to be able to do that. We want to do these 10 wells on this pad. So that's sort of an apples to apples substitution. We also have a provision that by April 15th of each year, starting in 2025, the director will provide to the commission a report of pre-production operations that are authorized for the upcoming ozone season. Next slide, please. 316C, this is enhanced systems and practices. This comes straight from Senate Bill 24-229. Whereby we are required to adopt an initial list of ESPs as recommended by CDPHE by the end of this month. That's why we've incorporated this into this rulemaking. We will also intend to periodically update the list of ESPs, again, in consultation with CDPHE, and administer ESPs to minimize adverse impacts to disproportionately impacted communities. This applies to all oil and gas operations for which a Form 2A is submitted on or after January 1st of 2025. Another staff note, we'd like to recommend some cleanup language for Rule 316C1 that refers to Rule 304A1, specifically that this does not apply to existing locations, but new locations only. Next slide, please. The ESPs, similar to BMPs, will be listed on the Form 2A. They will be required, there's a couple of different buckets, if you will, of ESPs. There will be ESPs required year-round at all locations. There will be ESPs required year-round in DI communities, and only between May 1st and September 30th at non-DI community locations, and certain ESPs required during the ozone season in DI communities, and encouraged rather than required during ozone season at non-DI community locations. ESPs that are not used under that previous bullet, whereby the ESPs are encouraged but not required, the operator will provide a discussion as to why they were not able to commit to those ESPs, or how implementing those ESPs would cause adverse impacts to public health, safety, welfare, the environment, or wildlife resources. So for example, if one of the ESPs is to electrify the entire production facility, and the operator can't commit to that because they can't get highline power there, they'll provide to us a discussion of how they tried to get highline power or other sources of electrification for that production facility, but were unable. Next slide, please. The last part of new Rule 316 is actions to reduce NOx emissions. Again, this is taken directly from Senate Bill 24-229. This includes actions in the ozone season to reduce emissions generated from both pre-production and production operations, to ensure compliance with NOx intensity targets and other NOx rules that the AQCC will adopt by rule to achieve sector-wide compliance with the state's 2030 goals for NOx emission reductions. We will also be prioritizing actions by those operators who do not demonstrate compliance with their NOx intensity target. Next slide. So if the Form 2D indicates that an operator has exceeded its NOx intensity target, the director will initiate consultation with CDP and the operator. Consultation period will be 60 days. However, if CDPHE requests an extension, the director may extend that consultation period. The consultation will focus on the measures that the operator can implement to further reduce their NOx emissions and try to come into compliance with their intensity target. The actions that the director may ask or may require of the operator could include additional ESPs, could include shutting in of one or more existing wells, could include plugging and abandoning of one or more wells, or other actions as necessary and through consultation with CDPHE. Next slide. Okay, we've gotten through the 300 series. I apologize, I'm going longer than intended. Rule 803, we have one very small update. It's just a rule reference to the Form 2B, nothing substantive. Next slide, please. Rule 904, we are proposing to change the due date for the director's annual report on cumulative impacts from January 15th to May 15th. We have struggled in the past few years to get all of the data from the previous year concluded and analyzed in a report written in 15 days. And so we think that extending that due date to May 15th is reasonable. We also have a rule reference updating for cider in the move from 303A5 to 315A. And we are including AQCC's NOx and greenhouse gas intensity target information in the director's annual report. Next slide, please. We're amending Rule 1201 only to update a rule reference for the ALA now that the ALA is required for every proposed location. Next slide, please. I wanted to take a moment to walk through some of the new protections that the August 2nd draft outlines for disproportionately impacted communities. Keep in mind that cumulatively impacted communities are disproportionately impacted communities as established through one of the provisions in statute whereby a state agency can identify a subset of census block groups that are disproportionately impacted. In this case, CDPHE, AQCC designated a certain subset of block groups as cumulatively impacted where they have an EnviroScreen score above 80. So we've expanded notifications. This is actually to all homes within 2,000 feet of a proposed new location. They will receive notification, pre-application notice for both OGDPs and CAP, as well as notice of the director's recommendation for both OGDPs and CAP. Those residents within a DI community within 1 mile of a proposed location in a CAP will receive the CAP completeness notice as well. Current rule 303 already does require OGDP completeness notice to all RBUs within 2,000 feet, so we're not changing that. We have new consultations and meetings. Again, this applies to all homes within 2,000 feet of a proposed location. There is the new OGDP and CAP pre-application consultation and post-completeness community meeting for all RBUs within 2,000 feet, and specifically for locations that are within CICs. Next slide. We have the new community liaison. This person or these people will attend pre-application consultations for both OGDPs and CAPs. They will attend post-completeness community meetings for OGDPs and CAPs. They will help recommend to the operator meeting logistics, including locations, venues, dates, time, childcare, transportation, translation and interpretive services, and other actions or services that are necessary for members of disproportionately impacted communities to be able to participate in these consultations and meetings. They will also provide assistance to community members in accessing public comment opportunities, both written and oral, for OGDP applications, CAP applications, and other matters being heard by the Commission. We have a new longer public comment period. It would be 60 days for public comments, up from 30 or 45 days, depending on the specifics of the proposal. This provides more time for community members to work with the community liaison on how to review applications and submit appropriate comments. Next slide, please. We have new information required in OGDPs. The disproportionately impacted community maps will now require distance to RBUs and the number of RBUs within 2,000 feet and going out to 1 mile. This helps the director and the commission understand the spatial relationships between the proposed operations and where people's homes are. The community outreach plan will also now require both pre-production and production information and long-term engagement with DI community members. This recognizes that the operator's engagement should not stop once the wells are in production. We're asking them to keep, asking you, commissioners, to keep the operators accountable to and communicating with their neighbors over the lifetime of an oil and gas location. New required information in the Form 2B and with the cumulative impacts analysis. This is going to require the proposed number of wells to be plugged, tanks to be decommissioned, locations to be closed in a disproportionately impacted community, if any are proposed for that. This demonstrates specific and tangible beneficial impacts within the DIC. Next slide, please. There's new information required in CAP applications specific for disproportionately impacted communities, including a list of known adverse impacts to those communities. This provides the opportunity for community members to illuminate additional impacts that should be identified and analyzed. So where an operator or an applicant with a CAP application has identified what they think are the existing impacts, the DI community members can review that application, and if they have identified impacts that aren't noted, they would have an opportunity to bring that to daylight. The CAP application will also provide a summary of how the applicant intends to avoid, minimize, and mitigate new impacts to DI communities. This provides an opportunity for DI community members to engage the applicant for additional BMPs where they think that they are necessary. Next slide, please. We also have administrative protections for disproportionately impacted communities, including the in the lesser impact area exemption, the new prohibition for those exemptions to occur when in cumulatively impacted communities or for locations that are within 2,000 feet of homes in DI communities. This ensures that the full suite of required information is included in those OGDP applications. Additionally, the director can require a CI analysis for a Form 2 if the area has been newly designated as a DI community since the Form 2A was last approved. This ensures that the Form 2 is reviewed with current and recent demographic, socioeconomic, and cumulative impact conditions. Next slide. And last, we have new environmental protections required in disproportionately impacted communities. We have ESPs, enhanced systems and practices, that will be required year-round in DI communities, including things such as a LACT system, which reduces the manual intervention during unloading and risk of human error. The requirement for Group 3 or equivalent low aromatic drilling fluids to reduce odors and emissions. Squeegee or equivalent to remove drilling fluids from pipes that are exiting the wellbore in order to reduce odors, and ozone mitigation requirements on high ozone days. We have ESPs required during ozone season now in DI communities. Some of those include no hydrocarbon or produced water storage tanks, non-fossil fuel power for all permanent electrical production equipment, committed oil pipeline takeaway, and frac water being transported to the location via hose or lay flat pipe rather than through truck trips. Next slide, please. I'm going to stop talking and turn the next few slides over to our wonderful senior AAG, Caitlin Stafford, to take over.
Thank you, Ms. Trask, and good afternoon, commissioners. For the record, I am Senior Assistant Attorney General Caitlin Stafford, and along with my colleague, Assistant Attorney General Lauren Mercer, we represent ECMC staff in this rulemaking. We've prepared a few slides to discuss staff's position on certain legal issues that have been raised over the course of this rulemaking. Our slides deal with the requirements of the Act, agency authority, the requirements as proposed in new Rule 316D, and the definition of impact area. So I see my slide is up here, so I will just roll into it. So this slide sets forth the requirements of the Oil and Gas Conservation Act as updated this past legislative session. As part of this process, it's important to step back and review the statutory provisions under which ECMC takes its direction in this rulemaking. Now, the first provision you'll recognize from Senate Bill 19-181, which directs the Commission to regulate in a reasonable manner to protect and minimize adverse impacts to public health, safety, and welfare, the environment, and wildlife resources. The next provision comes from Senate Bill 24-229, requiring the ECMC to require enhanced systems and practices to avoid, minimize, and mitigate emissions of ozone precursors from newly permitted oil and gas locations in the ozone non-attainment area. The third provision listed requires the Commission to adopt rules that evaluate and address the cumulative impacts of oil and gas operations, and this is from House Bill 24-1346. As originally set forth in House Bill 23-1294, ECMC must provide resources to support community engagement in the permitting process from affected communities. And finally, on this slide, we have the statutory directive to ECMC to administer the act to minimize adverse impacts to disproportionately impacted communities that are negatively affected by oil and gas operations. Now, read together, these provisions require that ECMC adopt reasonable regulations to 1, evaluate and address cumulative impacts, 2, require the use of enhanced systems and practices at new operations in the non-attainment area during ozone season, and 3, support increased engagement by affected communities and disproportionately impacted communities negatively affected by operations in the permitting process. Both drafts of the rules that staff has released specifically address these concepts. For example, Draft Rule 315 furthers the evaluation of and the ECMC's efforts to require operators to address the cumulative impacts of oil and gas operations. Like its predecessor, current Rule 303A5, proposed Rule 315A focuses on evaluating the information submitted by an operator. That data input into CITER as part of its Form 2B, or now 2F under a cap, will be considered as part of the Commission's permitting process. The same thing goes for the cumulative impacts analysis required by Draft Rule 315B. This analysis will enhance ECMC's permitting process by ensuring operators are taking the steps necessary to avoid, minimize, and mitigate impacts to public health, safety, welfare, the environment, and wildlife resources as part of their proposed operations. The draft rules also require significant consultation with CDPHE, proposed enhanced systems and practices for operators to utilize at new locations in the non-attainment area, and as Ms. trask detailed just before I began speaking, incorporate numerous provisions, including Rule 224's community liaison and heightened informational and notice requirements to ensure those in affected and disproportionately impacted communities are afforded the opportunity to participate in ECMC's permitting processes. Next slide, please. In this slide, I'd like to briefly touch on agency authority, and I will focus on proposed Rule 316, which concerns requirements for oil and gas operations in the ozone non-attainment area. Rule 316 is best understood in the context of its relationship with regulations promulgated by CDPHE and specifically the Air Quality Control Commission. Staff has collaborated closely with the Air Pollution Control Division in the course of developing this proposed rule. Draft Rule 316 is intended to complement rather than duplicate the CDPHE's NOx intensity target rules adopted by the AQCC, which can be found in AQCC Regulation Number 7. This reflects that both AQCC and ECMC have legal authority in this arena. As we have previously stated in past rulemakings, both ECMC and CDPHE have authority to regulate oil and gas operations. This is specifically set forth in the Act at Section 3460-105, subsection 1B, which clarifies that delegating authority to ECMC to regulate oil and gas operations does not negate the authority of CDPHE to also regulate those operations. Legally, there's no prohibition on two state agencies regulating the same activity. Unlike the relationship between different levels of government, There is no preemption between state agencies, and it is common for two state agencies to regulate the same activity. ECMC has broad authority to regulate oil and gas development to protect and minimize adverse impacts to public health and welfare and the environment, which includes regulating in a manner that avoids, minimizes, and mitigates adverse impacts to air quality. In Rule 316, staff has proposed to take into account an operator's NOx intensity status as part of ECMC's permitting processes. Staff has proposed this framework in the interest of efficiency and streamlining regulatory enforcement. I will not rehash the information you've already heard today about Rule 316, except to say that staff has carefully tailored this rule to harmonize with CDPHE's significant work to date in this space. Now, staff has focused its efforts in this rule on reducing ozone precursor emissions through the use of specific practices and equipment and relying on the expertise of CDPHE in setting emissions targets, just as Senate Bill 24-229 envisions. Recognizing the agency's dual authority, Senate Bill 24-229 fine-tuned the framework in which APCD and ECMC will continue to work together. This can be seen most explicitly in the language directing ECMC to require enhanced systems and practices and to require operators to take actions to reduce NOx emissions within requirements set by CDPHE. Next slide, please. Now I'd like to focus specifically on proposed draft Rule 316D and the procedural guardrails contained within. Section 104.5, subpart 2 of the Oil and Gas Conservation Act authorizes the director to administer the act, enforce the commission's rules, and implement the commission's orders. Colorado law grants all boards and commissions broad discretion to delegate their powers to their administrative staff, so long as there are reasonable constraints on that delegated authority. The Colorado Administrative Procedure Act governs the legal and procedural requirements agencies must follow when promulgating rules and conducting adjudicatory actions, like those contemplated in Rule 316D, subpart 3. The agency must give the operator notice and provide opportunity for the operator to be heard on the issue. Further, Colorado law requires that, in most cases, before an agency takes final action to revoke, suspend, limit, or modify a permit, the agency must give the operator holding the permit notice, provide a reasonable opportunity to comply with all lawful requirements, and allow the operator to submit written arguments. These requirements ensure an operator is provided due process. Proposed Rule 316D both adequately makes use of the director's discretion and provides important due process protections. This rule authorizes the director to take action against those operators who have exceeded their NOx intensity target. This rule goes on to specify when such action may occur and what the director may require the operator to do. Staff has also built in an appeal process whereby the commission can review any decision by the director pursuant to Rule 503G10, which is the rule that allows an affected party to request a commission hearing on any matter subject to the commission's jurisdiction. Notably, Rule 316D2 also provides for a consultation with CDPHE prior to the director taking action against an operator who has exceeded its NOx intensity target. These processes, taken together, ensure appropriate protections as required by law. Next slide, please. Now, I'd like to talk a little more about Rule 316D and specifically the topic of sector-wide compliance. Staff originally included language around this concept in its June draft rules, but removed it in the August draft largely after revisiting the language reproduced on this slide. The slide contains the statutory language upon which a sector-wide compliance process could be grounded. Senate Bill 24-229 provides that the commission will require operators to take actions appropriate to ensure compliance with NOx intensity targets and other NOx rules that the AQCC adopts by rule to achieve sector-wide compliance with the state's 2030 goals for NOx emission reductions. To date, the NOx intensity program includes targets for individual operators, which are designed to meet sector-wide goals. There is no sector-wide target in place, and the AQCC has not yet conducted a rulemaking to set such target. Thus, it would be inconsistent with the statutory language to enact a sector-wide compliance process prior to that rulemaking. What these statutory provisions do allow for currently is a process by which individual operators may be held accountable for exceeding their NOx intensity targets, which is what is now set out in proposed Rule 316D. Next slide, please. Finally, I'd like to turn to impact area, which is the term the legislature has defined in statute. Staff has proposed to reproduce such definition in the 100 series definitions. Here, though, I want to discuss how staff has proposed to determine the impact area as part of the proposed cumulative impacts analysis process, and how staff's proposal is a reasonable interpretation of and aligns with the definition. In Rule 315B2A, staff has proposed an impact area determination process for the cumulative impacts analysis that presumes a 1 mile impact area from the working pad surface. Such impact area may be expanded if reasonable and necessary due to the nature, intensity, and scope of the oil and gas operations and geographic extent of potential impacts. Therefore, impacts to resources will be analyzed at a minimum 1 mile radius, with director discretion to increase, but not decrease, the area based on the specifics of the surroundings and proposed operations. This process meets the 2 prongs of the definition, requiring that 1, the impact area be a defined geographic area, and 2, that the nature, intensity, and scope of the operations be taken into account, and the area expanded if the operations have potential to contribute to cumulative impacts in a larger area. The process to determine the impact area for purposes of the cumulative impacts analysis also has 2 important features to ensure informed decision-making and regulatory certainty. In Rule 315B2A(i), the director has discretion to expand the impact area based on a reasonable and necessary standard. Such determination must be based on the nature, intensity, and scope of the proposed operations. Taken together, these provisions provide reasonable constraints on the authority delegated to the director. Further, the director and her staff are in the best position to perform a thorough analysis to reach a determination of the impact area based on their expertise in location assessment, which has been enhanced in recent years via the current alternative location analysis process in which staff regularly engages. The process staff proposes here will help to ensure the impact area is known early on in the process so that operators can adequately prepare their cumulative impacts analysis in preparation for commission review. And now I will turn it back over to Ms. Trask to conclude the presentation.
Thank you, Ms. Stafford. Next slide, please. So next steps for staff, we do ask the commission for feedback on the August 2nd draft rules and the August 29th draft statement of basis and purpose. We specifically are asking for clarification on the following items, most of which hopefully I've flagged in the blue highlighted font throughout this presentation. We'd like to clean up some of the language and the order consistency in subparts throughout the 300 series that reference locations within a CI community or within 2,000 feet of an RBU and a DI community. Excuse me. We'd also like to expand the definition of enhanced systems and practices to include new operations only. We didn't make that clarification, and only that applies in the ozone non-attainment area. We'd like to provide some clarification on Rule 314B3. The rule as written is interpreted as exempting the operator from submitting the Form 2B with their subsequent OGDP application, but the language is currently unclear if the exemption includes the CI analysis as well. So we'd love commission feedback on that. Next slide, please. Also, as mentioned earlier, the revision of rule or cleanup of Rule 315B3 to allow the director to review and administratively approve a CI analysis per Rule 308 or 312. Those are in cases where the commission would not need to review. Clean up Rule 316B2B language to clarify that the operations permitted without a Rule 316A determination. The language in that rule is currently written to imply that it's permitted, that any permit, not just permit through the 316A rule. So a little bit of cleanup there. Also clean up Rule 316C1 language to clarify that it only applies to Form 2As submitted pursuant to Rule 304A1, which are 2As submitted for new locations only. This would not apply to amended locations. And then a very simple one, Rule 316D1A, we have the word that twice. That's a simple typographical correction. And then additional specific direction on additional or increased or enhanced or revised protections for disproportionately impacted communities. Of course, we're open to any other feedback or direction that you commissioners would like to share with us. Next slide, please. Thank you. I'd like to wrap up just by thanking a handful of folks. Certainly Caitlin Stafford and Lauren Mercer have been utterly invaluable to me over the last number of months. I want to thank Sarah Bartlett. She's been consulting with us from Potential Energy Consulting, particularly with air quality matters. A huge shout out to APCD staff, especially Tessa Sorensen, Jessica Furco, and Kate Fury for all of my frantic chats in Google Chat almost daily asking for clarification on Reg 7. I'd like to thank CPW staff, especially Dr. Karen Voltura, Brian McGee, and Taylor Elm. I'm hoping that one or all of them will be available later next week. Certainly a huge thank you to the parties in this rulemaking. We've been meeting with many of you for many, many months, and it's been enlightening and helpful and wonderful to work in a collaborative process with you. Thank you also to the hundreds of stakeholders and public commenters who've provided both written and oral public comments for well over a year and a half now. Special thanks to ECMC commissioners and former Commissioner Karen McGowan. And special thanks to ECMC staff, particularly Dita Osborne, Mike Wells, Stephen Schwartz, Megan Adamczyk, and our amazing hearings unit. So with that, commissioners, thank you for this opportunity, and we welcome your questions and comments.
Great. Thank you very much, Ms. Trask, and thank you, Ms. Stafford, for the amazing amount of work product that has gone into the 74 pages of slides and the 59 pages of rulemaking edits. We've got a lot of different diverse stakeholders who, have different viewpoints on the proposed drafts, but I don't think anyone can make a statement that our staff and our team and working with stakeholders that you've not done an amazing job of promulgating rules around cumulative impacts and disproportionately impacted communities and enhanced systems and practices. What I'd like to do is take a short break for lunch and then bring you guys back up if there are any questions from commissioners. Let's return, it's 12:36. Let's return at 1:10, a little more than 30 minutes, and then we'll be back for a Q&A session. All right, welcome back. This is the Colorado Energy Carbon and Management Commission. It is Tuesday, September 3rd. It's 1:10, and we're undertaking docket 2406-00145, the Cumulative Impacts and Enhanced Systems and Practices Rulemaking. Prior to our break, we heard from staff with an extensive review of the rules drafts that have been promulgated, and now we have an opportunity for commissioners to ask questions of staff. Does any commissioner have questions? Raise your hand. Commissioner Oath?
Yes, thank you. Ms. Trask, wonderful job in your presentation. Thank you very, very much for that. That was incredibly helpful. I do have a number of questions. Thanks for walking through a number of things with me here in advance. I tried to put some of them in the same kind of sequential order as you did, but ultimately had much less success than you did. So sorry for jumping around a little bit. So starting with 314, wanting to, and you covered it in a couple of different spots in your presentation, and I thought I had it, but I think then I got myself confused again. So want to talk through kind of what the August draft requires with respect to cumulative impacts analyses in caps, in OGDPs that are within caps, and then kind of the policy around that. So my understanding is there's the Form 2B or the Form 2F, depending on whether you're talking about an OGDP that has nothing to do with a cap, or a Form 2F for a cap, and that is about the incremental additions from the OGDP. And then there's the cumulative impacts analysis, which is about capturing the incremental and cumulative impacts of existing, current, reasonably foreseeable future impacts from sources in the impact area, and how it will affect cumulative impacts and measures to avoid, minimize, and mitigate adverse cumulative impacts. Okay, so can you tell me again, is in the August draft, is a cumulative impacts analysis, it is required for an OGDP that has nothing to do with a cap. Is it required for an OGDP that was part of a cap?
Thank you for the question, Commissioner. It's a little bit confusing, and this is one of the things that I would ask for clarification or direction from the commission on. So in the 300 series for OGDPs, whether let's just start with OGDPs not subject to a cap. A Form 2B is required, and a CI analysis is required for each. The Form 2B for the OGDP and a CI analysis for each location that is part of an OGDP application. In Rule 314 for caps, the Form 2F, the new proposed Form 2F, would be required for every cap application to identify those incremental impacts that would occur from the development of the cap as proposed. The language in 314 E10, which is where the Form 2F lives, I'm not sure that it adequately provides a cumulative impact analysis. I think it starts to, but I think it really primarily provides for the incremental impacts of the cap rather than a holistic view of what some of our stakeholders might consider a baseline, whereby in a cap, if it's 50 square miles, we would need to evaluate everything, all past and current and future impacts within that 50 square mile radius. And so staff intentionally didn't really develop a cumulative impact analysis process for a cap application piece. So that's kind of a missing part or a gray area. The other piece I want to try to clarify is that in Draft Rule 314 B3 under rights conveyed, an OGDP that is subject to a cap would not have a Form 2B submitted with it, but it would have a cumulative impact analysis submitted with it. So with the proposed rule changes to 314 for cap applications, we're seeking the incremental impacts through the Form 2F. We're not seeking a robust cumulative impact analysis with the cap, because the intention is that we'll get that cumulative impact analysis for every location in the subsequent OGDPs.
Okay, that is very helpful. So why not require a Form 2B for OGDPs that are part of a cap, given how much more information we have at that stage in the process?
That's what we proposed in the June draft. We basically removed under the 314B3 the rights conveyed. Current rule 314B gives the grants the operator relief from doing the Form 2B with their subsequent OGDP. And that's what we included in the June draft. Industry was concerned in their, at least we heard in their pre-hearing statements, they were concerned that we were getting cumulative or incremental impact information at the cap, which we were in 314E10, but that we were also getting it for each location in the OGDP, and they felt that that was redundant. In some cases it was, because a lot of the information required in the cap literally is the same information required at the Form 2B, just on a different scale. And so in the August version, we opted to remove the language that we had proposed in the June version. And then in order to better obtain cap incremental data, that's why in the August version, we've proposed a Form 2F, which is sort of the equivalent of the Form 2B.
Okay.
If I may add just one point there, for the record, Assistant Attorney General Lauren Mercer-Gelman. Another reason for the change of taking, putting back in the provision that a Form 2B would not be necessary for OGDPs under a cap was based on feedback that is a powerful incentive in our current rules for caps. And the feeling that by removing that, we were removing an incentive for operators to apply for caps. And this commission in the past has expressed a pretty strong preference for that landscape level planning that caps provide. So we wanted to make sure we weren't interfering with that.
Thank you. Okay. Appreciate that. Okay. Shifting to 315. Next, so I'm going to start with the impact area. So could you talk about how you came to propose the default of 1 mile?
Yes, I can try. And I will definitely ask for help from Ms. Stafford and Ms. Mercer-Gelman here. Staff took the approach that our current rules have a lot of rule-based requirements around a 2,000-foot radius from a proposed location. We have that throughout the 300 series for multiple different rules. We first thought, let's look at 2,000 feet because that's what we've been largely using over the last, 5-ish years since mission change. But as we were contemplating a 2,000-foot impact area, we just recognized that there are so many impacts that could occur and receptors that could be impacted beyond a 2,000-foot impact area. So we talked about, should it be a half mile, a mile, 3 miles, 5 miles? Should it be the entire non-attainment area for air quality impacts? And where we decided to land was starting with a minimum impact area of 1 mile. The reason why we chose 1 mile is because in our current rules, there's a few places for information requirements on the Form 2A that already ask operators to tell us what exists out to a 1 mile radius. And I can't think of which rules off the top of my head, but I can get those rule references for you. So the current rules are already in some places asking for information out to a mile. We thought it was convenient and a good way for us to be consistent across basins, across operations, across operators to start with that 1 mile radius, knowing that in the course of the impact area determination conversations, which we intend to happen at the pre-app consults, if there is something right out just outside that 1 mile, invisible line, the director or the local government or one of the residential building unit owners, whoever is a participant in that pre-app meeting could say, hey, wait a minute, there's this thing just outside that 1 mile area that should be considered. And so we wanted the director to have flexibility to expand the impact area based on the actual conditions on the ground. We also feel that meets the statutory requirement that impact area determination is made based on forgive me, I can't remember the exact words, but the scope and scale and type of operation that is being proposed.
Okay.
If I could just jump in here to put a finer point on that, and Sabrina, that was the nature, intensity, and scope. I think that the words you were searching for then there. Again, Caitlin Stafford, Senior Assistant Attorney General. Just to put a finer point on how staff came to propose the default 1 mile. So basically we took a look at the current rules, current rule requirements around rules 303A5, the Form 2B, and current rule 304C19, which is the cumulative impacts plan. During the mission change rulemaking, that 1 mile radius was determined to be an appropriate radius for assessing cumulative total acreage of disturbance for surrounding oil and gas impacts and industrial impacts, among other things. So based largely on that foundation, staff determined it was appropriate to set at least a 1 mile default here in order to help us assess those impacts, that impact area.
Okay, thank you. Oh, that's helpful. And then on the standard of review, it was helpful. Thanks for talking about the clearly erroneous standard and explaining kind of the thinking around that, of the concern about not having to send it back late in the process if the commission were to determine that they had a different sense of the appropriate impact area. Did you talk about other approaches that would, you know, like the director makes a decision on the impact area and allowing that to be kind of appealed to the commission kind of right then before the operator goes through the rest of the process, to avoid that, but still allow kind of some additional opportunity for commission input on with a different standard of review?
Thank you for the question. We haven't included that in the rules, but I'm certainly open to it if the commission would like to have sort of a preview of that before the application gets too far down the road in the process.
Okay. And then the last piece on impact area is about trying to understand exactly what's contemplated in terms of who's involved in that conversation. So what the rules say, you know, that impact area is one of the things that's going to be discussed during the pre-application consultation process, and that process is now proposed to include, you know, a larger group of people, including, you know, residents within 2,000 feet and the community liaison. But then another part of the rule said that, you know, the determination will be based on input from the operator and the local government. So I'm not understanding, like, seems like they are involved in that, and those either I'm not understanding or those are inconsistent.
I appreciate that catch. I think that's something that we might want to provide some clarity in the rule. Our intent is that determination will be based on input from all the participants of the pre-application consultation. So the director, the local relevant and proximate local governments, CPW, CDPHE, the community liaison as they are engaged, and certainly the residents within 2,000 feet of that proposed location. It's the residents who live there that know firsthand what those impacts, at least within 2,000 feet, what those impacts are. And so I think their input is really crucial to the discussion. I will say that the intent is that the determination will be made based on input, but the determination will be the director's determination. The goal is that determination is made in consensus with everyone at that pre-application consultation.
But I appreciate that, and I think that is a consensus on that is a very important goal. If there's not consensus, though, it is ultimately the director's determination, right?
Correct, correct.
Okay, thank you. Okay, so in the June draft, there were proposals in 604 related to setbacks, and then in the later August draft, there were some additional elements added to subpart GG. I forget the first part of the whole citation, but I think you know what I'm talking about. So if if the commission were to contemplate including setbacks, would there, like, are those two pieces mutually exclusive? Like, would GG or other parts of the rule no longer be appropriate or helpful, or help me understand your thinking on that?
Yeah, I appreciate the question. I think the additional, let me maybe take one step back. When we provided the August draft where we removed the rule 604C, I think is what we were calling it. We removed that provision. We went through our current rules. We went through stakeholder testimony and feedback to try to find places where we could introduce new and additional enhanced protections for disproportionately impacted communities. So in the August draft, although we removed that 604 provision, we did incorporate quite a few additional new protections for disproportionately impacted communities. I think it's the commission's choice whether or not to retain those or remove those. I would encourage the commission to retain those additional protections, even if you choose to reinstate some sort of a setback requirement. I think those protections are, they're reasonable, they're doable. I think they would provide a lot of allow for effective engagement of DI community members with the entire permitting process. Not just related to siting, but related to pre-app consultation and post-completeness consultation and enhanced notification and that sort of thing. So it's ultimately the commission's choice, but I would encourage you to retain those additional protective measures.
Okay, thank you. Okay, CIAs for alternative locations. So in the latest statement of basis and purpose language, it says, I'm going to just read it. Going forward, the commission intends for all operators to engage in an alternative location analysis for all proposed oil and gas locations, not just those that meet certain criteria. So this is, I think, is just needing to be educated on the current rule. So which oil and gas location applications currently have to conduct an ALA and which do not, that would have to do so under the proposed rule?
Yeah, that's a good clarification. In our current rule, I'm sorry, I'm scrolling to it. I think it's 304 B2, 304 B2. Yeah, alternative location analysis. There's a list under 304 B2B in our current rules that list 10 different criteria, such that if a location meets any one of those criteria, an ALA is required.
Okay.
In the proposed draft, we've removed the criteria because every location that would require a Form 2A must have an alternative location analysis. So the criteria becomes sort of, I guess, moot.
Thank you. I will take a look at that list. Okay. This time I do have the full site. So 3B2 E(i). So I think this is in kind of what is, all of the elements of what is required as part of the cumulative impact analysis, and it's the air quality section. Does not require quantitative information for air quality, just qualitative. So wanting to understand the reasoning for just proposing qualitative, not quantitative air quality information.
I want to make sure I heard you. You broke up for me a little bit. You're in 315B?
Yes.
Okay.
Yes. Yes.
Okay. So for, sorry, let me finish scrolling that exact section. Okay, so we're already getting the operators quantitative emissions estimates for their pre-production and production operations in the Form 2B. For the other components in, so we don't need that, I guess, duplicated in the CI analysis because we're already getting that, you know, volumes, basically emissions estimates in the Form 2B. For the other subparts, we could ask for quantitative data, although I will say, and I mean no disrespect to operators, sometimes they overwhelm us with data. We've had various OGDPs with attachments that are hundreds of pages of data tables from studies that they've conducted or studies that they've found, and it's not time well spent for staff to just review endless amounts of data. What we're asking for is a summary of data. So sort of what is great that you have data, but instead of overwhelming us with, 100 pages of data tables, tell us in a concise narrative, what is the meaning of the data? What does the data tell us? What value does the data give us? We're also asking for summaries of air monitoring reports. Again, we don't want pages and pages of air monitoring data. We want the results summarized. We are asking for Title V facility permit information rather than all of the emissions associated with the Title V facility. We just want the summary, so sort of the qualitative summary rather than the quantitative bulk of data that would be associated with that. The director and the commission can always ask for additional data. We have existing rules that allow that. And so if there is data available that is necessary for the director or the commission to determine that an OGDP is sufficiently protective, we can ask for that if there's specific information that the director or any of the commissioners would like to have.
Okay, great. Thank you. That's very helpful. And then I think you answered this in your presentation that these rules are intended to apply. Well, actually, I don't know that you did talk about that. So pending applications, I think there was a number of comments in the pre-hearing statements about wanting some clarification that the new rules are only intended to apply to new applications after the rule becomes effective, not pending applications. And I don't think I saw any clarification in the statement of basis and purpose on that note. Did I miss it, or is that something that is still outstanding?
I will try to answer this. I might have one of my colleagues jump in. I don't think that we specify it in the statement of basis and purpose. I think our intention is that we follow what I believe is the Administrative Procedures Act, but they'll correct me on that, whereby a permit is subject to the rules in place at the time that permit application is submitted. And so for pending applications, we would want to make a clear distinction of based on the date that these rules go into effect. There's permits before that time and then new permits that are submitted after that time. And so I don't think permits that are pending today would be subject to these rules.
I can, oh, sorry.
I was going to say, AG Mercer or Ms. Stafford, if one of you want to tackle that question from a legal perspective, that would be great.
Sure. I just wanted to sort of chime in to say that Ms. Trask got it exactly right. The default under the State Administrative Procedure Act is that permits are processed under the rules that are in place at the time that they're submitted. not sort of subsequent rules. And staff is not proposing that we deviate from that default in this respect. So put more simply, staff's intent is that these rules apply to new applications that are submitted after the effective date of these rules. And we'd be happy to make that point more clear in the SBP at the commission's direction.
Okay, that's super helpful. Thank you. Okay, 316, Knox. So on the Form 2D, I guess my question's around both the director and the commission's review of prospectively and what authorities or things follow from that information that's requested on the Form 2D. So as I read the August draft, it requires the submittal of a bunch of information as part of the Form 2D. So part of that is submitting the interim and annual reports, but it's also a bunch of information about the operator's intent in the upcoming season. What kind of activities are planned, and how does that relate to their expected compliance with their NOx target. And then it says the Form 2D has to be approved by the director. So the director would be reviewing both the past information as well as this prospective information. And then the provisions say that the director will disapprove the Form 2D if the past stuff shows that there's not compliance, and will approve it if it shows, that there is. But it's silent about what the director has the authority to do in the event that they're looking at the information about what is planned for the upcoming season, and based on what's happened in the past and how close or not an operator was with previous operations, how close they were to their target, any kind of an assessment if the director's looking at that and saying, I don't see that you're going to meet this, having the ability to therefore deny or add conditions of approval in that kind of a situation. I think that's implied, but would like to understand your thinking about what you all would intend to do with that information, and if indeed you would agree that there may be cases where the director would prospectively making a determination that they don't think that the operator is going to be able to comply with a target in the upcoming season, and therefore either add additional conditions of approval or recommend denial.
Yeah, that's a really good question. I appreciate it because it's making me really think about this. I feel like the intent, and certainly if the rule is unclear, and it very well could be, we can certainly clean up the language. But the intent is that if the two reports say that the operator is in compliance, then it's reasonable to assume that they will continue to be in compliance and can therefore conduct pre-production operations in the upcoming ozone season. If the two reports, the annual and interim report, say different things from one another, one says compliance, the other says not in compliance, that will trigger a consultation with the operator and with CDPHE. That's where we really want to dig in and look at what are the BMPs that the operator used during that prior reporting year. How many wells did they drill? How many wells did they complete? What kind of drilling fluid did they use? What kind of rig did they use? And really have that in-depth discussion with the operator about why they either did or did not or meet their NOx target, or what changed throughout the last year in their operations that made them go from exceedance to on track. So that's a really important discussion where the two reports both indicate that the operator has exceeded their target. We are recommending that the director would recommend denial. But I believe we've added the provision that the operator has the ability then to sort of bump that denial up to the commission for a conversation as well. It may be that we need to add some another off-ramp to have another consultation at that point if both of the reports show that the operator has exceeded. I think it's reasonable for us to give the operator a chance to describe why they have exceeded and what they're going to do differently in the upcoming season, so that they won't exceed. I think that a little bit of difficulty with that, though, is that the Form 2D is due in, I think it's February 15th, and it gives us a chance to review just for a few months prior to the beginning of ozone season, which would be May 1st. There would potentially need to be a lot of operational changes for that operator to make in order to demonstrate compliance. So I'm definitely open to ideas or suggestions, but I do think that the current draft as written does give the operator an opportunity to sort of have that conversation with the commissioners after the director denies their Form 2D. I also want to highlight that denying a Form 2D doesn't mean they can't conduct any operations. It just means they can't conduct pre-production operations during ozone season. So an operator that has truly exceeded their NOx intensity over the previous year would still be able to conduct those operators outside of ozone season. Those operations outside ozone season.
I appreciate that. To get back to kind of the first scenario of an operator where maybe the interim and annual reports show that in the previous season they were in compliance with their target. Would the staff be able to review that in context with the new operations that are planned for the upcoming season? And if that, like, let's say they were very close, they were in compliance, but really, really close, and now they're proposing a lot of additional activities in the upcoming season that were not performed in the previous season, that would give reason for concern about compliance. Would you be able to do that review and recommend denial or conditions of approval in that type of scenario?
I appreciate that comment. The rule as currently written does not explicitly have that sort of language in it. So I would say that maybe is something we would want to consider adding. Certainly the intent of staff is that we don't just look at the Form 2D, we're looking at the operator sort of as a whole. And so part of the Form 2D will include not just the list of operations they're seeking to conduct, but the list of ESPs that they're committing to, as well as other measures to avoid, minimize, mitigate. Certainly we'll be able to review their previous Form 2s, especially where those Form 2s were approved as part of the OGDP process. We can go back into the files, look at their previous Form 2s, look at what BMPs they've used, but the process as currently written does not have that design in it.
If I could just add briefly, in addition to what Ms. Trask just explained, in my view, while it's not, explicit in the rule language, the rule does leave room for the exercise of the director's discretion there. It's in, where are we, 316 B4A, that if, the operator's annual and interim reports demonstrate compliance, the director may approve the Form 2D. It's not a will approve, though I believe that language was requested by some parties. Staff felt it was important to leave this as a may to retain some director discretion for the kinds of situations I think that you're alluding to.
That's helpful, and that's why I was trying. Yeah, first I thought it was just a clarification thing, that because it does say may, but we got a lot of comments from folks saying you should be able to, and I was reading it as, well, I think we could, I think the director could deny it or the commission could deny it because of that discretionary element. But it sounds like if that's the direction the commission wants to go, maybe it currently allows it, but clarification would probably be helpful. Okay, thanks. And this may be a G question. So the next one is, in 316A4, I have down that it says that the director will recommend denial if the operator was not in compliance with NOx targets the previous year. And I'm wondering about whether it should be will or may, like should the operator be able to demonstrate that they've made changes since the non-compliant year that will ensure there will not be a repeat year of missing its target. And actually, Ms. Trask, I think that you had indicated earlier that that was maybe the intent. So we may want to take another look at that, whether that should be a will or a may in cleanup.
Yeah, we're happy to take another look at that.
Okay.
Yeah, and I think that's, in my view, it's more of a policy call than a legal one. I know quite a few stakeholders really were asking for there to be hard denial criteria for new OGDPs based on NOx intensity status. And so that's what the will deny, because 316A is consideration of NOx intensity status with the submission of an OGDP. And so in response to some of those stakeholder requests, staff went with a will there. But if the commission feels it should be may, that's certainly your prerogative.
Okay. And then in your presentation, you did note that like for this first year, operators are only going to have their interim report at the time of submittal in February and not the annual report as well. So just to totally understand that, how that's going to be implemented. So if an interim report shows that an operator is out of compliance with their intensity target, is the intent that the director, and currently the language is will deny, or perhaps it'll be may deny, but is the intent that that will be based just on the interim report, then that would be the outcome?
You're correct in that for upcoming OGDPs where the annual report isn't ready yet, staff would be using only the interim report to make that determination. I do want to clarify, and we don't have this in rule language, maybe this is something we could add to the SBP, that because of the lack of information, the lack of that annual report, maybe there is a little more leeway or a little more flexibility for the director to approve or conditionally approve a Form 2D for this first year. Knowing that in later years, both of those reports will be available.
Okay. And then speaking of the interim report, a number of parties argued in their pre-hearing statements that should be removed, that should not be a requirement to submit. And I totally appreciate and understand kind of the structure of the proposal about, if the two reports have a discrepancy, that will trigger consultation. But can you just talk generally about the value of receiving interim reports and why that's important?
Yeah, thank you for the opportunity to walk through this, because this is another one that I've kind of had to put down on paper so that I understand it carefully. And let me preface this that I am not an expert in Reg 7, so I'm going based on the information that information in Reg 7 as I understand it. The operators are required to submit to AQCC an annual report, which is due every year, I believe in June. That annual emissions inventory or emissions report is for the previous calendar year. So if we look at 2024, the emissions from January through December of 2024 will be reported to the AQCC in the operator's June 2025 annual report. The value of getting the interim report is that if we're making decisions on OGDPs or on Form 2Ds for operations conducted after that annual report comes out, we're looking at ozone season 2026. So for decisions about ozone season 2026, We're using data from 2024. It's 2-year-old data. To my knowledge, there's not a good workaround for that. And that may be why AQCC adopted the interim report, which is a report that the operators are required to submit in November that details their emissions from this year's ozone season. So for 2024 ozone season, so May 1st through September 30th, operators will be reporting to AQCC an interim report in November. We could use that November report to make decisions about ozone operations in the ozone season for 2025. We don't have to wait for that annual report to come out because that's not going to come out until June of 2025. So the value in getting that interim report is that it gives us a more short-term data set and a short-term sort of AQCC check-in on their NOx status without us having to wait 2 years between when data is generated and when we're making a decision on operations, 2 years down the road.
Thank you. So just to play that out a little bit, like in February, March of 2026, when you've gotten the Form 2Ds and you're looking at those for upcoming season, the annual, if we were to say we're only going to require the annual report, then we'd be looking at only emissions from 2 years prior to that, from 2024. Whereas if we also require the interim report, we can see if anything changed between 2024 and the 2025 season that would cause some concern.
That's correct.
Thank you. Okay. Okay, ESPs. So the first part of this question, I think you addressed in your presentation that these are intended to apply only to new facilities. And so you had suggested we clarified that, as well as it's just in the non-attainment area. There were also a number of parties who requested some like kind of discrete or distinct clarifications about various ESPs. Have you had a chance to take a look at those and have any thoughts on whether or not some clarifications there are warranted as suggested? And if we want to revisit this later after parties talk, that's fine too.
Yeah, I appreciate that. I have not had a chance really to get into the weeds on those. I acknowledge that the ESPs that we've laid out here in the August draft were developed in cooperation with CDPHE. And so many of these were taken directly from the CDPHE Energy Liaisons sort of list of consultation BMPs. So they're largely familiar to industry and the public. But I recognize there is some opportunity for fine tuning and making sure that we get the language and the techniques or the equipment properly identified and laid out in this rulemaking. So that is something that I would like to revisit.
Okay, great. Thank you. I'm getting very close to the end of my questions. So a number of parties kind of on the flip side proposed that one of the ESPs should be that electric drilling rigs should be required in every application in the non-attainment area unless the operator can demonstrate that it is impractical. So do you have any response? Did you all consider that in your thinking? I know you said that they were largely taking from CDPHE's consultation guidance and their list, but would like any thoughts you might have on that particular piece.
Yes, we tried to stick very closely to the requirements in Reg 7 around electric rigs. AQCC has laid out some very clear provisions, and so we didn't want to overstep that. So we're trying to be as closely aligned to Reg 7 as possible. I do understand that there are certain locations within the non-attainment area where highline power is just not yet available. That relies heavily on operators negotiations with utility providers where they are bringing highline power out into the more rural areas. And so it's not always going to be possible for every location to have highline power. And so we didn't want to require that, knowing that we were setting operators up for failure if they literally couldn't get power. It's not something that we can require. What we can require, though, is that they provide a demonstration of what alternatives can they offer? Is there battery power? What other types of rigs are available? Or what conversations have they had with utility providers? What indications can they give us that they've been able to negotiate a future utility line headed out, to the back 40 somewhere? And so we wanted to give them off ramps, but also hold them accountable to really striving as much as possible to reach that higher level of protective measure.
So follow up on this then, because I appreciate that. But the proposal was to only to require it if practicable, which sounds very similar to what the sort of information that you just indicated.
Yeah.
Asking for the operators to submit. So it kind of would be an off ramp. And so I guess, again, maybe I'll say this and then would invite you all to go back and think about it. Maybe we can have you come back up and share some thoughts, but would like to hear your thoughts on whether, if that were the case, is that the kind of information that you all would need in order to assess whether or not it's practicable? And do you feel like you would be able to do that kind of a review and have a sense of, what meets practicable and what it does not?
Yeah, I think the intent is that we would encourage operators to use these ESPs every chance that they can. Where they legitimately cannot use them, we want them to demonstrate to us why they can't. And so it puts the burden on the operator to show us why they can't commit to these ESPs. And maybe this is something that either of my two colleagues can speak to. I'm happy to circle back. I feel like I'm not answering your question very well.
I think you are, but yeah, I think it would be good if maybe we have some follow-up conversation after you have a chance to kind of look at it. Okay.
Sure.
All right, very close to being done. We talked a bit earlier about when it's appropriate to use 2,000 feet versus 1 mile, and that, the various rules use 2,000 in some cases and 1 mile, it sounds like in some other cases. So for, in the draft rule, things like pre-application consultation, things like pre-application notice, and maybe another piece, it contemplates that being triggered when the location is within 2,000 feet of the specified buildings and homes and people. Some parties have proposed that those provisions be expanded to 1 mile. So curious if you had thoughts on that.
Thank you for the question. I probably don't have very clear thoughts on that. I did read a lot of party responses asking for a 1 mile notification zone for wherever we offer notifications. I'm willing to have that conversation or certainly take direction from the commission. If you feel that a 1 mile notification zone is appropriate, we can sure do that. I think that in some cases, noticing out to 1 mile would mean noticing a lot of people, which is fine because people have the right to know these things. I think that industry would, and I'm not speaking for industry, I should probably stop talking, but I would think that industry might find some difficulty in providing that many notices, a pre-app notice, a notice of completeness, a notice of director's recommendation. There could be cases where there might be multiple hundreds of people or even thousands of people, and trying to find addresses to that many could be time prohibitive and difficult. I do see the value in noticing out to a mile. So again, if the commission wants us to consider that further or has direction for us, I'm eager to receive it.
That's helpful. And don't worry, I will ask industry parties for their thoughts on this as well, so they can weigh in. Okay, last question. The community liaisons. So a number of parties had some proposed red lines in their written materials, looking to kind of expand the duties and role of the community liaisons. I don't actually know where within the organization the community liaisons are intended to fit, if they're going to be part of your team, but want to get thoughts on kind of capacity of the liaisons, and kind of what's the priorities specified in statute versus kind of the expanded roles and duties that are proposed. Like, do you see that as being feasible for future staff members for the ECMC?
Thank you for that question. My understanding is that the community liaisons will be housed not in my unit, but in our community relations unit. That is being a little bit reorganized. I think we just closed a vacant position, or closed the job posting for a manager for the community relations unit. So that unit is being expanded with the addition of these two community liaisons. My instinct is that the community liaisons will likely be very busy attending pre-app meetings, post-completeness consultations, and other community meetings, both for OGDPs and for CAPS. Also, I think that part of their duties, and I think that we've listed this in Rule 224, is that they will actively engage in outreach in DI communities. And so I think the intent is that they are kind of boots on the ground, going out, meeting with people, providing input and education about how disproportionately impacted community members can access information, can access opportunities to be engaged in commission hearings and decision-making, whether that's application hearings or rulemaking hearings or variance application hearings. I see them as really being integral to developing trust and accountability and good relationship between the commission staff, and members of DI communities. And so I feel like that's going to take up the bulk of their time. I believe that the statute allows that, or doesn't preclude that we could have more than two. I think over time we could increase the number of community liaisons. I think we're starting with two. Again, one intended to be on the West Slope, one intended to be on the Front Ranger in the DJ Basin. As this program develops, and I hope that it develops very much in alignment with recommendations from the EJ Action Task Force. But as this program develops, I think we'll get a better understanding of what the workload looks like for these new positions, so that we can either hire more as needed, or we can start giving them additional duties, such as reviewing the community impacts plan, or community impacts plan, doing more sort of permit review if there's time. But I think their priority should be really getting to know the communities that they're serving, and being a resource for information for those community members.
Okay, thank you. Thank you.
Commissioner Messner.
Thank you, Mr. Chair. And Commissioner O, thank you for kicking us off. And Sabrina and Ms. Stafford and Ms. Mercer, thanks for your work on this. I know that this is a difficult task, and really appreciate your dedication to working hard at it. So I've got a number of questions as well. clarifications just so that I better understand at least what your proposal is. And this is going to jump all over the place as well a little bit, and so I apologize. So I'm going to start with the rule that was, which is Rule 311 revisions. And I guess I wonder if you could talk me through the decision to remove the draft language that was included in June on 311. And then in turn, second part of the question, explain to me how we're going to evaluate cumulative impacts if we don't know when those impacts are going to occur.
Yeah, thank you for the question, Commissioner Messner. We opted to remove Rule 311 because we made some additional revisions in Rule 308 and Rule 312 that hopefully addressed some of the concerns around that June Rule 311 that we proposed. The main point when we drafted the June draft with Rule 311, one of the main concerns was when operations were being conducted where there was a large gap between a cumulative impact review and the operations, or a cumulative impact review had never occurred. These would be for locations that were permitted or built prior to mission change. The language that we've added in 308 and 312, I think largely address that, whereby if an operator submits a Form 2 under Rule 308 that is not subject to an OGDP, so it never had a cumulative impact review, the director can require a cumulative impact analysis happen as part of the review of the Form 2. The reason for that is because we know a lot can change on the ground, right? In between the time the 2A was approved and when the new operations are going to take place. So that's the first benchmark where the director can require that additional information and make an informed decision on whether or not to approve the Form 2. In Rule 312, it's not a Form 2, it's a Form 4 sundry notice, but it's the same sort of application where an operator is proposing subsequent operations on a well that involves heavy equipment, which could include a rig or a frac crew. And so they submit a sundry notice to review the location. If it turns out that that location was approved prior to mission change or was approved through an OGDP 5 years ago, it gives staff and the director the ability to look holistically at the current state of that location and make a determination whether or not to require a cumulative impacts analysis or a Form 2B. And that then provides information to whether or not to approve those subsequent operations through that Form 4 sundry. I had another point, but it just left my brain. So maybe Caitlin can read my mind. Sorry, it just popped back in. One of the other reasons why we elected to sort of omit the Rule 311 question in the August draft is because a number of parties and stakeholders identified that there was some legal concern about an operator's vested right. If there is an active built location, regardless of the sort of expiration date of the Form 2A, that the operator could have a legal vested right to continue operations on that location. So perhaps one of my colleagues can give a more resilient legal accounting of that issue.
I can just jump in briefly to say that, you know, based on some of those legal arguments that were made, it made more sense to take a step back and do some further evaluation on the potential ramifications of changing the language as we had proposed. So that's just to put I guess a point on that piece of it.
Okay. I mean, I appreciate that there was attempts that were made in Rule 308 through Rule 312, even Rule 314E7 has some consideration for timing of operations. But I do struggle a little bit with, well, struggle a lot with a lot of the cumulative impacts analysis that will be done during OGDPs, having timing as a critical piece to that. And whether that's one occupation, multiple occupations, conditions of approval with timing stipulations, all kinds of, different adjoining land uses. I mean, there's all kinds of implications to it. And so I'll continue to think about ways to ensure that the timing of these operations can be evaluated and enforced, even if there's legal implications that have to be worked around on it. So that's one thing I had questions about. Another one is, and this is going to jump over to kind of impact area questions, and Commissioner Oath talked about this, and I'm wondering if you could provide a little color. HB 24-1346 created a definition of cumulative impacts. It emphasizes the need to address cumulative impacts in disproportionately impacted communities. A lot of the new considerations, particularly in the August draft, in disproportionately impacted communities, utilize 2,000 feet to an RBU as a metric, but 2,000 feet to an RBU is a direct impact consideration based on the study we utilized to set the 2,000 feet. And cumulative impacts don't necessarily have a 2,000 foot correlation that has been presented to us in our rules to date. And so I'm wondering how these provisions that are being contemplated inside disproportionately impacted communities related to 2,000 feet, which again is a direct impact radius, address cumulative impacts.
Thank you for the question. I think that lends credence to why we chose 1 mile as the impact area to review those cumulative impacts. So the 2,000 foot radius, I agree with you, that's where the bulk of the direct impacts will happen. We understand that impacts don't stop at an imaginary line. And so that's one of the reasons why we chose the 1 mile impact area to evaluate those cumulative impacts. And that would be for any location, not just locations in DI communities.
But and maybe sometimes I get confused, but aren't there provisions in there that utilize 2,000 feet from an RBU inside of a 2,000 foot setback as the criteria for additional protections?
Yes, so maybe I'll take a step back. In the June draft I believe we had some language around locations in DI communities. And many of our stakeholders identified that there are geographically a lot of acres that are in DI communities, from as identified in EnviroScreen and on our GIS maps. I don't know the percentage. It's roughly half the state is a DI community on our maps. Many of those DI communities, especially on the Western Slope, don't have a lot of people living in them, but they're very large geographic areas. And so by restricting operations in DI communities, we realized we were potentially restricting operations in very large geographic areas where there might not be any people living nearby. And so as sort of a workaround to still provide protections in DI communities without prohibiting operations over large geographic areas, we opted to use the 2,000 foot radius. So wherever there is a home, an RBU in a DI community, we sort of put a 2,000-foot bubble over that, well, a 2,000-foot bubble over the location, and any disproportionately impacted homes that are within that bubble get those additional protections. That means that if there are homes 3 miles away from the location but are still in the same DI community, the operator is not prohibited from conducting those operations. So that was our way of trying to find kind of a middle ground so that we're still protecting the people who live in DI communities, but not prohibiting operations in DI communities that are large in geography, but few in residents.
Okay, I mean, yeah, I think I'm struggling with the direct impacts versus the cumulative impacts, and whether the cumulative impacts are adequately being addressed in DI communities specifically versus addressing the direct impacts, which arguably we're required to do 2,000 feet of any RDU. And I think the same kind of notice requirements and making sure people are aware of what's going on there to help additionally address cumulative impacts, or at least have that input and the notice and community involvement. I think I also think about as well, because having, and let me just ask this, like having a community meeting for people within inside 2,000 feet, which is direct public health impact, versus having notice of that operation at a further distance in order to get the input from people on potential cumulative in a DI community. You know what I mean?
Yeah, I'm happy to continue the conversation, and if you have ideas or would like to propose language, I'd love to read that.
Okay, thanks. And then on the community liaison piece, and appreciate the idea of the community liaison. And there was a couple of things that was in statute though that I'm wondering whether we addressed or not. So one of them, give me a second here because I have to look it up here. But one of them is the term advocate, because it does say in statute that the community liaison should be serving as an advocate for disproportionately impacted communities in a non-legal capacity, while taking into consideration the engages practices described in statute. I didn't notice the word advocate in our rules, and so I wonder if there was any discussion in utilizing the language that's in statute versus creating new language in that particular situation.
I believe we actually did use the word advocate.
Is it in there?
Yeah, it's 224 C1, and it reads serve as an advocate for disproportionately impacted communities.
Okay. Yeah. Now, and then does that section kind of line out the other pieces that are in statute? Because again, I'm trying to apply statutes to make sure that we're getting our statutory requirements in the rules. And so I'm just trying to make sure in a lot of situations, we've just applied statute language into our rules. And is that what happened with the community liaison as well?
I think so, but I would ask one of our AAGs to confirm that for me.
Sure, I can jump in here. So the duties that you see listed out in Rule 224 largely mirror the statutory explanation of those duties. There are some places where we made some wording changes, but it largely aligns with what you see, and specifically that subpart A is a reproduction basically of what is in the statute.
Okay. Thanks. Okay, so in 301F, it talks about deferring to the local process for pre-application, and I appreciate that. I think that local governments, particularly ones that have taken it seriously as far as regulating oil and gas development within their jurisdictions, and have developed good land use process for that. But I guess I'm wondering if there's a conflict in a situation where a local government indicates that they regulate oil and gas, but their kind of criteria for a pre-application conference doesn't follow the 301G minimum standards, at least for ECMC. And what happens then?
That's a really good flag. And perhaps that's something that we can revise in this draft rule. I think our intent is that where a local government has that pre-application process already in place, we would honor that as being equivalent or in lieu of the 301G consultation. Staff has been attending pre-application consultations with a couple of local governments, particularly Weld County, for quite a few years now, and Garfield County as well. And so I think there's a lot of trust and collaboration between ECMC staff and those counties in walking through those county pre-app consultations. They're largely successful. They I think always, or maybe almost always result in similar determinations on locations that are proposed by operators. And so where those processes exist, we don't want to change it. We were just trying to kind of memorialize it here in the rule, but we can sure add additional clarification if needed.
Okay. I'm not trying to beat a dead horse on this one, but I am trying to just better understand this kind of pre-application notice, or kind of notice in general, utilizing this 2,000 foot number. And I think local governments in particular, provide notice for all land use applications, and sometimes there's the utilization of the term neighborhood, or if there are homes, if there are homes captured in whatever metric that they're using, that includes homes inside of a neighborhood organization or a neighborhood group or something like that, then everyone in that HOA gets notice. And was there any thought or consideration for that? Was there any utilization or consideration of what other local governments did as far as determining that notice requirements?
In all honesty, I did not consider that, but I think it's certainly worth the discussion. Maybe we could propose where a local government has their own notification parameters, where those differ from ECMC, then like where they're more expansive, then maybe ECMC follows that lead, depending, so that we're not smalling down the size of the notification, where the local government would prefer that larger area. So I think that that's definitely worth a conversation.
Understand that some local governments are less than 2,000 feet. So
Right.
I'm not, there's one size fits all. So 306B talks about conditions of approval. I think the initial draft talked about the condition would be not operating inside the non-attainment season. The new draft talks about conditions of approval may be applied, and this kind of goes to Commissioner O's question as well. But I wonder if you could help me, just give me some examples of what conditions of approval may be applied that would be different than not allowing them to operate in the non-attainment season.
That is a good question as well. I think there could be conditions of approval around the requirement of certain equipment or certain best management practices or certain ESPs. I think that the commission has the ability to assess or apply conditions of approval based on operators conducting operations within a set time frame. We know that the Form 2A doesn't expire for 3 years, but I think that the commission has the ability to say, this location is in an area where there will be new homes developed within 2 years based on the local government's consultation, and the local government would prefer that the operator comes in, gets in, drills, completes, puts in production, and then moves off site, and instead of having sort of repeat occupations. I think there's quite a bit of flexibility between what staff could recommend, what the director could recommend, and what the commission could recommend or ultimately adopt as COAs.
Thanks. So one question, like Rule 314E7, which talks about the timing of operations. I'm wondering how that's going to be enforced if we can't enforce timing.
So the timing of operations, 314E7, that's specific to CAP applications. CAP applications aren't, when a CAP is approved, it doesn't grant, excuse me, the approval of the CAP doesn't grant the operator the immediate ability to go take action. They still need to get OGDPs, those subsequent OGDPs approved. What staff has historically done with CAP applications that are approved is any COAs outlined in the CAP application are then sort of transferred over to the individual OGDP applications as well. So if there are operational timing restrictions or timing limits applied by the commission in the approval of a CAP, those would automatically be added to the subsequent OGDPs as well, where they can be tracked and monitored for enforcement.
Okay, but they wouldn't still have the same legal challenges associated with Rule 311.
I will defer that answer to the attorneys.
In my view, and Ms. Stafford can chime in here, in my view, no, it's a different matter, in my view, to do what proposed Rule 311 was looking to do, which was change the expiration dates for OGDPs or Form 2As, including those that were issued prior to the rule. That raises a very different set of concerns than requiring timing stipulations for operations related to ozone. To me, that's a lot more similar to the timing stipulations the commission routinely requires around wildlife. It's not saying you can't operate or that you're losing the right to drill under your permit. It's a matter of saying when.
Okay. So in these draft rules as written in your minds, how does the CIDR database that continues to get populated get utilized to inform cumulative impacts analysis?
That's one of the frustrations that I personally have had over the last few years since mission change. I think that the CIDR database is a fabulous construction idea. We're still working on the construction of it. And it has been populated to date by the Form 2B, the Form 2B with every OGDP application. We have not historically had a mechanism to capture CAP-wide cumulative impact information in CIDR, simply because the CAP application has always come in through e-filings, which is not connected to our database. So the proposed new Form 2F essentially becomes the CAP version of the Form 2B. It would be required with every CAP application. The operator would submit it into e-forms or web forms rather than e-filings. That way it gets added directly into the CIDR database and would give the commission its first real, I guess, data-driven glimpse at the cumulative impacts associated with CAPS. I will say that CAPS are rare. There's not a lot of them. And so one CAP would give us one suite of data points, which is not really enough to base a theory on or create additional rules over. But year over year, as we get and approve additional CAPs, it'll be really useful data for us to have in the database where we can compare apples to apples across multiple CAPs and start seeing trends, start identifying, maybe geographic differences that require other protections. We've just never had that opportunity yet. So that's one of the, I guess, one of the things I'm looking forward to most about the potential for a Form 2F. I will say maybe a little bit cheekily, I'm not looking forward to developing a new form, but I do see that there is some real value in it.
And is there any expectation for operators to use CIDR in developing their cumulative impacts analysis for individual GDPs?
Yeah, I wish that we had that in place now. we do have a person on staff who was hired in my unit, I think in March of this year. And one of the projects that he is working on and is developing, basically doing what I think what the commission has intended to do with CIDR from day one. We just haven't had the resources to do it until now, which is to take CIDR and develop a public interfacing dashboard tool whereby all of the Form 2B data that is currently in our database is publicly available, sort of similar to our daily activity dashboard that we currently have on our homepage. I envision that the public operators, anybody could run queries to look for trends in the data, and having the ability to do that both for OGD at the OGDP level and at CAP levels would be a really powerful tool for operators to use to develop future OGDPs and future CAPs.
So with cumulative impacts analysis, and the cumulative impacts analysis in the proposed rules is kind of an enhanced version of what's already in the rules. I wonder if you could talk about how you envision those cumulative impacts analysis getting reviewed by staff. Who's reviewing them? Are there internal referrals that will be associated with them? And are they going to have external referrals to CDPHE or CPW in reviewing those cumulative impacts analysis?
Yeah, I appreciate that question. That's something I've actually thought a lot about. We have a vacant position slated to hire a cumulative impact specialist. I've been working on the position description for that for quite a few months now, but every time I get close to posting that job announcement, something happens with rulemaking or legislation that I kind of put it on hold, and I'm hoping that I can resolve that by the end of this rulemaking for cumulative impacts. Once we know what the cumulative impact analysis will look like, whether it's what we've currently proposed in this draft rule or any revisions or additions that you commissioners would like us to make, we'll hire a person that will be a dedicated cumulative impact specialist. I'm hoping that this person will have some expertise in air quality and also the NEPA process. My anticipation is that this person will be housed in the cumulative impacts unit, but will work very closely with the location assessment team in the planning and permitting unit. A lot of what it will be in the cumulative impacts analysis is related to the alternative location analysis. There just naturally is dovetailing between those two processes. And so this new staff member will work closely with the lead location assessment specialist on every OGDP application or CAP application. This person will also likely take the driving role in reviewing the Form 2B as well. So both looking at the incremental impacts on the Form 2B and the cumulative impacts in the cumulative impact analysis, and dovetailing that review work with those location assessment specialists. I anticipate that this person will be very busy.
And, you know, understanding that staff will need to make a finding that that applicant has adequately addressed, that the applicant has evaluated and addressed cumulative impacts as part of their cumulative impacts analysis. And that includes impacts to public health and wildlife. Is there any anticipation to see this go to CDPHE or CPW for review and determination whether it does evaluate and address public health and wildlife considerations?
We don't currently have that in the rule language, but I think it's worth considering adding it. I think, again, the intent is that when staff has questions that could be answered by our partner agencies, we generally just reach out to them whether it's required or not. So we have excellent working relationships with APCD staff, with CDPHE staff, and with CPW staff. But I do think if that's an addition you'd like to see in the language here, we can sure add that in.
Thanks. This is kind of the last question, and I appreciate your Commissioner O's question about cumulative impacts analysis and 2Bs from a CAP standpoint versus an OGDP standpoint. And I think they're important for both. But on the kind of legal question as to whether it applies to existing permits or to future permits or retroactively to existing operations, and understanding that the APA talks about when an application is submitted, but that at least most regulations that I've seen, at least at the local government level, apply if an application has been deemed complete. And in fact, the mission change rulemaking initially contemplated that it was deemed complete. I wonder if there was any consideration to ensure there wasn't a rush to permit to get some piece of paper in the pipeline that says that they've submitted an application, because at least the way that I read, when an application is submitted, it means that all they have to do is file a piece of paper and then finish up an application at some point 5 years in the future to have enough information provided in this rulemaking to make a determination that they may apply to anything that's not deemed complete, and any kind of challenges associated with that at this point in rulemaking.
I don't recall having a specific conversation or dialogue around that. If these rules are hopefully when some version of these rules are adopted, the effective date I think will be approximately sometime in late November 30th-ish. There might be some operators that put together an OGDP application and throw it into us prior to then, but it doesn't give a lot of time. And I would like to think that most operators would not want to just sort of put a placeholder application in knowing that they're going to have to it's going to come back to draft and they're going to have to basically redo the whole thing. I think most of the operators that we've been actively working with over the last number of years are very conscientious about their the quality of their permits. So I don't foresee a big rush of sort of placeholder permits coming in. But I can't predict if there will be or not.
If I could jump in, Sabrina, so if the commission wants these rules to or to apply to applications that pass completeness by the effective or after the effective date rather than are submitted, that is an option the commission could look into. The staff took the approach of the default under the APA, which under the statute is very clearly application submittal. There is a sort of an exception to that provision, though, that if the commission makes a number of written findings, they can change when the rules become effective. So for instance, 2 applications that have passed completeness. That's something that, would require some pretty detailed findings. And we'd probably want to take another look at that and have you speak with AAG Davenport as well. But there is that option.
Thank you. Thank you very much for answering my question. Sorry to be so long, but I appreciate it. Thanks.
Other commissioners with questions? Commissioner Cross?
Thank you very much, and thank you again to Commissioners Messner and Hook, because you did ask a lot of the questions that I had, so I know that helps with the efficiency that we're trying to make sure we follow through on here. I think I'm going to start with some follow-up on some of the questions that my fellow commissioners asked. To begin with, the first, I want to kind of go to the 316 discussion of the NOx intensity. I know that there was also some discussion from AQCC about sort of the validity of that interim report and the information that's put into it. And so I was kind of curious if, because you did mention working with CDPHE a lot and working on these rules, I wonder if you had any feedback from CDPHE on kind of the structure of this 316 area, specifically with the use of the interim report, given some of the comments that they made as they propagated it.
Yeah, thank you for that question. And I just want to mention, I was having a little bit of trouble hearing you, Commissioner Cross. So if you cut out a little bit, I might ask for you to repeat.
Yeah.
I think I've got the gist of your question for now. We did work very closely with APCD staff. The interim report is something that they are developing. I have asked for clarification on, what exactly is it going to look like? They are still in the process of developing what they want that report to look like. To the best of my understanding, what I think they're aiming for is some sort of a Google form or a very simple sort of fillable form that can be submitted through their website, and that they will have an intake process for that. My understanding is that for the interim report, there won't be excessive QA/QC review other than is the form sort of properly filled out and does the data look reasonable? I don't want to speak on their behalf, so I would encourage you to ask this question. I believe it's next week. We'll hopefully have somebody from APCD staff available to answer questions like this. But my understanding is that they feel that the rule as written, as developed in 316, accommodates the process that they are envisioning developing for that interim report. The staff has been very encouraging and very supportive as we've developed this rule in conjunction with them. So I feel pretty confident that the interim report will be a useful tool for the director and for the commission.
Thank you for that. That is helpful, and I apologize that my mic does not seem to be working well in the office, so I'll try to be slow and enunciate. Looking at the ESPs that Commissioner Oath brought up, I specifically want to look at 316 C4B. So it talks about the operator explaining whether or not it's going to implement some of the ESPs, and including but not limiting to. And it says the availability and explaining the availability. I think that's helpful. Roman numeral 2, it says an explanation of how implementing the enhanced systems and practices could present adverse impacts. I'm guessing that's supposed to be prevent adverse impacts. And then the potential reduction of emissions compared to operational difficulties. And so with especially numeral 3, I just want to make sure are you envisioning this being quantitative in what the overall difference is in the emissions reductions? Or are you more so focused on saying, yes, there could be some benefit from using X ESP, but it's going to be very difficult to get it, even if available, because of, you know, maybe the pipeline, the distance that it has to go, and you have to go through a lot of different rights of way in order to get it. Are you looking at it more qualitative or quantitative?
For that Romanet 3, I think you nailed it in your sort of your second read of that, where ozone could be reduced by the use of an ESP, but able to use that ESP, it will result in additional impacts because of access roads or rights of way, or would require truck traffic or some other impact that would basically offset the NOx reduction that would be gained by the use of it. To the question about Romanet 2, I might have Ms. Stafford jump in, but I think we do mean present adverse impacts. A number of stakeholders have asked us about some of the ESPs. There's one ESP in particular, I think it's the one around, sorry, it's not coming to my mind, the sandbox, that there might be, the use of certain technology might actually cause safety risks when used with certain other equipment. And so I want to be really careful that we understand what any safety risks might be with the use of an ESP. So that would be under Romanet 2 there. That would be the operator's opportunity to describe, if we use this technology that you're telling us to use, it could result in these safety issues. And so that's what we intended for that subpart.
That's helpful. Sorry, go ahead.
Sorry, I was just because Ms. Trask asked for an AAG. I was going to say that's exactly right. The intention was for that to say presents adverse impacts for the reasons she just articulated.
So just to make sure I'm clear on this as well, sort of what you're proposing and saying this is maybe why we're not using an ESP. These combined is really a qualitative explanation as to why they may not want to implement one of these ESPs, and then it's reviewed.
Yes, that's correct.
Do you have any issues with a quantitative analysis in that as well to try and put it in better perspective, or is that too difficult to estimate?
I would encourage operators where they have quantitative data to provide that as part of this response. I don't think we put it in there specifically because there might be circumstances where data is not available, where actual, measurements are not available. And so I think we've written this in a manner that gives some flexibility to the operators to be able to provide however they are best able to describe why they might not be using ESPs.
Thank you. Turning to one of the questions that Commissioner Messner brought up, there was some discussion about the notice matching the direct impacts, but not necessarily matching the impact area for the cumulative impacts, the 1 mile. I'm curious, in the June draft, it didn't go to the full impact area, 1 mile impact area, but it talked about 2,500 feet. And I'm curious if you can explain a little bit about the 2,500 feet and again, why you maybe went away from that as well.
Yeah, I wish I had a really good explanation for this. I'm afraid I don't. As we were drafting that June rule, we were contemplating expanding the notification zone and sort of the what other protections can we offer for DI communities and RBUs in general. I will say somewhat arbitrarily thought, well, let's use 2,500 or let's use a half mile. And then in rethinking that with the August draft, we realized that it was sort of an arbitrary distance, that we didn't have a really solid scientific base for why we would use that number. So it made more sense for us to go back to the 2,000 foot, which I feel like was significantly vetted by this commission during mission change.
And this is perhaps more of a question for the AAGs. With respect to the increase, we have increased times for notification and availability for public comment. We're looking at potentially changing who gets notice here in certain instances as well. And there's also some post-completeness consultations that are being discussed. I just want to make sure that staff and the AAGs don't consider notice or consultation to also be an assumption of being a party automatically to an OGDP.
So I can try to answer and let Ms. Stafford help. But staff didn't propose any changes to the sort of party status provisions of the rules. So I don't think we were contemplating any change there. The same, what is it, 503? I'm forgetting the exact rule offhand that defines who is an affected person. That would not change.
And again, going to one of Commissioner Messner's comments, in looking at we'll call it the sister agency review of the cumulative impact analysis. I mean, you mentioned that obviously there's already some informal discussions with some of the sister agencies, whether it be CPW or CDPHE, to talk about issues that arise. And in proposing that, are you thinking that it's going to be a request? Have you talked to them about making it something more formal in the process? Because I obviously know we don't want to say they must consult with us. We can't put that kind of requirement on another agency, but have you had any feedback with them on the making it more formal as opposed to informal?
I think that Rule 309, which is the post-completeness consultation, I think that's the appropriate time to engage that discussion. That's after the application has passed completeness, which means staff has certainly already had a really good, solid look at the application and the cumulative impacts analysis. As we are engaging with CDPHE during that consultation, that would be totally fair game. The asking CDPHE staff or CPW staff questions about the cumulative impacts analysis. So I don't know that it's I don't believe that it's adding additional consultation. We already have that opportunity built in Rule 309 E and F for CPW and CDPHE.
And this may go back to your prior answer as well, but have you had the conversation with CDPHE about this issue specifically, or is it something else that you sort of anticipate us asking about?
I have not. I have not had that specific conversation with CDPHE staff. It's certainly something that I will bring up next time I meet with them.
And I think the last issue I want to talk about is the DI community versus CI community kind of the development of that. And Ms. Trask, I think one of the things that you mentioned in your presentation as well, and for everyone's edification, the definition of CI community is contrived from one of the subsections of disproportionately impacted communities, correct?
Yes, it is my understanding that every CI community is a DI community.
And specifically, one of the prongs in the statutory definition of DI community is what?
Subsection F. Sure. So, you know, and it was trying to make sure that I made note of all the times that cumulatively impacted communities were brought in. And I just kind of wanted to get a better understanding of staff's viewpoint on the use of cumulatively impacted communities. In particular, a lot of the areas you have within 2,000 feet and within a DI community, and you kind of add the cumulatively impacted community as well. So do you think it's best described as saying, using the cumulatively impacted community is kind of taking it another step further, saying, yes, you can have that spatial impact to a disproportionately impacted community, but if you're talking about a census block for a cumulatively impacted community, we're not even going to be worrying about spatial impact anymore, just regardless if you're a CI community, it's going to apply.
Yes, that is our intent with that. So we have repetitive language throughout the 300 series that describes locations that are within 2,000 feet of an RBU in a DI community. That is us saying that when there are disproportionately impacted residents within 2,000 feet of a location, they get this suite of protections or notices or whatever the rule is speaking to. When the location is in a CI community, those protections are expanded to the entire block group that is the CI community. It doesn't matter if the location is within 2,000 feet of people or not. So it is additive. It protects the 2,000 foot language protects those people that are in a disproportionately impacted community that are also within 2,000 feet of a location. And the rule language also protects those people living in a cumulatively impacted community, regardless of how close they are to the proposed new location.
Okay. And then I think one final question with respect to the cumulatively impacted communities. Because this is based on the EnviroScreen, and you said it may be based on the 2.0 later on, but because the EnviroScreen changes over time, what could be a cumulatively impacted community could also change over time, correct?
That is correct. I don't know a whole lot about EnviroScreen, the actual EnviroScreen tool. I've been playing around with it in the last few months. My understanding is that the EnviroScreen uses the 5-year American Community Survey data from the US Census. It's sort of a rolling 5-year. My understanding is that the CDPHE is planning to update EnviroScreen from 1.0 to 2.0 later this year. I am not sure, but I can find out for you if that would include updating the data as well. My understanding of the conversion from 1.0 to 2.0 is that it will create some new interface enhancements that aren't currently available in EnviroScreen 1.0. Things such as the ability to have the maps show sort of queried results. Like right now, the maps are limited. The map display is limited to showing only certain types of data. And you hover your mouse over a block group and it pops up the information for that individual block group. What 1.0 currently is not able to do is to have a user sort the data or filter the data to a refined set such as CICs and then display that. So my understanding is that 2.0 will create some additional functionality for the user. I will find out though if the 2.0 will also change the data set, the census data set that is used, which may change the block groups designations for DICs or CICs. I can ask APCD staff about that and circle back with the commission.
Thank you. And I was wrong. I have one more question. The definition of cumulatively impacted communities, that's consistent with what AQCC did previously, correct?
Yes, that is correct.
I think those are my only questions. Thank you. And sorry for my microphone issues.
Other questions for the panel? Commissioner Ackerman?
Thank you, Mr. Chair. I'll be relatively brief, as most of my questions for staff at this juncture in the conversation are generally broad and philosophical. I certainly have a lot of thoughts, and we'll reserve the majority of those for after the time after we hear cases in chief and when we're giving direction to staff. I wanted to add my thanks to everybody involved in helping to draft these regulations, but especially to the two people that were left off of the list by Ms. Trask, which is Ms. Trask herself and Ms. Stafford. I appreciate the work that they've done. It's been a great deal of work, and wanted to add my thanks to them as well. Ms. Trask, I think this first one is for you. You mentioned at the onset of your presentation that staff's typical process was followed by drafting straw dog rules for cumulative impacts, then soliciting feedback on those rules, and then revising those into draft rules, which were then not just intended, but actually noticed for hearing prior to the time that we decided that it would be prudent to stop and pause during the legislative session to then kind of restart and implement direction that was given in that legislative session. And then I just wanted to verify that I think what you said was, I think you just said we followed the process, but I think what you meant when you said that was that you again drafted a straw dog rule set, you again solicited for feedback, just like you did before, you received that feedback, and then you again revised those straw dog into actual draft rules for noticing for this hearing. Is that correct?
Excuse me. That's partially correct. And I apologize for not making my case clear earlier. I don't believe, and the AAGs can correct me if I misspeak here, I don't believe that we put out a straw dog rule for the initial attempt at the CI rulemaking. We put out, I think the first draft was the notice draft in February of this year. I don't believe there was a straw dog prior to that. There was certainly a lot of robust stakeholdering throughout 2023, but I don't recall putting out a straw dog. I think we just started with a February draft this year. But you are correct for this sort of round 2 of cumulative impact rulemaking attempts. We did put out a straw dog, and then did we? Sorry, I'm losing my train of thought. Revised the straw dog with feedback that we received from stakeholders, noticed that draft in June, received pre-hearing statements from the parties and additional input, public comment, written public comment from stakeholders, and then re-revised that June draft into the August draft that is under consideration today.
If I could briefly jump in to clarify the timeline there.
Sorry.
It's okay. There's a lot of things going on here. So staff released an initial straw dog draft to request feedback from stakeholders in January 2024. Based on that feedback, staff then issued a draft set of rules that were noticed with the Secretary of State under a different docket number than what we have here today. Following sort of reading the tea leaves with the legislature, it seemed as though there would be some bills that would address some of the cumulative impacts issues that we were dealing with. There was a pause, and then We still convened with stakeholders to receive feedback on things. The initial docket was then the initial application for the rulemaking hearing was then withdrawn from that previous docket. The rules, the draft rules, the notice draft from June was noticed under this docket that we are currently in now, 2406000145. So those were the June 2024 noticed draft rules, along with the SBP provided to the Secretary of State. And then in August, we had a revision to the notice draft. And that is at least, those are the sets of rules that we are contemplating or reviewing now.
Thank you for that clarification to both of you. I appreciate that. And I think that what you outlined there was what I perceive to be staff's general rulemaking process, although this one was different because it was essentially repeated after the legislative session. And much like we did with the geothermal rules, we put out a straw dog, we revised them based on feedback, and then that resulted in the draft rules. And what I'm trying to get at there is that the revision in early August was generally a standard procedure in how we handle rulemakings, and the evolution of draft rules from a straw dog to incorporating feedback from stakeholders in preparation for hearing. Is that correct?
Yes, I believe that is correct.
Thanks so much. And together with that, I mean, in companionship with that, we did hear earlier today, and I saw in some other comments, some statements that the August changes were largely deferential to industry comments and feedback. And they asked why other groups' comments on the draft straw dog were not implemented in the August 2nd draft. And wanted to see if you, off the top of your head, could detail a bit more of the evolution of those rules and the one into what we have before us, including any suggestions that were implemented in the August draft from NGO or local government or non-industry sources.
Yeah, thank you for that question, Commissioner Ackerman. We did, in the June noticed draft, we did incorporate a lot of feedback from some of the environmental NGOs and conservation groups. And I acknowledge I've been reading a lot of newspaper articles and op-ed pieces saying that the August draft, we just pulled everything out and went with industry's proposals. Without sounding too much like I'm pushing back, I will push back gently in saying that there is some accuracy there. We did pull out some of the information or some of the requirements that we had in the June rules, but we tried to replace those with expanded and enhanced additional protections, particularly for disproportionately impacted communities that weren't in the June draft. So I hope today's walkthrough, especially the series of slides near the end of this morning's presentation, where I highlighted some of the new protections for DI communities, I hope that those are visible to all of our stakeholders and all of our parties. Staff certainly did not intend to ignore the feedback from our ENGO and conservation partners. We revised the August draft as a means to provide different protections for DI communities that didn't require a setback. So this opens up the conversation maybe around, in the June draft in particular, we had a 600 series rule. I think it was 604C, and I apologize if I've got that wrong, that required or proposed to require 2,000-foot setback to homes in DI communities and would require informed consent from anybody living within that 2,000-foot setback. That was one option. I believe staff is still open to that option. In August, we replaced that option with a different option where we removed that setback, but we added in a slate of additional protections, including expanded notification, expanded public comment period, more involvement for members of DI communities in consultations that went above and beyond those initially offered in the June draft. So so really that question is still unresolved. Staff has issued two versions, the June version and the August version, which may look very different from one another, but if you itemize the protections, they may actually be more similar than first is identified. So that's something that I very much look forward to hearing from the other parties or the parties to this rulemaking, and certainly looking forward to hearing commissioner questions and deliberation on this matter, because to me it's that's an issue that is really one of the prime issues in this rulemaking overall, and something that I am deeply involved and engaged in trying to find the right answer to.
And if I could add to that, you know, in addition to the rules that Ms. Trask was just discussing, there are definitely a number of areas in the August draft where there are added protections compared to what was in the June draft. Some of these were sort of directly responsive to recommendations from some of the conservation stakeholders and local governments. Others were sort of staff's original ideas to get at concepts or larger issues identified by those groups. So these include things like the ESP list. There were at least two that I can think of off the top of my head, new ESPs that staff added based on stakeholder feedback related to sandbox technology and covering drill cuttings, I believe. Staff also made a number of changes to really ramp up the protectiveness of Rule 308. That includes sort of the overall process for ensuring that the director can receive an updated, or for the first time, 2B and cumulative impacts analysis if, you know, the analysis for the location has gone stale, but also a requirement that before applying for a 2B, the location must be in compliance with interim reclamation requirements. Interim reclamation is an issue we heard a lot about from stakeholders and are trying to address that way. Also, the new additional requirement that operators have to provide notice to the relevant and proximate local governments if they file Form 2s that are not subject to an approved OGDP is another way to sort of make sure that transparency and community input is prioritized. There's also the new Form 2F cumulative impacts data identification for CAPS that Sabrina has talked a lot about. And another, sorry, I'm sort of rattling off a list, but it's what's top of mind here. We included a requirement that operators affirm in their cumulative impacts submission that they're not using PFAS chemicals in hydraulic fracturing fluid. That was another new add from June to August. And those are the ones that are sort of most top of mind for me right now. And then I would say that there were also a number of areas that staff discussed sort of after responses to pre-hearing statements came in. Staff was not going to be issuing another draft, but we felt there was a lot of good input from the community and environmental groups around the community liaison's role in ways that could be perhaps clarified or expanded. So those are just some ways that the August draft increased protections, and perhaps the commission could continue taking it in that direction.
Thank you so much to both of you. And you weren't rattling anything. You were directly responsive to my question. So thank you so much to both of you for those responses. Just a few more, again, a little bit broader philosophical questions. And Mr. Chair, I saw you unmute. Do I need to pause? Okay, thank you. We've talked quite a bit about the cumulatively impacted communities discussion here. And, you know, I kind of wanted to see if we could pick your brain a little bit on the philosophy of why talk about limiting from DICs, limiting to a certain subset of DICs, which in this case, as we've got drafted, is the direct adoption of the CIC concept that was deliberated and designed by AQCC. So I certainly can see why you ended up there when talking about the limitation to a subset, and that makes some sense to me. But can you talk a little bit about the philosophy of what staff thought about when they talked about, rather than just blanket regulations associated with DICs, the necessity of limiting to some subset of that?
Yeah, I can start with that. Thank you for that question too. Our, I guess, philosophy, to use your term, is that we wanted to ensure that the people who are already most impacted, cumulatively, not necessarily just from oil and gas, would potentially have additional protections. I think it makes sense that where CDPHE has adopted a term, that we also might adopt the same term. I think that there probably is room to improve how we apply that term in our rules if you commissioners decide to adopt it. I do recognize also, though, that and per many of our stakeholders, that there is not a lot of new oil and gas development happening in cumulatively impacted communities. So there, without looking at the maps, which I don't happen to have on hand, it might not be, it might not add value if those are communities that are already recognized as having extremely high or higher than normal impacts, and operators are already not requesting new operations in those communities. Maybe the term doesn't add any value to this rulemaking. We wanted to include it as a consideration for you. Certainly, I think it's worth the discussion. And again, I'm eager to hear your thoughts on it.
Thank you. I appreciate your response, and I'll continue to reserve those thoughts a little bit until we have the cases in chief put out there. But I really appreciate your further description of that. And this one is related, but it might be a little bit too crystal ball for you. And if it is, then, of course, just let me know. But if we do have a discussion about limiting certain regulations to some subset within DICs, as you pointed out, DICs are about half the state, very, very broadly and grossly defined. If we do have that discussion about limiting to some subset, do you think a departure from the CIC concept designed by AQCC would have the potential to put ECMC regulations in an inconsistent state with AQCC or CDPHE, or do you feel like there's some room for that discussion?
I'm not, that's a really good question. I'm not as familiar as I should be with Reg 7, but I do believe that there are some language in Reg 7, in AQCC's Reg 7, particularly in the non-attainment area, and particularly regarding NOx, where there are additional and forgive me for, I can't remember the phrase, but use practices that are required in cumulatively impacted communities. And so I would be a little hesitant, maybe not hesitant. I would just want to make sure that if ECMC were to designate a different subset of disproportionately impacted communities, other than CI communities, that wherever we landed in our language would not conflict with the CIC language in Reg 7.
Understand. Thank you. I appreciate that response as well. Just a couple more. This one should be relatively short, but on the topic of biological resources, this is a topic certainly that I'm very interested in and have a lot of thoughts on. And again, we'll likely share those after the cases in chief. But the question I have for you is, as staff kind of wrestled with how to properly include biological resources protections at this phase, excuse me, sorry about that, which I'm sure was impacted by your consideration of how this topic juxtaposes with the pending CPW implementation of House Bill 1117. Did you have any thoughts or discussion about the utility or potential utility of maybe reconvening a kind of maybe biological resources working group 2.0 to address this issue further?
Yeah, I think that that could be a really good idea. We know we have a lot of both parties and non-party stakeholders who have a deep interest and concern in how we are evaluating cumulative impacts to biological resources. And so there's a lot of expertise, there's a lot of variety throughout the state, just geographic diversity and biological diversity. Certainly, as you mentioned, CPW's new authority through 1117, which expands, my understanding is that it expands their ability to study plants and invertebrates. And so that, in combined with their updated 2025 SWAP data that's coming out, might be a good opportunity to sort of reconvene a work group to take all of these different biological resource prongs into consideration.
Thank you for that response. And I know that just a brief editorial comment on that. I know that making that kind of a comment may be frustrating to some, especially those from the first Biological Resources Working Group who worked so very hard to provide some recommendations to the commission, and I'll be addressing those later on in this hearing. Especially grateful to Mr. Clefane, who commented this morning and urged us to continue to address this matter. So thank you. And then my last two questions are a little more, just a little more procedural, I guess. The Rule 315 impact area discussion. Just wanted to, well, I guess this one's a little philosophical too. Your thoughts on restricting the potential broadening of project-specific impact area to the original consult, and your thoughts on the workability of, if we do go down that road of a base 1 mile, but opportunity for expansion, your thoughts on the workability of a potentially more involved impact area boundary setting process at the OGDP stage.
Yeah, we've had a number of conversations with some of our stakeholders about that, and we've certainly talked internally about that. I don't have solid answers. I have ideas. A number of stakeholders and parties have asked over the last month or so if the impact area is expanded. Is it expanded uniformly? So it goes from 1 mile to 1.5 miles, and then all of the resources are accounted for within that 1.5 miles. Or is it only expanded for the resource or impact which triggers that expansion? So, for example, if there's a cement plant that is just beyond the 1 mile radius, do we just include or expand the impact area just to include that cement plant and air resource concerns and nothing else? Again, I would look to the commission for ideas or for direction on that, because I think there's a lot of variability in what is achievable. And maybe even a third idea would be that the impact area itself doesn't expand, but the director requires information about that specific cement plant. I don't know what the right answer is. It's been an ongoing question, and that I look forward to trying to find some consensus through this rulemaking and finding the right answer there.
Yes, thank you. Appreciate that. And I certainly understand the difficulty and enormity of that task of trying to get our arms around it. I expect that we'll have significant further discussion on this topic, and I also look forward to group thinking this one a little bit as well. Finally, this one was the procedural one. I note that, and I don't think you mentioned this in your presentation, but I note that we removed Rule 225, proposed Rule 225 in its entirety. That's the rule on the Operator Impact Reduction Program and Preferred Operator Designation, which is a potential program that we set off to explore My read was that it was ubiquitously not supported on all sides, but I just wanted to touch base for the record on the removal of that and the reason that we removed that.
You are correct. There were very few parties and stakeholders that liked that rule. I want to recognize, though, that we are under an obligation to develop a program like that based on the governor's letter from March of 2023. I think that there is a potential opportunity to establish a working group around that as well. Or if a working group isn't necessary, then maybe it's something where staff can redraft some ideas, share with a diverse group of stakeholders for feedback, and try again. I do think that from a commission policy perspective, it makes more sense for that program to be a policy rather than in the rules. And the reason why I think a policy is better is because if there are BMPs or enhanced systems and practices that we want to update as requirements for those preferred operators to follow, if it's in the rule, we have to do a rulemaking to expand or update those enhanced practices. Whereas if we put it out in a policy format, it gives us a little bit more flexibility to be adaptive year over year as new technology is unveiled or as the governor issues new directives to us on that. So I do think it was the right decision to remove that program from this rulemaking, knowing that we do and we will intend to circle back with it and complete that directive.
Thank you, Ms. Trask. I appreciate the considerable brain power that went into that program, as well as all of these other rules and the recognition that the governor has directed us in that direction. Mr. Chair, not as brief as I had envisioned in my mind, but that's all I have for right now.
That's great. I don't have other questions going last. I generally can find that most of the questions have been asked and answered. I want to thank again Ms. Trask and her team for the really brilliant work here. I think this last couple of hours really sets the stage for the cases in chief as we hear from the parties. So I would remind everybody that the PowerPoint that was put together is going to go into the portfolio. And so folks can access it under our hearings page link. And I think it's a helpful document for all of us to have in front of us. With that, it's almost 3:30. Let's take a 10-minute break and come back at 3:40. I've got a few procedural matters, and then we'll go into at least one case in chief. We are back. This is the Colorado Energy and Carbon Management Commission. It remains to be September 3rd. It is 3:40, and we are going to return to cumulative impacts rulemaking docket 240600145. A couple of procedural matters before we get started. Hearings Manager Thomas, thanks for elevating. Excuse me. We are set for a second round of public comment via Zoom tomorrow at 5:30. However, commissioners, I want you to know that we've got a lot of people that have signed up, probably close to 5 hours of public comment. And so what I'd like to do is create 2 evening public comment sessions, one tomorrow night from 5:30 to about 7:30, and then one Thursday night, November 5th, from approximately 5:30 to 7:30. We are going to go all day tomorrow, and then if we were to go 5 hours tomorrow night, I think I would pull my hair out. So I think we're better served to create just 1 or 2 sets of smaller public comments. We would not reopen for more public comment. We would just put half of the public commenters in tomorrow night's session, probably the first half of those that signed up in sequential order, and then the second half for Thursday evening. Does anybody's calendar have a problem with this notion?
Well,
Commissioner
Mr. Chair, I would just note that I actually had a previous conflict on the Wednesday evening, so was not going to be able to attend the Wednesday evening public comment session and was intending to review the recording afterwards, but do not have a similar obligation on Thursday.
Okay, yeah, and that's not a problem. The public comment will be videoed, and we'll put that online in the portfolio, and you can certainly have an opportunity to refresh by looking at that at a time that works for your schedule. Hearings manager, Commissioner Cross.
Thank you, Mr. Chair. I don't think I have any issues. I'm just curious if we'll accommodate people, public commenters that may be able to do Wednesday and not Thursday, or vice versa, as opposed to just kind of cutting the list in half.
Hearings manager Thomas, if you are able to facilitate that sort of notion, go for it. But at this point, we've just got to accommodate the calendar. So do the best you can, but also just make sure that it happens. Is that fair?
Yes, and we'll make a posting on the website. Obviously, we'll do our best to accommodate people that we can accommodate within reason, and all that'll be outlined in the posting that'll go up shortly.
Okay. All right. AAG Davenport, anything from an Administrative Procedures Act perspective that I need to be wary of?
No, nothing, Chair.
Okay, great. Okay, with that, we're going to turn to cases in chief. How this is going to work is we've got it outlined in terms of the order of play. The party, the attorney for the parties, if there is an attorney, can certainly provide their case as they desire. I would remind folks that we do better without a question and answer format and just let the witness sort of speak. Obviously, the attorney probably has a lot to say as well, which is fine. I would remind folks, as I did at the outset, that we've got a ton of hours set aside for this, approximately upwards of 1,500 minutes. So let's all try to be cognizant of the time. Reminder that if we get to it and we're not where we need to be by Friday afternoon, we will likely be having a rulemaking hearing on Saturday for those who missed that from the very beginning. I do understand, and Hearings Manager Thomas, if you could confirm that we're changed the order of play right now. Earlier, it was going to be Conservation Colorado going first, but I understand perhaps that it's now Earthworks. Is that right?
That's correct. And counsel for Earthworks, as well as his one witness, have been elevated already.
Great. Okay. And then AAG Davenport, in terms of witnesses and swearing in, not swearing in, can you provide to everyone the rules of play for a non-quasi judicial and instead a quasi rulemaking hearing?
Yes, happy to, Chair. As opposed to quasi adjudicatory, which is essentially non-rulemaking matters. In rulemaking matters, the Commission's practice, and this is consistent with generally how legislative matters are conducted, does not swear in witnesses and does not hold folks to direct examination. I'd also note that there's no cross-examination in a regulatory quasi-legislative proceeding.
Okay, thank you for that. Mr. Freeman, if you want to visualize yourself, we are ready for you.
Thank you, Chair Robbins. And I'd like to add Andrew Closter from Earthworks, who will be joining me today. I'll be presenting our remarks, but Andrew's available to help with any questions the Commission may have at the end of those. Could I also share my screen? I have a PowerPoint presentation.
Yeah, absolutely.
Thank you. Let's see here. Okay, can you all see that?
We can. It's not in presentation mode.
Right, let me put that into presentation. How's that?
There you go. Now you got it.
Great, thank you. Okay. So I'll begin then. First, my name is Michael Freeman. I'm counsel for Earthworks.
With me is Andrew Closter from Earthworks as well. We'll be presenting Earthworks remarks on the cumulative impacts rulemaking. First, I'd just like to thank the Commission for the time you're taking in allowing us to speak today. And I'd especially like to thank Ms. Trask and her staff, and as well as the Attorney General's staff who worked on this. Cumulative impacts is a really challenging issue, and it's really clear how much work that staff has put into these, and we greatly appreciate it. I'm covering 3 issues today, and I'll try, given the amount of time involved, I'll try to be concise with as much as I can with all of them. The first topic will be the proposed amendments to Rule 604 that were initially proposed in the June draft, but dropped from the August draft. The second topic I'd like to cover is Rule 315 and our concerns with the approach that the rule takes towards cumulative impacts. And then finally, I'll briefly address Rule 316 and the proposed provisions for ECMC to support enforcement of the NOx intensity standards. So turning to 604, I think in considering the June proposal for tightening up the Rule 604 setback in disproportionately impacted communities, I think it's important to consider why the Commission adopted Rule 604B in the first place. The 2,000-foot setback was adopted as part of the 2020 missing change rulemaking to implement Senate Bill 19181. And a primary goal of Senate Bill 181, as described by the legislation sponsors, was to keep oil and gas drilling away from homes. And in the mission change rulemaking back in 2020, the Commission made extensive findings before it adopted Rule 604B. It found that oil and gas development should generally be at least 2,000 feet away from homes, and it adopted 604B and the 2,000-foot distance as a presumptive setback from homes, high occupancy building units, and other buildings. And in doing that, the Commission's rationale really started with the statutory mandate. And in the statement of basis and purpose, it pointed out that the Act directs the Commission first to try to avoid impacts from oil and gas development. And it found, based on a really extensive record and extensive fact findings, that a 2,000-foot distance is reasonable and necessary to meet that statutory mandate. For example, it found that a 2,000-foot distance is effective at avoiding noise impacts and minimizing traffic impacts, just by way of example. The Commission also considered extensive evidence in that rulemaking as to the public health impacts of oil and gas development and at what distances nearby residents would experience health impacts associated with oil and gas development. The Commission recognized that there's uncertainty in the science, but it found that it was appropriate to keep most oil and gas drilling 2,000 feet away from people's homes as a public health measure because there's always going to be uncertainty in the science. The science is developing, and in any site-specific application, there's always going to be uncertainty and incomplete information about what the actual risk is to the neighbors, and found that using distance as a proxy for avoiding public health impacts is worthwhile. Now, the Commission, in adopting 604B, of course, allowed for a number of exceptions to the setback. And unfortunately, in practice, those exceptions have largely swallowed the rule. What we found in practice, and this is based on the Commission's annual cumulative impact report, is that particularly in the Front Range, about half of new and amended OGDP locations over the past 2 years have been approved within 2,000 feet of people's homes. The report found that in 2022, 51% was within the setback distance. And in 2023, the figure was 47% of locations were within that setback distance. Now, statewide, the figure is lower. It's 28 to 35%. But that's because this is primarily a Front Range problem. The rate is lower, much lower in other parts of Colorado. The cumulative impact report indicates that On the western slope and in southwestern Colorado, only about one location a year was approved within the setback distance. And in the eastern plains and in southeastern Colorado, there haven't been any oil and gas locations approved within 2,000 feet of residence. So the proposal in the June draft to limit the exceptions to Rule 604 would have a significant, would be focused on the Front Range, but it would have very little, if any, impact outside the Front Range in other parts of Colorado. Now, one of the key issues with the exceptions to 604 is 604B4, which is the exception for substantially equivalent protections. And the commission, part of the issue that we've seen with the implementation of 604 is that the commission hasn't required operators to show operators who want to take advantage of the substantially equivalent exception. Operators haven't been required to show that the proposed operation would actually reduce impacts to the same level as keeping the well pad 2,000 feet from the home. And in practice, operators typically will just propose a set of best management practices or operational measures with no discussion of how they compare to 2,000 feet of distance. Instead, they will typically describe their measures as robust or sufficient to address impacts. And the exhibits we attached, the Exhibit N in particular, with our pre-hearing filings provide some examples of that. And in many cases, the measures that operators offer to support an exception to the setback are just steps that the operator applies at all or most of their new locations. Again, there's some examples of that in Exhibit N with our filings, and the Chevron written testimony for this rulemaking also provides an example of that kind of a description. And so if the operators are really using what they view as robust measures, but just standard mitigation measures across all operations, it's really unclear to what extent the Rule 604 setback is providing any additional protections in those locations. So we were very supportive of the proposed changes in the June draft to essentially require informed consent before an operator wanted to go within the setback distance in a disproportionately impacted community. And we, again, based on the commission's cumulative impacts reports, under current drilling patterns, the change that was proposed to 604 in the June draft would have had a very modest impact because they generally have been able to get informed consent when working in disproportionately impacted communities. The reports indicated that there was only one oil and gas location in 2023 that in a DIC that used the substantial equivalent exception. In addition, we went beyond the reports and took a look at 2024 OGDP approvals in Weld County to assess what the practice has been recently. And we found that so far this year in 2024, in Weld County, only one proposed or amended location would have been affected by the change to Rule 604. So our view is that if operators are continuing their current practices of either getting informed consent in disproportionately impacted communities or avoiding homes there altogether, the change to Rule 604 shouldn't be objectionable to industry operators. On the other hand, though, if operators are anticipating that they may want to drill closer to homes in DICs in the future, the change here is really important and would yield substantial benefits to Colorado residents. So we were really surprised and disappointed when the changes to Rule 604 were dropped from the August draft. And we asked the commission to reinstate those changes and finalize them in the final rules. I think there's several significant benefits to requiring informed consent, especially in DI communities that are just not provided by other DIC protections that are under consideration by the commission here. So first, I think it's important to remember that under the state statute, the goal of engagement with DI communities is not just to give them notice or more information about the project or to ask questions of the operator, but to actually engage and let them modify the proposed state action and change agency decisions. letting the operator make its own decision about whether to grant informed consent for drilling is allowed near his or her home advances that statutory goal in a way that the other DIC provisions that the commission is considering just don't do. Second, the requiring informed consent also goes a long way to leveling the playing field for residents. One of the issues we see with the substantially equivalent off-ramp is that it inherently puts communities at a disadvantage for several reasons. First, there's just no clear standard there. It's not clear what exactly qualifies as substantially equivalent, and the commission has it just really has boiled down to what the commission and the director view as adequate or sufficient mitigation. Another problem is that assessing substantial equivalence really turns on a whole set of technical assessments about the oil and gas equipment, pollution control measures, and other steps that communities, especially DI communities, just aren't equipped and don't have the time and resources to usually address effectively. As I'm sure you all are well aware, I mean, operators with their OGDP proposals will invariably offer lots of technical arguments and data asserting that their operations will be very protective and that not to worry that the drilling won't make any more noise than just a refrigerator. And residents in the DI community just are not in a position to address and respond to those claims effectively. Moreover, the substantial equivalent off-ramp creates a power dynamic that is similar to what residents face with force pooling. An operator can go to the residents near where they want to locate the well pad and make them an offer in asking for informed consent. But if the resident doesn't like the deal being offered and wants more protections or additional measures, the operator always is able to just walk away and say, take it or leave it. If you don't like this offer, we'll just go ahead and do it anyway with a substantial equivalent standard. But eliminating that substantial equivalent off-ramp and requiring informed consent from DI community members gives operators much more incentive to address their concerns and forces them to focus on going above and beyond to require extensive mitigation before they drill near people's homes in disproportionately impacted communities. Now, I want to note that setbacks are certainly not the only tool for the commission to address cumulative impacts and to protect DI communities, but it's really a necessary one because distance, as this commission recognized in 2020 during mission change, distance is a key part of avoiding impacts. And it accounts for the fact that whatever the operator proposes, whatever technical review the commission can do, there's always going to be uncertainty, and nothing substitutes for just keeping distance between the drilling and operators. And that was what was found in 2020, and we think it still holds true. We think that is especially appropriate in DI communities because, and it's appropriate to set a much higher bar in DI communities because these are folks who are already disadvantaged and are already subject to other environmental stressors, and they ought to be able to have a direct say in whether new oil and gas drilling happens close to their homes before it goes forward. And ultimately, the bottom line, we think, is that drilling close to homes is supposed to be the exception, not a routine operational issue. And that's especially true for DI communities. That was the intent during the mission change rulemaking. It was also the intent of SB 1981. But what many of the industry parties are advocating in this rulemaking is a much different approach. And what they're advocating for are a set of protections that are procedural notice that would effectively make drilling in DICs essentially a routine matter as long as a number of boxes are checked and procedural steps are taken. And we think that's not what that's just inconsistent with both the spirit and the language of the act. And we would urge the commission in DI communities to really adopt the changes to make sure that the setback lives up to what it was intended to do when it was adopted 4 years ago. So next, I'd like to talk about Rule 315. And that's the rule addressing, of course, cumulative impacts. And as Ms. Trask and the Attorney Generals have pointed out, the process of evaluating and addressing cumulative impacts is a necessary part of the Commission's statutory duty to avoid and minimize and mitigate impacts to resources like ozone, wildlife, communities, water, and numerous other resources. And ultimately, the point of cumulative impacts is to consider a proposed oil and gas project in context. Earlier, I think during the informational docket, one of the commissioners described cumulative impacts as essentially about, with a bathtub metaphor, that that even if the commission knows how much water is being added by a particular OGDP that it's considering, it also needs to look at how much water is already in the bathtub from other sources and who else is adding water to that bathtub at the same time or expected to add more water to that bathtub in the future. And ultimately, you look at whether, when you put it all together, the particular OGDP under consideration is going to contribute to the tub overflowing. And what that means is looking at not just the OGDP under consideration itself, but other oil and gas development that's already happening in the area, future oil and gas development, and then all the other activities that are being approved by non-oil and gas activities that are being approved by other agencies. And considering that broader context and those other factors just is something that can't be done effectively through a permit by permit review. And so that's really our overarching concern with Rule 315 is that it's trying to address cumulative impacts as part of the existing OGDP process. But the permit by permit review for OGDPs is just different in kind from a cumulative impacts analysis because the entire point of cumulative impact is to look beyond the proposed project itself. And we're not aware of any other agency at the federal level or at any state level that tries to address cumulative impacts solely through a review of individual permits. And I note that the Colorado Environmental Justice Task Force rejected the permit by permit approach to cumulative impacts. And essentially what Rule 315 would do would to put the commission between a rock and a hard place because it would create a choice between doing really an inadequate assessment of cumulative impacts that overlooks many of the impacts that the commission needs to address, or to require operators to do a much more extensive analysis that they view as far too burdensome and inappropriate for individual permit review. Just by way of example, the 1 mile impact area that's under consideration would overlook most of the relevant impacts that need to be considered for cumulative impacts because they're for most resources, any given project will contribute to impacts well beyond a mile. On the other hand, if the commission goes beyond that and requires a broader impact area through the OGDP process, industry parties, and they have objected to using a broader area because of the burden involved. And I'll talk a little bit more about that in just a moment. So what we propose is that instead of creating that kind of a problematic choice, the commission require operators to take a step back from the permitting process and require preparation of an analysis that covers a larger area and then uses that broader analysis to set requirements that could then be applied to individual projects and individual OGDPs in the area. I note that earlier in this process, I think it might have been during the informational docket, Weld County proposed a very similar concept for addressing cumulative impacts. And that kind of a broader analysis would be a really valuable tool for avoiding and minimizing future cumulative impacts. For example, if the commission or an operator did analysis that covered a significant part of the Front Range, that analysis could examine where existing oil and gas development is occurring and where that development is likely to expand in the next 2 to 3 years. The report then can also take a look at local government land use approvals and at where new residential and commercial development is expected to grow during that same time period. And then by comparing those two assessments, the commission can use that comparison to sequence new permitting in a way that avoids and minimizes impacts with residential development. Another example is regarding recycling of produced water. This commission's efforts to increase the use of recycled water for oil and gas development depend to a large degree on the installation of new infrastructure that's necessary to treat produced water and to move that water around Colorado. A cumulative impacts analysis of the scale that we're talking about could look at where future oil and gas development is expected to happen over a 2 to 3 year period, what existing infrastructure is already in those locations for water management, and then what new infrastructure would be needed in order to meet recycling targets for produced water. And then based on that analysis, the commission could use that information to set appropriate requirements for new infrastructure when new OGDPs are proposed. None of this kind of analysis and planning can be done with a 1 mile impact area and a permit by permit analysis, but is exactly the kind of benefit that cumulative impacts analysis is intended for. So now I'd like to drill down a little bit on some of the specific issues with proposed Rule 315. And again, in assessing the rule, I think it's useful to keep in mind what the key elements are of cumulative impact assessment. The elements I've listed here are required by the Act, and they're also consistent with how other agencies have approached cumulative impacts. The first one is what the impact area is, the area in which cumulative impacts may arise or be contributed to. The second one is the impact, or are the impacts expected from the proposed oil and gas project. The third element is to look at what other past, present, and reasonably foreseeable future actions may arise or may occur that could have impacts in the same area. The fourth one is what the impacts would be from those other actions. And then finally, the fifth element is to aggregate all of those impacts from different activities and assess what the aggregate overall cumulative impacts will be. We think that the proposed Rule 315 does a reasonably good job of covering element 2, which are the impacts from the proposed OGDP, but the improvements are needed with regard to the other 4, 1 and 3 through 5. Now, maybe our biggest single issue with Rule 315 is the presumption that the cumulative impacts analysis will only extend for a 1 mile radius from each well pad. And the problem, as we see, is that cumulative impacts to most resources will be felt far beyond 1 mile from the oil and gas location. Impacts to ozone are a regional issue. Wildlife impacts extend far beyond 1 mile from a location. And water use and impacts to communities also are felt outside just a 1 mile radius. Looking just at 1 mile from each location is arbitrary and will essentially guarantee that the cumulative impacts analysis will be incomplete. In fact, most of the OGDPs that the Commission is reviewing and approving cover an area that's considerably larger than 1 mile from each well pad. And so using the impact area presumed in Rule 315 wouldn't even cover the same area as of the OGDP being proposed. Another concern we have with the 1 mile impact area is that it's one-sided. It only requires operators as a presumptive matter to look at impacts or 1 mile away from the well pad. But when they're doing other measures that are mitigation measures or beneficial measures, they're allowed to consider the steps they're taking or other good things that are happening well beyond 1 mile. It's not clear why that should be. If operators can consider, if operators don't have to consider adverse impacts outside of 1 mile, we don't think it's appropriate for them to, at the same time, be able to consider beneficial impacts at a much greater distance that systematically would skew the analysis. So I'd like to offer a couple of examples to illustrate our concerns with the 1 mile impact area. The first of these is the Pronghorn OGDP, which the Commission approved earlier this year. And I think this demonstrates a number of our concerns. The pronghorn OGB, of course, was approved under the commission's existing rules, but I think what this example illustrates what would likely happen or be allowed under Rule 315 with a 1 mile impact area. As you can see from this, a 1 mile radius from each well pad won't even capture the full area of the OGDP. The Pronghorn project covered about a 10 square mile area. It's about 5 miles long and 2 to 3 miles across. The orange dots on the map here are the proposed well pads. And as you can see, most of those 4 well pads are just a little bit over a mile away from each other. So what the operator could do under Rule 315 would be to simply do a cumulative impacts analysis covering each of the well pads without actually considering the entire project as a whole. And that's actually, in fact, what the operator here did. It did 4 separate cumulative impacts plans for this OGDP. None of those 4 plans mentioned, each was for 1 well pad. None of those 4 plans mentioned the other 3 well pads. In addition, as you can see from the map here, there's a lot of other producing and active oil and gas development happening in the vicinity of these 4 well pads. A lot of that's just outside or a couple miles outside of the 1 mile impact area. All that development would not be required to be considered under the proposed impact area of Rule 315. And I think that can make a really important difference in terms of considering impacts, because what I think EDF made this point in their Environmental Defense Fund made this point in their comments that HAPs from hazardous air pollutants from oil and gas wells can aggregate, and to really understand what the cumulative impacts are to residents and public health from HAPs, you need to look at the overall impacts of multiple wells occurring in multiple well pads occurring in an area. And as this map indicates, proposed Rule 315 wouldn't generally require that. Here's another example. This is the Sprout project, which was also approved earlier this year. And the Sprout project covers the red cross-hatched area shown on the map. It covers about 11.5 square miles and involves 3 proposed well pads. We've added circles to the map to make them easier to see. And again, what this map shows is that a 1 mile radius impact area won't even cover most of the OGDP area itself. In addition, there's numerous other wells, pits, tank batteries, and other development happening in the vicinity of this project, but more than 1 mile away from each well pad. And under Rule 315, using a 1 mile impact area would overlook most of the impacts, both HAPs and other impacts from this development. I'd also note, if you look at the map, you can see road patterns within the cross-hatched area, which I assume reflects residential development. None of that residential development would need to be addressed, or at least most of it would not need to be addressed under a 1 mile impact area, because it's more than 1 mile from a well pad. But there's also another issue with this project, and that's that at the same time that the operator was getting the Sprout project approved, it was also getting approval for another project, the Hickory OGDP, and that's the project circled in the upper right here. These projects were both proposed by the same operator at the same time. And as you can see, Hickory is adjacent to the Sprout project, but because the Hickory well pad is more than a mile from any of the Sprout well pads, there would be no need under Rule 315 to address both of these projects together. And in fact, that's what happened here. The operator did cumulative impacts plans for the Hickory project and the Sprout project, but those plans didn't address each other at all. In addition, there's one other issue that I think is relevant to the impact area that the Hickory project illustrates. The Hickory project called for piping produced water 4 miles south of the well pad to an offsite water management facility. And that offsite water management facility was actually in a DI community. But again, because it was it's more than 4 miles from the well pad, there'd be no need to mention any impacts to the DI community or the water management issue. And again, in fact, the operator's CI plan, I don't think mentioned those impacts at all. Now, what we understand that the Rule 315 gives the operator or gives the director the discretion to increase the impact area. But as I think what these maps illustrate is that this isn't a situation where 1 mile is generally going to be appropriate to capture all cumulative impacts or the area where cumulative impacts from a project will be felt. In fact, in most, if not all projects, there's going to be cumulative impacts that extend well beyond a mile, whether it's ozone or HAPs or wildlife, public health. So again, what 1 mile as a presumption is simply not going to be adequate to comply with the act and capture all cumulative impacts. So trying to use a 1 mile impact area on a permit by permit review basis, even if there's an opportunity to depart from it, again, creates a kind of a rock and a hard place choice for the commission and the director, because the director will either have to routinely depart from the presumptive impact area and require a lot of differentiation and create potentially numerous appeals to this commission and a great deal of debate over what the appropriate impact area is, or if it sticks to 1 mile in most or all cases, which we suspect may be what ultimately happens, you'll just have a series of cumulative impacts analysis that just don't cover most of what's required to be covered. I'd also note that the Attorney General is pointing out that the second sentence of the statutory definition for impact area refers to looking at the specifics, conditions and a specific project. But I think the first sentence to the impact area definition in the statute is also very important. What it says is the impact area is the area, quote, where oil and gas operations have the potential to contribute to cumulative impacts. And I think as applying a presumption of 1 mile, it just does not meet the requirement of that first sentence, which is to look to where you can expect cumulative impacts or an operation to have the potential to contribute to cumulative impact. So that's, I think, we hope that illustrates really the concern we have. Now, instead of using a presumptive arbitrary 1 mile radius, what we propose is that the rules establish presumptive impact areas for each resource listed in the Act and set it at an area that reasonably reflects the area where a project may contribute to cumulative impacts. To do that, the Commission can look to other agencies that have expertise in this issue, so in these resources. So CPW with regard to wildlife, the U.S. Geologic Survey when it comes to water resources and watersheds, the CDPHE for air pollution. And each of these agencies has their own areas that they use when they're evaluating aggregate impacts and assessing the health of a given resource. We think it's appropriate to use those same areas that these expert agencies have selected for their own use to try and get a handle on cumulative impacts. And so just we pointed out a couple of examples on the slide here. We proposed in our pre-hearing statement using the data analysis units for big game from CPW. The U.S. Geologic Survey has a set of hydrogeologic unit codes for defining different watersheds where water resource impacts could be evaluated. And then the CDPHE has a set of air quality monitoring regions that could be used to assess cumulative ozone impacts. Now, I'm sure there's other options that might be available, but I think what's important here is to look at a scale that's large enough to capture the cumulative impacts to each resource so that the Commission will get the full information that's required by the Act. Now, we recognize that doing an analysis with areas this large would be burdensome for operators to do for individual OGDP review. And you heard that loud and clear from industry parties. I think that complaint really just underscores my prior point that it's important to do the cumulative impacts review before the individual permit review stage, not to try and fold it into review of individual permits. We recognize, though, that the commission has a statutory deadline to complete these rules, and so we've offered some proposed red line language based on the proposed Rule 315 that would adopt broader impact areas for each resources along the lines of what I've described here. You can find those red lines in Exhibit A to our pre-hearing statement. And I think what would likely happen if the commission adopted a set of rules that required full, broader, resource-specific impact areas is that operators wouldn't do the same analysis for every single OGDP. They wouldn't have to go through and complete a massive analysis every time they submitted a new permit. What in practice, I think you can expect that operators would do would be to take a much more efficient approach and do a more regional analysis that captures, that involves a full adequate impact areas. It might be done as part of a CAP. It might be done with multiple operators collaborating to cover the area where they foresee potential future development. But get the analysis done up front, and then that can establish, reasonably foreseeable future impacts as well as the existing baseline for the review of individual OGDPs later. And so that would take some more work up front from the operators, but then it would make the OGDP process and the Form 2A process a lot more efficient, we think. Pardon me, let me scroll down to the next slide. So I'd like to next turn to the other concerns we have with Rule 315. And as I mentioned, in addition to the impact area, when I was talking about the 5 elements of a cumulative impact analysis, we think Rule 315 needs to be expanded on to cover other existing and reasonably foreseeable future activities. And I think there's 3 key elements where we'd like to see more detail added to the rule. The first one is that a key part of a cumulative impact analysis is establishing the baseline of existing conditions. And proposed Rule 315 is reasonably complete with regard to other existing oil and gas operations, but it is pretty vague in terms of other non-oil and gas activities. There's a definition for industrial facility that I think industry is asked to be made more detailed, and we agree that could be expanded on. We suggest, for example, that the commission could adopt a definition of industrial facility using SIC codes. In addition, the rules refer to other significant existing sources of impact without defining what that means carefully, and we think it would be important to add some clarification to what sources are talking about and what those look like. Second, it's also important, we think, to provide clear direction requiring that all reasonably foreseeable future development be identified. And this is one area where I think there's some common ground between us and many of the industry parties, because we think a useful way to approach this would be to require operators to survey relevant state and federal agencies to identify all pending and approved permits within the relevant impact area to get a full inventory of what those other activities are and where they're happening and when they're happening. So, for example, the rule could require that the operators survey permits for Title V permits at CDPHE, APENs at CDPHE, water discharge permits that are both pending and approved at CDPHE. The rule could require operators to look to the Federal Bureau of Land Management or the National Forest Service where appropriate, Colorado State Land Board, and certainly relevant county and local governments. In Exhibit A to our pre-hearing statement, we've offered some proposed rule language that would do that. And providing that kind of a clear, detailed inventory would help ensure that the commission gets consistent and robust analyses and robust assessments of other activities in the area, at the same time would give operators clear direction on what's required of them. A couple of details I want to add here, though, is I think it's important that in reviewing other permits and permit applications at different agencies, the review has to consider not just permits, but also permit applications. There are a number of provisions in the draft rules that would limit the information to only approved permits, and that's inconsistent with the Act, which expressly refers to permit applications when it's talking about reasonably foreseeable future development. In addition, while we agree with the industry that looking to other state agencies for permit applications is a good way to go, a number of the industry parties have asked that review be limited to in several ways, such as only requiring operators to identify permit applications that are available on a publicly accessible database. That limitation is not included in the Act. As long as the permits are publicly available, they need to be included as part of reasonably foreseeable future development, even if it requires the operator to go to the agency and look and ask for them. And finally, a third issue that we want to address with regard to the detail analysis is that in a number of places, the rules allow for the description of impacts that operators provide to be done with just a qualitative or a narrative matter, rather than with specific or quantitative information about the project. We think that's a really major issue because what it will effectively do, we think, is prevent the commission from getting the information it needs to meaningfully avoid and minimize cumulative impacts. And ultimately, the purpose of the exercise here is not just to generate an extensive report about impacts and more paperwork, but to give the commission and the director's staff the information it needs to reduce those impacts. And a qualitative discussion just generally won't let the commission do that. What we found in our experience looking at cumulative impacts assessment is that when someone refers to a qualitative analysis, that's generally a euphemism for just a boilerplate description about types of impacts that are just too general, to provide useful information. So you see statements like leaks and spills can impact surface water. That's from the Pronghorn cumulative impacts plan. That's a statement that could be made about any oil and gas project anywhere in the country. And it doesn't provide really any useful information for the commission and commission staff to figure out how to reduce the likelihood of spills or prevent impacts to surface water. Instead, what the commission needs to be asking operators for is detailed information that's specific to each project, where that information is available, so that the commission staff can assess whether what the operator is proposing will actually minimize and avoid adverse impacts. Let me just offer one example of this. Many operators decommission and plug old existing wells as part of their project, and they tout the fact that reduces air pollution in connection with their project. But unless the commission gets information about just how much air pollution, how many emissions are being eliminated by plugging those wells, the commission has no way to assess whether that plugging will meaningfully reduce the new emissions from drilling new wells there, or to what extent, if at all, that it will meaningfully offset those emissions. And so I think for that reason, we think it's really important to require, where possible, a quantitative, specific analysis of the particular project. Now, Ms. Trask pointing out that there's a concern that if the commission asks for quantitative data and quantitative impacts, it will just get a data dump with lots and lots of information that overwhelms staff and isn't particularly useful. And we recognize that's a valid concern. What we've offered in our proposed rule is some language to try and address that. And what we suggest is that operators be allowed to aggregate the data they're providing in a way that's useful for the commission, so they can say, look, the existing sources in the area, in the impact area, generate this many tons of VOCs per year. The currently proposed and approved operations in the impact area will generate this many tons of VOC emissions a year, but they don't need to give the staff, a play-by-play list of every single possible operation and the emissions from that specific operation. So finally, on Rule 315, we think if the commission gets the information it needs to fully evaluate cumulative impacts, we think the rule should provide a clear standard for whether the statutory mandate of the act is being satisfied. The language the staff has proposed in Rule 315.3, I think is a good start, but it's not clearly tied to the commission's statutory mandate. It refers to whether asking with a number of factors, whether the proposal would just adequately evaluate and address cumulative impacts. Instead, we propose that the operator should be required to bear the burden of demonstrating with substantial evidence that all net adverse impacts from its project cannot reasonably be avoided, and that if there are, to the extent there are unavoidable impacts, those impacts are minimized. And in making that showing, the commission should consider the factors that are already offered in Rule 315.3, but also require the operator to address the possibility of offsetting all if it views adverse impacts as unavoidable, it should be required to assess whether they can be offset in some manner, whether air emission offsets or potentially wildlife mitigation, but to really do a full analysis of what might be possible there. The other factor that we think should be considered is the option of just avoiding those impacts altogether by denying the project or denying part of the project. The act doesn't require that operators be allowed to recover every last amount of minerals they're targeting. If impacts can be avoided by limiting the scope of the project, that's a consideration that should be considered when assessing a project. And then finally, there may be other reasonable approaches to avoid impacts. In addition, one factor that wasn't in the proposed language, but we think is significant, particularly with cumulative impacts, is that the operator should consider whether the proposed project would cause or contribute to exceedances of air quality standards, water quality standards, wildlife population targets, or other environmental laws or standards. And we think it's reasonable that if an operation is going to contribute to a violation of an environmental or environmental law, that the operator should be expected to try and avoid that impact. Again, we've included some proposed language in Exhibit A of our pre-hearing statement to flesh out Rule 315.3. So finally, the third topic I'll cover, and I'll be brief on this, is Rule 316 and the NOx intensity standards. We agree with, I think, the commission staff and other parties that the commission has an important role to play in reducing NOx emissions during ozone season in the non-attainment area, and that there's ways to do that don't duplicate the efforts of CDPHE. You've heard in written filings for a number of industry parties claiming that the commission doesn't really have authority to address the NOx intensity standards or to regulate NOx, and that it should just defer to the CDPHE. In that regard, we agree with the Attorney General's conclusion that it's clear based on the statute that the commission does have express authority to assure compliance with the NOx intensity standards. And on top of that, its general cumulative impacts authority and direction to deal with cumulative impacts, including air quality impacts, is broad enough to encompass measures to require regulation of NOx and to enforce the NOx intensity standards. So under the statute, this commission's job is to consult with the CDPHE on these rules, but not simply to defer to the CDPHE. And with that frame, I think there's two changes we would ask the commission to consider with regard to Rule 316. The first relates to prospective finding of compliance with the NOx intensity standards before operators are allowed to do pre-production activities during the ozone season. The June draft rules included provisions that would have required a finding that those operations would allow the operator to remain in compliance with the NOx intensity standards. That language is in Rule 316B as well as Rule 306B and Rule 307B. And we think that prospective review by this commission is a valuable measure to enhance compliance, in part because as the staff pointed out, the final NOx intensity reports won't even be available before the 2026 NOx or ozone season. Having this commission review pre-production activities before it authorizes them next year won't duplicate the measures that CDPHE is undertaking. It also would provide quicker and we think hopefully much more effective enforcement immediately of those standards and hopefully make them ultimately more successful. And finally, the second change we'd like to see in Rule 316 involves, relates to sector-wide compliance. There's been a lot of debate over whether the director has the authority to require action to address sector-wide non-compliance. And we believe the director does have that authority, and that there are ways to structure sector-wide enforcement in a way that's fair to operators who may be complying with the targets. But to simplify matters, we'd like to offer some new language that hopefully will get to the same place in a much more direct way. Rule 316D, as the staff discussed earlier, allows the director to take action to require limits on production from an operator who's not in compliance with the NOx intensity standards. We would suggest just changing a may to a shall there to require that if an operator is not in compliance with the NOx intensity standards, the director will take action to bring that operator into compliance with those standards. That may involve limits on any new drilling proposals or pre-production proposals by the operator during ozone season. That's covered by Rule 316B. But where you have operators who may not be drilling new wells or not doing any new drilling during the ozone season, but have significant existing operations producing wells, and they're exceeding the NOx intensity standards, 316D1 would be valuable here because it would allow and direct the director to make the operator either shut in wells or take additional steps to come into compliance with the NOx standards. So that is all we have. I'd like to reserve the remainder of my time for rebuttal and for closing, but I'm happy to answer any questions.
Great, thank you, Mr. Freeman. If you want to stop the screen share, I'll be able to see everybody a little bit better.
Yeah, here. And let's see here. How do I stop sharing my screen here? I think I have, haven't I? There we go. Okay.
It's still screen sharing, but
Is it? Okay, here, let me, how's that?
that's better. Okay. Commissioners, the panel is open for questions. Commissioner Cross.
Thank you, Mr. Chair, and thank you for the presentation, Mr. Freeman. I apologize again if you have a hard time hearing me. I'll try and be loud to make sure
So
you
far,
can.
so good.
Just want to go over a few questions. And I know you and I have talked about some of these individually in prior meetings, but want to try and, for everyone's benefit, get your answer on some of these topics as well. The first is I'd like to talk about informed consent. And you made a couple points that informed consent provides a meaningful opportunity for people in disproportionately impacted communities. And I think one of the points you made was it requires operators to go above and beyond their standard practices. And I'm kind of curious how it requires them to go above and beyond, because couldn't an operator just go in and say, here's a bunch of money, please provide me informed consent.
That's one option, you're right. But our view is that if the resident is willing to do that, that should be the resident's choice to make. But if the resident's concerns are primarily environmental or the impact to their public health or well-being, they have the right to require or insist that the operator take additional measures in order to address their concerns about air pollution, maybe traffic, water pollution. And I think this is one area where the new community liaison has a really valuable role to play, because I think if the operator is seeking informed consent from the resident, the liaison can, I think, help the resident assess what it's facing, what that person's facing, what the options are, what possible additional protections might be requested, what kind of limitations on traffic or other steps might be asked for. And so certainly there may be cases where the resident simply wants a money payment. We think for a DI community, that should be their choice to make. But if the concerns are primarily about public health and environmental impacts, allowing them to say no gives them quite a bit more leverage and will require the operator to do more than they may be doing now.
And completely understand the idea that it gives them the choice of trying to do that. But I'm just kind of curious how, if it can simply be solved with a payment, and I'm sure everybody has a number to a certain extent, isn't it more beneficial to have requirements for the ESPs and some of these other protections, as opposed to just saying, you can drill here if you get informed consent, because doesn't it then become pay to play?
Well, I think it's not an either or choice. I think this came up maybe in one of the commissioner's questions earlier, that the commission still has an important role to play in protecting DI communities, regardless of whether any individual resident there consents, both with ESPs and requiring that operators provide adequate notice to residents and take other steps. So it's really both, that there may be residents who are within 2,000 feet, who are willing to consent to it for a money payment. But as we've discussed, the impacts of that oil and gas project are not going to be limited to 2,000 feet. And it's critical that this commission also carry out its role to make sure that the impacts of that project are avoided and minimized, and that they're done so with particular care in the DI community.
So you would have us different than the way we do now, where we don't necessarily review it under a stricter standard if there's informed consent. If they have informed consent, it can move forward, but still have to look into using the additional.
Exactly, kind of, a two-step process. If it's within 2,000 feet of a home in a DIC and the resident doesn't grant consent, then the operator will have to move the well pad or make adjustments. But even where the resident grants informed consent, the commission still has a role to play to make sure that that the emissions, water pollution, and other impacts from that project, which may affect many other residents within that DI community, are done in a way that's protected.
Okay, and one other question related to the informed consent presentation, part of the presentation you made. You made the comment that a lot of times individuals can't necessarily respond to, I think you described it as, operators can provide broad-based comments that their practices are protected. But don't we separately require, and don't we have consultations with CDPHE to make sure that the practices that are being put in place and being used are sufficiently protected?
Well, you're right. There's certainly a process to require protective conditions, and that's done in consultation with CDPHE. What we've seen, though, is that those measures very often don't avoid a lot of the impacts that the residents are worried about, whether it's headaches or nosebleeds, odors, air pollution. There are cases, and some of these were discussed in detail during the mission change rulemaking, where a project went through consultation with CDPHE, A number of mitigation measures were implemented by the operator. And once the project started going forward, the neighbors actually did some monitoring and kept track of complaints. This was done with the city of Broomfield, and they found high levels of some, I believe, high levels of some pollutions on certain instances from that project, as well as spikes in complaints, headaches, and nosebleeds. So I think that's an example of why distance is not the only approach for protection, but it's an important part of it, because as thorough and careful a review as this commission and the staff will do, and as much consultation can happen with CDPHE, there's still going to be uncertainties and still be impacts that don't get caught. And ultimately, it's important to press operators to keep their drilling away from homes, and if they want to drill closer, to give those residents, especially disproportionately impacted ones, a say in what happens in their neighborhood.
Looking at the impact area comment you had, one of the things you proposed was talking about the resource by resource area. And you said for wildlife, we can use the data analysis unit; for CPW, for water, the USGS hydrogeologic unit areas. And I wanted to make sure that I understood this. As an operator would be analyzing each of those different impacts, each of those different resources, that resource would be limited to that area, or would you use the largest area and do it all with it?
So I think that would be up to the operator. You can imagine, if several operators collaborate on a broad scale analysis that would cover, say, a big part of Weld County, there may be a lot of benefit to covering all the resources for the entire area. But if the operator wants to do it differently, they can do so, but they need to look at an impact area that's a reasonable approximation of the geographic area in which their project will actually contribute to impacts to HAPs or water or wildlife. And they can go beyond that if it's helpful for planning and permitting, but they can't just rely on a 1 mile zone where that really will overlook most of the impacts that we're concerned about here.
So understand what you're saying about they could go broader, but what I'm trying to understand is, are you saying for wildlife, when in the analysis of the wildlife, you would only be looking at that wildlife analysis unit? Or would you say because the CDPHE air quality monitoring region is the largest of those different possibilities, they're looking within that?
Okay, I'm sorry, I misunderstood the question. No, it would be for wildlife, you would be looking at the relevant data analysis unit. That would be the presumption under the rules as we proposed them. You wouldn't have to look at the entire ozone non-attainment area for wildlife if what you're doing wouldn't contribute to cumulative wildlife impacts outside that data analysis unit.
And how would you, or would you, modify that impact area if, for example, if you're looking at water impacts and you're proposing looking at the USGS hydrogeologic unit area? What if it's in an isolated area, maybe in a valley where it's not really going to have a potential to have anything go beyond that area? Would you modify that, the impact area for water at that point in time? So
again, what we proposed is that these are presumptive impact areas, similar to what the proposed rule will do. And so if you had a situation where the evidence in the record for the OGDP showed that using that particular watershed area would not be either necessary or relevant, or either because it was too big, or in some cases, maybe it's too small to capture the relevant impacts, the commission and the operator could depart from that, but that these would be a set of presumptive standards that are, we think, a better approximation of the areas in which cumulative impacts will be felt. Better than 1 mile.
It would be fluid.
Yeah, it could. Yeah, as long as there's evidence in the record to support what the operator is proposing to do, they could depart from it. but there'd be a presumption that this is where they need to look. So that the default here is to cover an area that's adequate to capture the full scale of the environment of the cumulative impacts.
And I think my next two questions are kind of related, and it kind of goes into the quantitative versus qualitative. And I think part of my first question was answered a little bit with one of your statements, but I wanted to follow up on that as well. You gave the example of the pronghorn OGDP, and you specifically mentioned that the language of the surface area could be impacted by a spill or a leak. And you said that's qualitative, it's not quantitative, it doesn't really provide information. I guess I'm curious, how would you propose a quantitative solution to that example?
Sure. I mean, so I think what you want to look for, and this would be how much condensate is being kept on the site, where it's located, how far it is from the water, what the flow is for a given water body over time, and then the operator could, I think, offer some detail about what plans they have and how likely that would be to impact the water body. But in addition, to look not just at the particular project, but look at how many other condensate tanks are within a mile of that same river, right? And look at it that way. The concern we've got, and again, what we proposed in our proposed red line wouldn't require a quantitative analysis where the data is not there, it's not possible to get there. But where it is possible and where adding information specific to the project could be useful, the operator should have to provide it. And I think the example I used is one that we see in a lot of examples where it talks about the issue at a level of generality that's too broad to be helpful. And what we're saying is quantitative where possible, and specific, in all cases, specific to the project itself, so that the commission staff actually get something they can work with in trying to assess the project and minimize the impacts from it.
And one of the things I'm curious about in looking at the potential quantitative analysis for this, and I know we've had NEPA litigation in the past where a lot of times in the lease sales, it's, well, let's look at the worst case scenario for that. Or is that the kind of analysis you would want to see, is if there was a complete blowout and everything was happening, this is the total amount of oil that could go in based off the size of the reservoir, or are you looking for more of an explanation, as you said, sort of the quantitative and qualitative together, to say, because of our automatic shutting capabilities, this is how much may potentially be leaked into a system that's 50 feet away or 5 feet away.
Yeah. Well, we as we've drafted it, there's no requirement for assessing worst case scenario. There may be situations where that's appropriate and valuable to include. It's not something that we would propose to require in all circumstances. What we're asking for, again, is the details and the exact information would depend on the resource and the particular project, as well as what's going on all around it in terms of existing and future activities. What we're trying to avoid is boilerplate that doesn't talk specifically about the project itself, but just takes up paper rather than providing useful information. I think that what that looks like will depend on each project, but it requires a lot more than just a rule that provides for a qualitative analysis is an invitation to just get boilerplate that won't be helpful for the commission.
And would you foresee that determination as to whether the analysis, whether a quantitative analysis is possible or not? Is that a determination to be made by the director, by the commission? Where do you see that determination being?
I mean, I think, that's part of the 315.3 language that we proposed, is that I think the director and the commission need to look at what the operator is offering, and the level of detail and the information the operator is offering, and assess, does this provide the evidence that we need to fully assess what the impacts of this operation may be, and has the operator demonstrated to us in a way that robustly lets us make a robust finding that this will actually avoid impacts and minimize the impacts that can't be avoided. And that's really what we're aiming for here. And the cumulative impacts analysis has to be part of that assessment, which requires specific information about the project, not broad generalities.
And I think my final question is, as you were talking about, again, still within respect to the 315 concerns, you talked about avoiding and then minimizing and mitigating, and you talked about it being the operator's burden to show that it cannot be avoided, and to show that it is minimized and mitigated. And one of the things you talked about with respect to the minimization and mitigation was achieving a no net impact standard. And I'm curious, is there something you can point to that requires a no net impact standard, or is that what ultimately you'd like to see? Because doesn't the no net impact standard sort of render the minimization and mitigation sort of meaningless if there is no impact there?
Well, so I mean, I guess I go back to the statutory language of the Act, and the Act requires the Commission to protect and minimize impacts from oil and gas development. And minimize is defined as to avoid impacts where they can be, where it's possible to do so, and for any unavoidable impacts to minimize or mitigate them. And we see a no net impact standard as one approach of avoiding impacts, of meeting that statutory obligation. There may be cases where offsets or other steps are not available, that it's just not possible to achieve a no net impact standard. But we think where it's possible to do so, and reasonably possible to do so, that operators need to consider, and we think probably adopt those where it can be done. That's still
no net adverse impact is not an across the board standard.
We would say it's part of avoid where it's part of meeting the avoid mandate where it's possible to do, where a no net adverse impact standard is possible to achieve.
I just wanted to make sure,
sure,
if it was limited, not like no matter what you have to achieve it. Okay.
And we're resting our framework and how we think about this in kind of that mitigation hierarchy that's part of the statute.
Okay, perfect. I believe those are all my questions. Thank you again for the presentation and also the conversations we've had leading up to this to try and iron out some ideas.
Thank you.
Mr. Freeman, segueing off of the questions on Rule 315 and your red line there, my notes reflect that we cannot address cumulative impacts as part of a permit by permit review. Need to require broader analysis prior to OGDP, evaluate cumulative impacts across the relevant area, then use that assessment to set requirements that apply to individual ODP in 2As. That's kind of the summary that I got. And I looked at your red lines again. How does your approach work in practice?
Sure.
Say I've got operator X. How does operator X use this approach? What is the quote relevant area? And if we're not looking at it on a OGDP by OGDP, what are we looking at?
Right. So we offer the red lines here in recognition that the commission staff have put a lot of work into developing the rules, and that you're facing a deadline for finalizing these rules. Starting from scratch, we would actually suggest requiring that this analysis be done at a broader scale through a completely separate process that predates or precedes the OGDP process. But in the interest of proposing some solutions in light of the constraints here, we try to offer red lines that work within the proposed rules. And what we've done is to propose revisions to the definition of an impact area to cover the broader resource by resource areas that we've been talking about.
I get that, but my question is, how does, under your theory of the cumulative impacts analysis, how does that work practically? How does operator X come to the commission and provide a cumulative impact analysis? And I guess I'm kind of getting at the fact that unless and until we know where they're planning on operating, it's kind of hard to figure out the cumulative impact. But help me.
Sure. So I think what we would expect would not happen would that operators would do a full cumulative impacts analysis as we're conceiving of it for every single OGDP again and again and again. What would be more efficient and would work within these rules is to require that they capture this information before the first OGDP they submit. So the operator could either on its own or maybe in consultation with other operators, do the analysis to say, in this area, here's what the existing activities, oil and gas, other activities are, what's the baseline of impacts for this larger area where we hope to be doing work. Then do the assessment of what other reasonably foreseeable future activities can be anticipated in that same area, whether new oil and gas projects or new projects of other kinds. Do that analysis. That will take some time. And then once that's done, that can be applied to multiple OGDPs for a period of 2 to 3, maybe 4 years. So it would essentially say, the requirements as we propose them are written into the language of the proposed rule. In practice, though, we think that operators would take a more proactive approach, get out front of it, do the analysis, that kind of the broader picture analysis, and then they could apply that analysis to individual OGDPs, looking at the Form 2B information that goes with an individual OGDP. One other way to do this would be through the CAP process. One or more operators could do a CAP for a larger area that does a really robust cumulative impacts analysis, and then they'd be set up for doing OGDPs under the standard CAP mechanism.
Okay, appreciate it. Other commissioners with questions? Commissioner Oath?
Thanks. I have questions on kind of 2 main areas, and one of them is the one that Chair Robbins was just talking about with you. So I want to provide some context maybe before I ask my questions for other commissioners who maybe wouldn't be thinking about it in this context. So you referenced the EJ task force recommendations. And so I was on the task force and part of the subcommittee that, wrestled with exactly this question: what is the right way to go about cumulative impact analyses, permit by permit, larger scale, et cetera. And so what came out of that process was a unanimous recommendation to recommend that, we attempt to get resources and directive authority to do cumulative impact analyses on a very large geographic scale, with recognition that that would take a very long time and that would not be able to be done by operators or even one agency, that it would need to be very robust. And so a lot of, things outlined in those task force recommendations. Following that, there was, a series of roundtable conversations with representatives of EJ groups and DI communities, where it was discussed that the biggest priority of those groups was that piece of the task force's recommendations. So that led to legislative effort in this past session to obtain both that that directive and authority to CDPHE to hire and bring in a third-party consultant to help develop this in consultation with all of the other agencies, local governments, community members, etc., and a substantial amount of resources, right? $2 million to do 2 of these. So my question is, what you're proposing seems like it's duplicative of that, getting out ahead of it, potentially inconsistent with it, because it would be either the operator doing it or the agent, ECMC as an agency just doing it. So can you share your perspective of how you see that what you're proposing fitting with the path that is en route and there's a substantial buy-in and investment in it?
Sure. No, thank you for the question. Let me be clear. We're not advocating that the commission undertake something similar to what the multi-agency process you're describing was. I only brought up the task force report to illustrate that doing cumulative impacts on a permit by permit basis is a really ineffective way to do it. And that's my understanding is that was part of what the task force concluded. I'm definitely not advocating that this commission undertake something similar to what's come out of that task force report. What we're asking for is, I think, much smaller in scale than what's being considered. It's also would be limited to addressing impacts from ECMC approved activities, not activities and approvals from every state agency. And again, what we have in this rulemaking is an independent statutory mandate from the legislature to address cumulative impacts in a way that covers the entire impact area and all reasonably foreseeable future development. And our point is that, and again, the only reason I raised the task force report is that can't be done effectively by just reviewing individual permits. It needs to be an analysis where either the operator or the commission steps back and looks at a broader area. We're not trying to duplicate the task force project.
Okay. I'm still struggling to see how it would be, not duplicative or kind of potentially inconsistent, which was, part of the worries, but I appreciate your perspective and thanks for that response. Okay. So the other area I wanted to ask a question about was with respect to the setback topic and 604 generally. So recognizing and acknowledging that I think, in both in written testimony and in your presentation and other parties' written materials, there are a number of reasons that people are interested in the setback approach. But my question has to do with that a piece of that seems to be highlighting concerns or perceptions of the shortcomings of the substantially equivalent test and how it's been implemented over time. So I wanted to see if you have thoughts on if that's either all of or a substantial part of the problem here about improving that test.
So I think broadly speaking, we would support a consideration on the part of the commission, not limited to DI communities, but to reconsider what the substantial equivalent standard means in practice and how it's applied. I don't think that's a substitute for requiring informed consent in DI communities. I think there's a lot of value to requiring and giving the residents of DI communities a direct say, thumbs up or thumbs down on drilling near their homes. And even if the substantial equivalent standard was expanded on or refined, it still creates many of the same problems that I described earlier, where it's be highly technical in nature, difficult for DI residents to engage with that and make their case. It also creates an issue similar to the force pooling situation, where it gives the operator another way of going around the wishes of the resident if the resident doesn't accept what's being offered. And so we think there's certainly some benefit to refining Rule 604B apart from DI communities and apart from this rulemaking. But for DI communities in particular, we think it's important to get their consent and require operators to get that consent before they start drilling near their homes. I also think that, as I mentioned, this is a change that, based on current drilling patterns, should have a minimal impact on the west slope and elsewhere in eastern Colorado, and even in the Front Range. If current drilling patterns continue, it shouldn't have a very significant impact on operators. But it will, if operators do think they're going to be drilling closer to DI communities in the future, it's important to get ahead of this and adopt the changes that were proposed in June.
Okay, thanks. That's all I have.
Okay. Other questions for the panel? Commissioner Messmer?
Thank you, Mr. Chair. Just a couple quick questions. Thanks, Mr. Freeman, for your presentation and all the information you've submitted and your thoughts on all of this. It's appreciated. I did have, I've been noodling as well on like the applicability of this kind of broader cumulative impacts analysis that's being proposed. I don't know if you heard me earlier ask questions to Ms. Trask about how the CIDR data was being captured, and how to put that in a form that's useful in cumulative impacts analysis. And so I'm kind of wondering your thoughts on whether if there was an expectation that data that's now been collected almost 4 years gets developed in a form that could inform cumulative impacts analyses, whether that gets at least partway to what you're asking.
Sure. No, thank you for the question. We think the CIDR database actually is an important part of the answer, but it's not the entire answer. And what I mean by that is, Ms. Trask, I think, as she explained this morning, what the CIDR database does is not a cumulative impacts analysis in the sense that the Act directs. What the CIDR database is an aggregation of OGDPs approved by this commission. Now that goes to existing impacts statewide or in different parts of the state. Goes to past activities in different parts of the state from oil and gas operators. But what it doesn't cover are future impacts from other oil and gas operations, and it doesn't address any past or present or future impacts from non-oil and gas sources. So the CIDR database and what the information the commission gets in the Form 2Bs is really valuable and an important part of the answer, but it's only a piece of the puzzle, not the whole thing. Does that answer your question?
Yeah, no, I appreciate that. I guess that's why I was asking if it got partway there and what holes would be missing, and how that would all apply. So I'm just thinking aloud with you here. So and then I think that's my question for right now. So thank you.
Thank you.
Further questions for the panel? Commissioner Ackerman?
Chair, I don't have any questions for Earthworks, but I just wanted to say how much I appreciate their very attentive attention to this matter and particularly for their proposals of solutions that as they bring up issues. I think that's a really productive approach and appreciated their presentation. Thank you.
Thank you.
All right, Mr. Freeman, we will allow you to be concluded. And commissioners, with that, with it being 5:15, I believe we should conclude for the evening. The next party is slated for up to 85 minutes worth of testifying. I would also suggest, sort of as we think about tomorrow, we're beginning at 9. Tomorrow evening, we have the 5:30 public comment session. I would suggest we think about doing 9 to 4 tomorrow, and then taking an hour and a half break before we go into the evening session. We'll take 30 minutes or so for lunch and the relevant morning and afternoon breaks as well. So those are my thoughts on that. Procedurally, I note that the Energy and Carbon Management website is now updated with the September 5th, 5:30 public comment meeting. Folks that would like to testify on Thursday rather than Wednesday are encouraged to email our staff. All that can be found on the website. We'll try to accommodate as best we can, but we're not going to get through everybody tomorrow. Plan on trying to do like 2 hours tomorrow and 2 hours Thursday. We are we are, based upon how we set it up, we're one party behind, but we'll get started with them, and that'll be Conservation Colorado, first thing in the morning. AAG Davenport, do I just say we're continued to tomorrow morning at 9, or do we need to have a motion, or remind me what's appropriate?
Chair, we don't need to have a motion to continue the hearing to when it's regularly scheduled, start 9 o'clock in the morning. I think a motion to adjourn until 9 o'clock tomorrow morning.
So moved.
Second.
Any further discussion on any of this? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? All right, folks, we'll see you tomorrow morning. Have a good night.